Test 1 2 1 2 1 2. Test 1 2 3 4 5 6 7 8 9 10.
Good. All right, it's a little after 1 and I'm going to gavel in. I'm not doing that because the Republicans are gone, but oh, here you go. Here you go. We got 1 Republican in. Who are you? All right. Good afternoon, everyone. Today is Tuesday, February 14th. Happy Valentine's Day. Love to see you all. Today we have 11 bills on the docket. We'll start off with Senate Bill 290. We'll then go to 208, 336, 226, 330, 209, 236, 295, 285, 257, and then we'll wrap up with Senator Waldstreicher with 292. So with that, without further delay, I'll ask the Vice Chair to take the gavel while I go up to present Senate Bill 290. Got it. Thank you. All right. No, also just a PSA for the folks on this side. You got a camera back there, so make sure your monitors are clear. Good afternoon, everyone. Mr. Vice Chair, members of the committee, Senator Smith here on behalf of Senate Bill 290, the Office of the Attorney General, Independent Investigations Division, Authority to Prosecute. Now, I always, when we deal with this office, I start off with a quote from the Department of Justice, the Police Use of Force and Examination of Modern Policing Practices, which was published in November 15th of 2018. It says that as the Commission on Civil Rights explained, investigation and prosecution of use of force cases should be made as independent and public as possible. The agency is investigating and determining whether to move forward with the prosecution should not have an ongoing relationship with the department. And that's the principle that guides the reforms that we've initiated from March of 2021 to today. Now, this bill completes the reforms that we began in March and ensures that both the investigations and the prosecutions of officer-involved deaths that are likely and incidents that are likely to cause death are independent, instilling a level of trust and transparency between our police officers and the general public. Now, I wholeheartedly believe that this is one of the most important reforms that we've set in motion, and the proof is in the product and the process. Now, on your desks, I've distributed the report of Independent Investigations Division, the ID first annual report, a report that was not required by statute, but it makes all the information, as well as the website that I have up here before you, These two documents, this document and the website, makes all the information, the statistics, the videos, the reports, and more readily accessible to the public. And to my mind, this is exactly how government should function. It's transparent and accessible. As the report notes, for the first time, Marylanders who died at the hands of police would not have their deaths investigated by the same police agency that employed those officers. It was a true step towards impartiality and fairness. This report is also very important because it can inform and be instructive for a number of other policy considerations. It gives you the who, the where, the how. And so I encourage everyone to not only take a deep dive into the report, which I distributed earlier at the beginning of the session, but also this website. It's really, really instructive, and I think will be informative for us as we move forward. Now, as transformative as this reform has already been, the reform is yet incomplete. Though the investigations are thorough, independent, and transparent and accessible, the current framework leaves room for incongruity and conflict. For example, just last year, a state's attorney announced that he was declining to prosecute a particular case. However, at the time of the announcement, the state's attorney's office had neither requested nor received the results of any witness interviews, forensic testing, medical reports, nor had the state's attorney received the IID's report. Under current law, the IID has no legal remedy if the state's attorney decides to decline the case without waiting for or even considering the IID's independent report. Senate Bill 290 fixes this. So there are two major component parts. First, it enables the state's attorney to refer a police-involved incident resulting in injury to an individual that is otherwise not within the jurisdiction of the division, which basically means that injuries that are not likely to result in death or injuries that do result in death. The division may, in its discretion, decline to investigate, and the division may investigate any other crime related to police misconduct that is discovered during an investigation under this new power. Second, and the main thrust of the bill, is that if the Attorney General determines that an investigation conducted under his authority provides sufficient grounds for the prosecution of a criminal offense, the Attorney General shall have the exclusive authority to prosecute the offense. And that's it. That's the bill. I think this bill will round out and finalize our much needed and important reforms. It will solve incongruity. It will be more transparent, and it will be more responsive to our citizens' needs. In 2020, 2021, the citizens of Maryland called for just this type of transparency and accountability and accessibility. 290 rounds out that reforms and ensures that that information is accessible to every Marylander, and will ultimately will bridge the divide between the police who serve our communities and the general public itself. So with that, I ask for a favorable report, and I'll invite the Attorney General up, and then I'll stand for questions, or I'll stand for questions. I'll stand for questions first, then the Attorney General will come on up.
Thank you, Mr. Chairman. That's your preferred order. You'd like to do questions now?
Sure, that's right.
Okay. All
We'll do
right.
it.
Questions from the committee. All right, Senator West.
Thank you, Mr. Chairman. Mr. Chairman, so I've got two areas I want to discuss with you. First of all, I have some testimony here from Judge Hurd, Wanda Hurd. She was the Chief Judge of Baltimore City Circuit Court. Her testimony is quite lengthy. I'm just going to read one small section and ask you to respond to it. She says, an experienced trial prosecutor knows that in addition to legal knowledge and their trial experience, knowledge of the jurisdiction and its people who serve as jurors is essential to every prosecution. Hence, in Maryland, we have individual jurisdictionally elected prosecutors and judges who must live in the jurisdiction they serve. It is beyond the expertise of the Maryland Attorney General as a statewide, quote, law firm, close quotes, making necessary all-encompassing criminal case analysis in these very important cases. It's simply outside of their wheelhouse. So how do you respond to that it's not appropriate for a law firm headquartered in Baltimore City to send people out to try a case, say, in Kent County?
Well, first, I'd say that the Attorney General is certainly accountable to the people of Maryland as he stands for election every 4 years. Second, the expertise is clearly there, as is evidenced by the breadth of the Attorney General's scope and responsibility. So that's second. Third is, and you and I have worked on this issue about judicial elections. So if you want someone to be impartial and not subject to the political winds, as you and I have worked together on, it should be as independent and far removed from that influence of the whims of whatever the mores of the time are. It should be focused purely on the merits of each case. The IID, the Attorney General, have proven that they can be impartial. They're extremely transparent. I'm confident that this is the right way to go.
Well, let me present it for just a second. So Judge Hurd's point is that it's important for any lawyer, any prosecutor in such a situation to be very familiar with the customs of the local community, the citizenry in the local community, and the judicial system in the local community. And if you don't have that experience, you're probably poorly placed to prosecute a case in that community. So let's take Allegheny County and Cumberland, Somerset County, and Harford County as an examples. Is it your contention that the members of the Attorney General's office headquartered in downtown Baltimore are competent to prosecute serious criminal cases in Allegheny County, Somerset County, and Harford County, all three, even though probably they will have no experience at all with the people in those counties?
Well, I think you have experience with the process and the facts of the case and the investigation. So I would almost argue the opposite. You'd want someone, a neutral arbiter coming in, one piece investigates, one piece prosecutes, and divorced from, again, any of the influences with any jurisdiction. So of course, they're going to be competent prosecutors that are employed by the Office of the Attorney General, capable of handling these cases in all 24 jurisdictions.
Okay, let me move on to my second area that I wanted to ask you about. And that is, let me just read you two sentences from the testimony of the Attorney General. He said, the public should have confidence that prosecution decisions are made in an impartial manner by people who do not work together or rely on each other professionally or personally. Now, it simply is the fact that state's attorneys in every single county work with police forces in those counties on any number of cases covering the waterfront, from prosecutions involving police officers to every other prosecution in the county. So as I read these words, it would suggest that the Attorney General's office should take over all prosecutions in Maryland, because otherwise they're going to be handled by state's attorneys and assistant state's attorneys who work every day with the police, who will be required to give testimony in those cases. How do you respond to that?
Well, this is more of a direct and inherent conflict, because they're investigating the people that they work with are the subjects of the investigation. And that's why this reform is necessary, to remove any actual or the appearance of conflict or impropriety. So I'm not sure that same dynamic exists with those cases, which are much farther removed, because the officer is not the subject, him or herself, of the investigation.
Thank you.
Senator Carter, a couple other questions.
Senator, I'm following up just a little bit on what Senator West brought up. One of the things that I thought, the language he just quoted from the Attorney General when we were doing the prior bills I was not here for, but was this idea of impartiality, but also sort of a separation. And I thought that one of the criticisms of the local prosecutors deciding whether or not to prosecute a local law enforcement is that they work together closely. So one of the criticisms I'm hearing about this bill, and I know we're trying to just figure out how to make the best system work, but another concern is that now you are putting in, you have an AG's office that is not only investigating, but deciding to prosecute. And again, the idea of bias, not wanting for them to work together. So the idea that they're not separate and that there isn't pressure by investigators who, perhaps think in their minds and are telling the prosecutors, yeah, we think you should prosecute this case. And then they're in the very same office as the people who would decide to prosecute. So I think the criticism of how it worked before is somewhat brought back to life in this process. So how would you address that?
No, it's funny. I've heard that line of argument before,
Right.
and we may have even touched on it a little bit. So the way it was before the IID existed, you have the police would do the investigation, and then you have the state's attorneys do the prosecution. And although there's a very tight-knit relationship, it's two separate entities. Here you have a situation where we're seeking to kind of put both of those responsibilities under the roof of the Office of the Attorney General. But the way that this is drafted, and And I understand that element of prosecutorial immunity when you have that where we were before, that you have a different entity investigating and then one entity doing the prosecution. Right now, the way that the bill is drafted is that it says that the IID will do the investigation, but then it leaves leeway and latitude for the attorney general. It's the attorney general shall be prosecuted by the attorney general or his or her designee. And so there's a separation there, even though that responsibility is all under one roof. They're two separate rooms, so to speak.
Well, that's it. How separate are they? And could we make them more separate in some way? You know, in large law firms, you have what's,
The
a
check
firewall,
yeah, firewall, yeah,
right?
yeah.
So that there's not that undue influence and you really do have independent judgment. And again, my questions are never that this is happening, but only that it could happen.
No,
and there's a
understood.
perception. So I don't want anybody to misunderstand. But again, that very idea that there was a local bias, a local too close of a relationship. I don't know if the way the bill is drafted, we've addressed it so that people would have confidence that there isn't some kind of, because of the connectivity of the people in these offices. I know one's doing the investigating, but if they're able to talk to the prosecutors regularly, I just think that we're not attempting yet in this bill to make sure that that does not create influence and that does not undercut the impartiality and utter independence of the prosecutorial decision.
We will ever strive for perfection, but I would say, contend that this framework is much more aligned with those goals of transparency, independence, than what we had just 2 years ago.
Okay, thank you.
Senator Folden.
Thank you, Madam Chair. Hey, good afternoon, Mr. Chairman. How are you, sir?
Happy Valentine's Day.
Happy Valentine's Day to you. Where's your red?
I know,
Thoroughly
where's your
disappointed.
red, you know?
Well, I had it, but CT Wilson stole my tie.
There you go.
So
No comment.
I know he gave me this one, which is amazing, but there's a lot of
There's
love.
a lot of love, especially from the state's attorneys from behind. There's a lot of love.
I know.
Yeah.
So,
I do love
so an important component in this is that, an important element that was in place under, and it was a requirement, or is a requirement for a long time, is that because of the dynamic and fluid type situations that are encountered by law enforcement on a daily basis, that in the unfortunate event of a deadly use of force, regardless of whether or not it ends in death, but a deadly use of force should be viewed through the lens and reviewed and investigated by someone of a similar background. So it's not that you're being investigated by your own department, because I know there's a lot of MOUs that have been established that they have agreements because they want to rid themselves of the appearance of any impropriety, that they would have an allied agency do the investigation. But it's important. Is it not an important element that you have these fact finders going out and investigating that have a similar background?
No, I agree with you. I mean, and again, we had two jurisdictions, Montgomery and Howard County, that had an MOU, and they would do that. And we explored that option back in 2021, but again, that just wouldn't work if you tried to scale that up statewide. You'd have different jurisdictions of different sizes and different resources and different caseload. So that's one thing. I don't think that works on a, you can't plus that up really.
So,
but to answer your question more directly, I mean, you have Maryland State Police are employed to do these investigations. And so, you have like-minded or, people that are in the profession on the front lines throughout this entire process.
So the state police is the body you're saying would be the one doing the statewide, all police involved shooting investigations.
Well, so the way that we drafted the bill in terms of the investigations, MSP is the entity that's employed to help with that.
But are they the entity that does the investigation is what I'm
They are
asking.
helping with the investigations. That's right.
Helping with the who are they helping?
They're helping the Office of the Attorney General. They're working
Okay.
together.
So again, trying to keep this influence separate because one is elected, one is sworn to uphold and protect and defend, and just like the other. But there are times we question how much someone's vigor is to uphold the Constitution when there's not a lot of. Some people feel that there's a lot of room left for interpretation. The reason I bring that up is I just reviewed a shooting case in Baltimore where the IAG's or the OAG's report came out, and it talks about it was an unfortunate shooting. Suspect, it passed away as a result of the shooting. But there was 4 shots by the officer that was diving out of the way of the car as it came towards him. And 3 of the shots, according to the Attorney General's report, they deemed them justified. The part that I found unique, and maybe this is better for the Attorney General to answer, and I apologize, sir, would be that it appears to me that it wasn't investigated by an impartial body, or it wasn't investigated by a law enforcement minded person, because they said that the 4th shot was questionable. So literally, as the person is falling to the side of the vehicle, there's one last shot that rings out, goes through the passenger's window, it strikes the subject in the side, resulting in the death of the suspect. This is an ongoing, active, violent incident. To be able, the concern is from many in law enforcement is that when we start breaking down body footage camera by literally fractions of seconds, to be able to say that one person can disengage their mindset from the actual reaction that they're seeing at the time and engaging their body to respond, there's a process to that. And the threat is falling, and as the person's falling, to say that, there's case law that talks about the first shot being justified to the last. If the first one is there, it's justified to the last. But the AG's office separated out and said, well, the 4th shot, there was no break. It was a succession of shooting of rounds. They're trying to say that one's questionable. That's my concern, is when we have people investigating this that do not have the pedigree or experiences to say, yes, in this situation, this is a very difficult thing to separate. Does that make sense? Why? I'm just asking, why? I want to make sure that if we're going to move forward with this, that we have something in place that validates the use of force policy and the scenarios that, or not scenarios, the situations that officers are being encountered with, because there is a perception and reaction time, and all that takes a time for your brain to process. Because I'll tell you, as being involved in violent situations, when they come to me, the first thing I always see is disbelief. I'm like, oh my gosh. And then I've got to react.
I'm not familiar with the specific of the case, so I'm not going to comment.
Yeah, no,
I'll comment on the process.
Sure.
And so, as MSP is intermixed and intertwined with this process from soup to nuts. And what I like, and I think this report is so instructive, is if you look at the appendix C, they'll talk to you, they lay out the protocols for how these investigations work. And you'll see that I like the process, because the Office of Attorney General has gone out and sought input from stakeholders from across the spectrum, law enforcement included, to develop these protocols so that they can work in lockstep together to do these investigations, and to have that input from law enforcement that understands the pressures of those split-second decisions, understands the pressures of the use of force standard changing, and understanding the nature of the job. Those folks are intermixed with the entire process. So they're woven into this process. It's part of the fabric of this process. And I would seriously take a moment to read the protocols, because I mean, they've literally thought of everything, and they've built in the ability to keep the dialogue going on between local law enforcement, state's attorneys, and other stakeholders to ensure that the best protocols are put forward to make sure that this process works.
Okay. I have some other questions, but I'll save those.
Sure.
Thank you.
I'll just say that, I mean, when the chief gets up here, I mean, she can explain those things more, in depth, because she's the one on the ground when the wind's blowing, and she can explain that to you. So I didn't want to invite another question just yet. I'll keep my mouth shut from now on. And go ahead, Senator McKay, go ahead.
Thank you, Chair.
Less is more.
So as I read some of the unfavorable written testimony, there's some written testimony submitted by the Chiefs of Police and Sheriff's Association. And I just have a question of how you would address this question. They're saying that this legislation, that it further diminishes the responsibility of the chief or the sheriff by expanding the investigative authority, and it limits their ability to hold officers more accountable in circumstances outlined by this bill.
Circumstances, I don't see how that's the case at all. again, I'll lean on the protocols. I mean, if you're talking about for other investigations of other misconduct, you know, there are protocols for collateral investigations. To my mind, it doesn't strip away the ability for an actual sheriff. I mean, the sheriff can't prosecute anything. They can take administrative action, which can still be the case after the investigation's done or after a prosecution is done. I really don't see how that's the case at all.
Okay, well, thank you. Maybe they'll expand that when they come up. Thank you. Thank you, ma'am.
Thank you. Questions? Thank you, Mr. Chair.
Perfect. Now we'll invite up the Attorney General.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Senator Carter, want to thank you and the members of the committee. First of all, congratulations on your re-elections, your elections. This is my first time testifying before the Maryland General Assembly this year. I'm no stranger to this body, having spent time in the lower house. And last year, for those of you who are here, you may recall I testified side by side with someone who I didn't know would be my predecessor, Brian Frost, when we testified on ghost guns. But it's great to be here, and it's great to be able to testify in support of Senate Bill 290. I think some of the questions that were asked of the chairman, I think I may be addressing in my statement, but I look forward to answering the questions that you have. I think the chairman thoroughly detailed the bill. It grants exclusive authority to the Office of the Attorney General to prosecute criminal misconduct in also involved deaths or incidents where death is likely. That's when prosecution is deemed necessary after an independent investigation. First, I do want to commend the Maryland General Assembly for prioritizing police reform, not only this year, but for the past several years. The legislation that you have already passed in prior sessions, I believe, ensures transparency and accountability and works toward restoring public trust in law enforcement. Mr. Chairman, when the IID was formed 2 years ago under my predecessor's tenure, the Office of the Attorney General assembled the very best attorneys to do this specialized work. I know a comment was made about pedigree. You'll hear from Dana Mulhauser, who is my division chief. She has 12 years in the Civil Rights Division at the Department of Justice doing this specialized work. And I invite you to ask Ms. Mulhauser about the complexities of investigating and prosecuting police use of force cases. Now, often we're thinking about conduct that resulted in the death. They thought it's a homicide. These are different homicides. These are complicated. This is a cross of a homicide and white collar criminal investigation. And she can further describe that point to you. We've assembled a group that is the best of the best. My number 2 at the IID, Renee Joy, before coming to the OAG, she led one of only 2 units in a state's attorney's office in Maryland. There are only 2 specialized units that do this kind of work. She led one of them in Prince George's County, and she's now the number 2 in this division. This is a division with a high degree of experience and expertise in this specialized work. They have conducted over 25 investigations with the expertise, the ethics, and the fairness that you intended and that the public deserves. And I think the chairman had already distributed copies of their report. This bill is about best practices in police accountability. Senate Bill 290 is about ensuring that the public has confidence that prosecution decisions, just like investigations, are made in an impartial manner by people, and I think there was a quote out of my written testimony, so I'll restate it here, by people who do not work together or rely on each other professionally or personally to the extent to which our local state's attorneys do with their local law enforcement agencies and officers daily. We're not talking about inappropriate relationships. We're talking about the public's confidence or lack of confidence in the process where the relationship suggests a lack of impartiality. Now, you have in front of you or in your file what I just said stated in a much more, I think, down-to-earth way, an on-the-ground way. And I'm going to invite you to the written testimony of Gerard Hogan. He spent 37 years as a prosecutor, his first 7 as an assistant state's attorney in Howard County. And he writes, and I'm going to just take a minute if I can. It is no exaggeration to say that this is when he was an assistant state's attorney, and the police were a team, often together in our office or at the police station, at crime scenes, or just as often as Shannon's Bar on Route 40 after work. Many of us became friends, and in a county the size of Howard, I knew most of the officers by name, knew many of their families, etc. We're not talking about inappropriate relationships. We're talking about close relationships when you're asking a state's attorney to now investigate and prosecute a case against the very men and women that they work so closely with every day in fighting crime in our communities. So 2 years ago, this committee took on the issues around independent investigations and prosecutions when it came to officer-involved deaths. The debate was robust and it was contentious. Many of you were here. You participated in that. I saw it from afar. And after that debate, you settled the question of what constitutes a best practice when it comes to investigations. Your work aligned with recommendations, and the chairman already cited the U.S. Commission on Civil Rights in their 2018 report regarding police use of force and modern policing practices. It also aligned with the 2015 report completed by the Task Force on the 21st Century Policing that was comprised of a diverse and varied cross-section of stakeholders across the nation. You recognized 2 years ago that our state's attorneys, who I can emphatically state are second to none in doing a very difficult and demanding job of investigating and prosecuting crime. But you recognize that their offices should no longer be responsible for these investigations. Now is the time to address the independence of prosecutions. 13 states, including Maryland, have given independent investigation authority to their respective attorneys general. Only 3 of those states, Maryland is one of them, did not include independent prosecutorial authority. A question was raised, I think it's a good question, about inspectors and prosecutors in the same unit. While our bill 290 in front of you, I can't say is identical to all of those other 10 states where they do both. It closely mirrors them. It is not uncommon to have a unit with inspectors and prosecutors that do the independent investigation and the prosecution. Now, one of the questions was asked, who helps us with the prosecution? The Maryland State Police, but we also have in the unit, organic to the unit, investigators, and I think Dana can correct me when she comes up. I think all of them have police law enforcement experience in Maryland prior to joining our office. So Maryland is not unfamiliar terrain to them and the work that they do. We have the experience to do the work. Now you're going to hear, and I think Senator West, I think you brought this up, about the OAG is unable to prosecute these cases because we don't understand the local communities, potential jurors. You mentioned customs and citizenry in jurisdictions where the case will be prosecuted. That statement, and I certainly respect the question and the testimony, the written testimony of a former circuit judge from Baltimore City. It is simply not consistent with our current experience. And let me explain. The Office of the Attorney General, today we're talking about the IID. We have a criminal investigation and prosecution unit. They are not involved in the work we're talking about. I'm only referencing them by way of example. We have an organized crime unit, second to none in the state, multi-jurisdictional offenses. Drug trafficking, weapons trafficking, human trafficking. We are often invited at the request of state's attorneys at the request of local law enforcement, we are invited to prosecute some of the most complicated cases that you can imagine in front of juries in their counties across the state. We do this work. We do this work. We investigate and we prosecute multi-jurisdictional. Now, again, that's a different unit. I'm just highlighting that an independent investigation division with the experienced prosecutors that I have and the handful that I'm going to hire when you give me the authority and pass the bill are going to be able to go into counties across the state and do the necessary work to bring a successful prosecution. We've demonstrated the ability to do it in a related but different context. Members of the committee, we independently investigate. We should independently prosecute. It's the natural evolution in the reforms that the General Assembly began to undertake when it created the IID. It's a best practice for police accountability, for public trust, and the prosecutorial function. Thank you, Mr. Chairman.
Thank you, General. All right, we have questions from the committee. We'll start up with Senator Carter, then go to Senator Folden.
Thank you, Mr. Chair. Welcome, Attorney General Brown. So Senator Folden actually brought up a question probably with a different perspective than I have. Donnell Rochester was 18 years old in Baltimore City. By all accounts and by the Attorney General report, he was unarmed and police had no reason to believe that he would be armed or was armed. The questionable shooting, my understanding at the time that he was driving a vehicle, there were no civilians or police in his path. This is according to the report. I'm just recalling what was written, what was found in the AG's investigation. And the officer at issue, Connor Murray, according to the AG report, stepped in front of the vehicle, fired 3 shots, and then at the time that the 4th shot was fired, he was no longer in front of the vehicle. The vehicle was not a threat to him. And the Attorney General's office found that through the investigation that these were the facts. This is according to the report. And so it was disheartening to me and many people in our city that were following this path of what happened to this 18-year-old, that nothing was being done and that it was a decision not to prosecute. I'm not saying the AG would have prosecuted, but I think at least that in that case, there was a foundation established where prosecution would have been, I would say, probable based on the AG's findings. And so I'm inclined to believe that in a situation such as Donnell Rochester, the politics of the local jurisdiction, the relationship with police and prosecutor would have been taken out of the equation, and a more objective and less biased result would likely occur. So even if the Attorney General's office, your office, decided not to prosecute, I think there will be more of a comfort level that that decision was not biased and it was more objective. Wouldn't you agree?
Yes, I mean, look, and not even speaking to the Rochester case, okay, this is about, like I said, public confidence. And when the public sees that a investigation is done independent of the law enforcement entity whose member is being investigated, when the public sees that a prosecution, if a prosecution is brought, or the decision not to prosecute, as in the case here, is brought by a prosecutor not working so closely with that law enforcement entity, public trust increases. And again, I'm not speaking to the facts of the Rochester case, but as a general principle, and that's what is the after the work of the Civil Rights Commission that the chairman mentioned, the Task Force on 21st Century Policing. This is almost a universal, with a few exceptions, belief that you enhance public trust when it's done independently. And I will say this, you asked us 2 years ago in our report, to provide detailed investigative findings. You did not ask us to simply recite the facts. So in every one of the reports that we publish, there is a factual analysis. There is a legal analysis. And when we go through the series of events, and take the Rochester case, for example, 4 shots fired, we evaluate the facts and the law around each one of those incidents. And when you read the report, and Dana can talk in detail about it if you'd like to, although I don't think the investigation side of what we're doing is really what's in front of you with Senate Bill 290. We have a balanced analysis of that case, the strengths and weaknesses of a prosecution. We do not include, although we're not prohibited, recommendations in our report because we respect that the local state's attorney under the current regime is going to make the decision. But as your question highlights, it doesn't come without friction between local state's attorneys and the Independent Investigation Division.
Thank you.
All right, Senator Bolden and then Senator West.
Thank you, Mr. Chair. I really appreciate you coming out, Mr. Attorney General. Welcome, congratulations. As always, as you'll learn with me, you're probably looking forward to a good dialogue and a healthy banter. So,
And happy Valentine's Day to you too.
happy Valentine's Day to you, sir. So I do want to clarify one point before I go forward, but I don't want to be putting out any inaccuracies in that report. That was a suspect who had a warrant for armed carjacking. There was reason to believe he was armed and that the police officer did not jump out in front of that car. He parked his car in the roadway and ran straight up the roadway, the most direct route. So facts are important. So when we start putting out things that aren't accurate, that lends to not trusting the process, whether it's here or in your office. So I just want to make sure those facts were pointed out and straightened out. You made the point, I thought it was a really good point, that people who rely on prosecution, they want to rely on prosecution decisions with input impartiality. I thought that was a really good point. And we have a system in place already where we have state's attorneys who are elected, like you are, sir, and they are held to the same standard. And we have MOUs in place for these allied agencies to do these investigations and have the other state's attorney involved in it, so that the issues that were brought up by the chairman saying that it would be, which he didn't want to recognize me, which is fine, but for another round of questioning, was that we have that mechanism in place by these MOUs to facilitate an objective eye outside the bounds, the jurisdictional boundaries in which the actual shooting occurred. Do we not?
So my understanding, and I think the chairman mentioned it, is certainly Howard County and Montgomery County has it. I would say this, though, is I don't think this General Assembly is going to put the horse back in the barn on the investigation. I just don't think you will. That's not in front of you. I can't imagine that would happen, although there are some that might want that to happen. So where we are today is you've got this independent investigation. The question is who prosecutes. I tell you, I've had conversations, and I think the focus is on, it should be on, public confidence, trust. I think law enforcement wants that public confidence and trust. It helps them better do their work. But in the conversations that I've had with prosecutors, federal and state, I'm not a prosecutor. The conversations I've had, and I dare say, any state's attorney who comes up and testifies, ask them to speak with you in the back room and to answer the question. Would you rather, I'm not talking about a DUI, or I'm not talking about a simple assault where the police wrap up the investigation, they hand it to the prosecutor, you show up in court and you present it. I'm talking about the complex, high visibility murders, rapes, and police involved shootings. Prosecutors want to be on that scene sooner rather than later. They want to help shape the investigation. Make sure you covered this, you covered that. Okay. A prosecutor doesn't want someone else, another prosecutor, to lead their investigation. They just don't. But we're not going to put the horse back in the barn on the investigation. We are doing the investigations. So I talked about public confidence. I finished my comments by talking about it's best practice for prosecutorial function. You want the prosecutor who is supervising the investigation to prosecute.
Well, I appreciate that, Mr. Attorney General. And should this move forward, I mean, last year there was 16 outside of vehicle crashes with the report that I read. There was 16 police involved fatal shootings or the like. Is that correct?
I mean.
Off the numbers,
report speaks
it was
for itself.
16
Yeah,
and there was 7 by motor vehicle.
Yep. I mean, I know I've got the numbers somewhere. Some were,
Okay.
gunshots, some were vehicular. Yeah.
Yeah, I'm not including any vehicular. I'm just
Mhm.
talking about police use of force
Mhm.
and or gunshot related.
Mhm.
So while they're looking for that, I just wanted to point, of those 16 investigations that the AG did their independent investigation on last year, how many of those would the AG have criminally charged?
Let me tell you this, Senator, I made a commitment to our state's attorneys that I will not answer that question because I am not trying to suggest that they are not doing their job. They independently judge the facts and the law, and they make their decisions.
Okay,
And I'm not going to second guess them in the reports, and I can't do it here today, and I wouldn't do that.
so we don't have to even make a reference. I understand what you're saying, Mr. Attorney General, but we don't have to reference specific ones. I'm just saying, across the state, you're the independent investigative body. How many of those reports would have required, in your eyes, the current administrations, that they've been prosecuted?
I'm not going to answer the question.
Okay, thank you. And then my next question is, where would these cases that your office would be investigating in tandem with the state police, once that's concluded and charges are filed, where would the cases be held? Where would the trials be held at if they were charged with something?
They'll be held in the jurisdiction where the offense is committed.
In the local jurisdiction?
That's right.
They would
Unless
not be.
there's some other
It would not,
reason.
I just want to make sure, because
Yeah,
I know
unless
your
there's
office.
some other reason for a change of venue, but I think the starting place is the venue where the incident occurs.
Okay, I just want to make sure that we weren't going to be, moving everything to one central location because it was a better commute or something. So, all right, thank you, Mr. Attorney General. Thank you.
The Court of Central Jurisdiction in Maryland. All right, Senator West, and then we'll go to Senator James, then Senator Sidnor.
Thank you, Mr. Chair. Mr. Attorney General, it's great to see you here. Over the course of the past 8 years, the former Attorney General, Brian Frosch, and I developed a very good working relationship. And I trust that you and I will develop the same sort of candid and congenial relationship over the next 4 years at least. But I need to ask you some questions about this bill. I've never liked this bill and I don't like it today. Let's hearken back to Marilyn Mosby. You'll recall that after the Freddie Gray situation, Marilyn Mosby quite publicly announced that she was going to prosecute some police in Baltimore City. Nothing good came from that. It created all sorts of divisions. The cases either were lost or ultimately dismissed. No policeman went to jail, but Marilyn Mosby became known as the police prosecutor of Baltimore City, and I believe at least it had played a role in her ultimate defeat at the ballot box. So if you get this power you're asking for here,
I'm sorry, okay, thank you. Thank you. Apologize.
Sorry. If you get the power that you're asking for into this bill, aren't you concerned that you're going to become known not so much as the Attorney General, but as the chief police prosecutor in Maryland? The other things the Attorney General does don't generally generate huge headlines. If the Attorney General's office, with all of its resources, indicts a policeman in Somerset County and descends on Somerset County to try to put that policeman behind bars, it's going to be headlines in every newspaper in the state, including the Washington, D.C. papers, for as long as that trial goes on. And the more you do this, the more you're going to become known as the chief police prosecutor of Maryland. Doesn't that concern you that the public perception of your office is going to fundamentally change if this bill is passed?
I believe that if this bill is passed, it is going to enhance public confidence in both the investigation and the prosecution of police-involved deaths. We're going to do our job in a fair and balanced way, as we've done for the last 2 years with the investigations, and we would take the identical approach to prosecutions, where the facts and the law suggest that a prosecution is warranted, then we'll prosecute. And if it doesn't, then we won't. And that's true whether it's in, Suitland, Prince George's County, or Somerset, Eastern Shore.
Well, let me ask whether during your campaign for office last year, you went around the state and announced that if you became Attorney General, you would seek to divest the state's attorneys elected in each of the counties of their power to try these cases and take that power into your office in downtown Baltimore.
Actually, Senator, if I could clarify, and I'm glad you raised that, because on the campaign trail, I actually took a different position that was going to empower the state's attorneys. The position I took then was the bill should give the state's attorneys the right of first refusal to prosecute. And if they decide not to, and we believe that the facts warranted, then we would prosecute. And guess what? State's attorney said they didn't want that. They did not want that. And I don't blame them, because just like I couldn't answer your question about whether or not I would have prosecuted any one of the 24 or 25 here, you've got a scenario where a state's attorney says, I'm not prosecuting. And now I prosecute. I get a conviction. Somerset County residents look at the state's attorney and say, what's your problem? So,
Let me try
so
to-
they didn't like the first right of first refusal. And we've had a lot of conversations with the state's attorneys, and they convinced me that, like, yeah, no, that it doesn't make sense. We need an exclusive authority to really build the confidence that the public deserves. And that's why I think the way that that this bill was introduced strikes that right balance.
Well, let me then go to a two-part question. Part one, have any of the state's attorneys in Maryland supported this bill?
According to their testimony,
Well, they don't all testify. There's some
No,
they're not heard from here.
according to the testimony supported or presented by the Maryland State Attorneys Association, the vote, I believe, was, and they can correct me if I'm wrong, 23 to 24. 24 state's attorneys, 23 opposed the bill. So presumably either one was not present or supported the bill.
I got you. Okay. So what would happen in your view if you decide, if the state's attorney quietly lets you know that based on your investigation, he would not indict, and you decide to indict anyway, and the state's attorney publicly states that he thinks the prosecution is misplaced and he would not have indicted? Wouldn't that put you in a difficult position?
I have considerably more confidence than that in our state's attorneys. I really do. I respect our 24 state's attorneys. I believe that they understand that our office will exercise independent professional judgment in doing the best job that we can. They'll recognize that the legislature is now giving that authority to the OAG. I believe they'll respect it, and I believe that they will not publicly undermine the investigation and prosecution.
All right, let me go back to the part of your testimony that I quoted earlier. The sentence is, and here's why I'm asking this question. 2 years ago, we first encountered the bill to take investigatory powers away from local states' attorneys' offices and give the power to the Attorney General. And I opposed it at that time, concerned that this was the camel's nose under the tent, that this was the first step to further displacement of of a state's attorney's power. So here we are 2 years later with a bill not only to have the Attorney General conduct the investigations, but also handle all prosecutions in these cases. So here is your statement in your testimony. The public should have confidence that prosecution decisions, you don't say prosecution decisions in police-involved deaths, you just say prosecution decisions are made in an impartial manner by people who do not work together or rely on each other professionally or personally. Now, every day of the week, state's attorneys across Maryland and their offices are working with police to investigate, and then state's attorneys indict criminals. Let's just say hypothetically a rape case. So the state's attorney's office would work very closely with the policeman on that rape case. If I'm reading your words, you say the public should have confidence that prosecution decisions are made in an impartial manner by people who do not work together and rely on each other professionally or personally. Is there any chance whatsoever that you will come back to us next year or the year after and say, okay, now we have the power to prosecute all the police-involved murders. We want to expand that power now and take more power away from the state's attorneys because they work with local police, and we want the power ourselves to prosecute situations in which the police and the state's attorneys have been working together, and there's a prosecutorial decision to be made in this rape case?
Senator, what I would say is the phrase prosecutorial or prosecution decisions, that has to be read in the context of this Senate bill that's in front of us.
But the principle is broader.
Right.
So this is a case of the Maryland Attorney General taking power away from the duly elected state's attorneys of the various counties. So you can no longer do what the voters elected you to do. And my question is, this is the second bite at the apple we've gotten in 2 years. Are we going to get a third bite at the apple sometime later during your term with you claiming there are more cases that should be withdrawn from the state's attorneys and vested in your office?
Right. I would say that's one slippery slope. You don't have to worry about us going down. I've spent 8 years sitting where you're sitting on the other chamber, 8 years on the second floor as lieutenant governor. I spent a lot of time in this room and 6 years on Capitol Hill. Pray for me. I've made it out. And I say all that only to know that with every authorization, it's not worth anything unless you have resources. For us to go down the slippery slope that you're suggesting that we would go, I would stand here before you and say, I need, and I don't know the answer because you got 24 state's attorneys, add up their entire staffing. Okay, let's say on average, they've got, I don't know, Baltimore City's got a 200 authorization. Some have 30. I'm going to come in here and ask for 2,000 prosecutors. I mean, that's a slippery slope. I really wouldn't be too concerned about going down.
Okay.
The prosecutorial or the prosecution decisions that I'm referencing is in police involved shootings when that relationship is directly in question, because it's not investigator and police working towards a case involving someone else. It's prosecutor and police who are in a relationship where they're now pitted against one another potentially. That's what that phrase is referencing.
Thank you. I appreciate your answer, but you'll appreciate, I think the question needs to be asked.
Yeah.
Because this is now the second time in 2 years, which we've gone further down the same road. Okay, let me read you a sentence out of the testimony of Scott Schellenberger, who's the Baltimore County State's Attorney. He said, just 2 short years ago, the decision was made by this committee to leave the power to prosecute in the hands of the local prosecutors. That's what the people elected the prosecutor to do, make prosecutorial decisions. Handing this power to the Attorney General and taking it away from the local prosecutors runs against hundreds of years of history. So my question to you is there some reason why this bill is being brought now as opposed to 100 years ago or 200 years ago? We've always had situations in which police officers get entangled with members of the public, and at the end of the experience, a member of the public is dead. So why this bill at this particular time? Is there some specific injustice that you can point to that you're trying to remedy with this particular bill?
Senator, I would say that there has been a clarion call across this country, and Maryland is not immune, for greater police accountability. There has been a decline in trust towards law enforcement. And let me just say this. I don't want to get too personal here, okay? Like, I spent 30 years in uniform in the United States Army and Army Reserve. It's a different uniform than the men and women who raise their right hand to protect and serve. But I got a sense about the difficulties, the challenges, and the sacrifices they make. My biggest priority when it comes to law enforcement is that they can do the difficult job that fewer and fewer people want to do today, but most importantly, come home safely to their families at night. I think when you restore confidence, when you have confidence in the police, you make their ability to do their job and come home safely even that much greater. I'm married to a woman. Both of us are in our second marriage. Her husband was a police officer who died in the line of duty. I raised a stepson who lost his father, who was a police officer. And I have I have a stepdaughter and a husband who both law enforcement, one Capitol Police, one Prince George's Police. The men and women who put on this uniform are near and dear to me. And every step I've taken in my public professional life is to empower them, to strengthen them, to make sure they have the resources, the leadership, the training, and the public trust that they need to do this. So I will never come before this committee offering up anything or supporting a bill that does that.
Thank you. I have just one final question, and that is, I'm looking at the testimony of the Howard County State's Attorney. I know nothing about him. I've just read his name for the first time.
He's a good man.
I assume
Rich Gibson.
He may be here. I'm still told he's here. I'm assuming because it's Howard County that he is a Democrat. And here's what he says, and I want you to respond to it. He says, there is no merit to claims that prosecutors are unable to evaluate and hold accountable law enforcement officers within our jurisdictions. To assert that we, as the elected state's attorneys, would be biased and either incapable or unwilling to prosecute law enforcement officers in these cases under the appropriate circumstances is not founded in any facts. So my question to you is, what facts can you cite which would suggest that the state's attorneys elected by their people in their own counties are unable, either incapable or unwilling to prosecute law enforcement officers?
That's a tough decision that you're going to have to make, right? And I point you to, there are different opinions on this very question. Look, these are not easy decisions that you have to make. There's no doubt about it. These are difficult decisions. And you can rely on the testimony of the current state's attorney. And if you do, that may not be an unreasonable decision. Or you could look at a prosecutor with 37 years of experience, also from Howard County, didn't rise to the level of state's attorney for Howard County, but a lot more experience, who talks about the relationship is too close. It's too close for a prosecutor to bring this type of action against a member of law enforcement of an agency that they work so closely with. This is a prosecutor with 37 years of experience, and you're going to hear from others who have experience in this field, more than me, okay, about the inherent conflicts and certainly the perception of conflict and impartiality when it comes to these matters, police-involved shootings, and who prosecutes and who investigates.
Thank you, Mr. Attorney General. I really appreciate our opportunity to have this conversation.
Thank you, Senator West. I'll point out that you remember our trials during the police reform effort, and this was in my mind back then in 2020, 21. I mean, this is the completion of that reform that I started to, and it was only after we had put forth the bill that the general's predecessor came forward and said, hey, look, this makes sense. And here we are today trying to round out the reform to make sense. Also, I'd say that, it's interesting history. I mean, I know you're a fan of this, but in 1975, before I was born, but 1975, you were there. You were practicing law in 1975. But when we created the Office of State Prosecutor, there was a huge struggle. We passed a constitutional amendment for that. And there was a vigorous debate over that. Not a single state's attorney supported that effort. Yet here we stand. Senator James, then Senator Sidnor.
Mr. Attorney General, we go back a long way, and I really am delighted you are here, and I'm also delighted I'm here. So
Yeah, congratulations.
we can have this conversation. I take really to heart that there's a worry that public confidence has been diminishing with the relationship between police and some communities. And so I know that's what's behind a lot of this. So all of my questions are really making sure that if we try to address that issue, that we don't create equally and opposite problems as well. So I think you have to appreciate that the public in many places also lack confidence that the state government, local governments are treating police fairly. And for them, this kind of law is part of that issue. And all the riots and demonstrations and discussions. So it's going on in both ways. So as we try to do a bill like this, particularly as my colleagues sort of brought out, that there doesn't seem to be evidence, but more perceptions. And I'm open if you can provide evidence that for why this bill has to happen. But I think without it, then both of us are trying to deal with perceptions and fairness. So that's sort of where these conversations are coming from. The first question I want to ask you is, the state's attorneys bring up, as my colleague said, the idea that they are locally elected, locally entrusted, because most criminal matters are locally dealt with and the community that's reflected. And your response was, well, the Attorney General stands for election. But I've just got to be super honest about that. In the state of Maryland, generally, especially in the last 30 to 40 years, it's Montgomery, Prince George's, and the city, and maybe one other county that really decide a statewide election. Other 19 or 20 do not. So I want you to bear that in mind as you move forward about this idea that you're going to be held accountable. But there could be 18 to 20 jurisdictions that think that you have gone in the wrong direction in how you're handling police investigations, but more importantly, prosecutions. And I don't know of a mechanism to hold your office accountable with a statewide election. So I just wanted you to be sensitive to that issue. So trying to get to the bill itself, and I was not here, so I have not read all the background, but you talked about how, and I get it, that you have some wonderful attorney generals, assistant attorney generals right now in that, the IID department. Would you be adverse to an amendment that discussed and included the kind of background they should have, as well as these prosecutors that we're going to create, so that they do have the kind of broad background, not only dealing with the perceptions you're talking about, but the perceptions I am talking about, as well as the experience. So in other words, their experience would allay concerns about perception. So that's a thought I have.
Look,
And I
I-
wonder if you'd be open to that.
Absolutely.
Okay.
I mean, I know the legislative process, and we're going to work with this committee, with the chairman, with the members to address and hopefully alleviate every concern that is raised.
Great.
And
So-
if we can look at qualifications
Good.
and there's a way that we can achieve what you want to do, we want to work with you on that.
And then again, another amendment that might be help with perception is putting in place some kind of firewall between the investigators and the prosecuting side, because just as you are worried about undue influence, so am I. And I think others are, about how these two parts of your office will work together. And I would like to see that they make their decisions very separately. I think I don't know where I put it. Currently, your investigators make no recommendation to the state's attorneys as to prosecuting. I didn't see that restriction in this bill, so maybe that would be a place to start.
Right. Well, if this bill passes, we won't have to worry about that because we won't be sending a report to the state's
No,
attorneys.
You're missing.
Yeah, maybe I missed
The
it. I'm sorry.
independent, the IID does not make a recommendation to the state's attorneys as to whether to prosecute. Maybe part of the firewall would be that same investigative group does not make a recommendation to the prosecuting side of this bill, that they give them their report, they don't make a recommendation. Let your attorney generals tasked with deciding whether to prosecute make that decision independently. It could be a possible amendment. The other thing that I was thinking about is, you mentioned, and I get it, you have all these criminal division, organized crime, human trafficking, and oftentimes you're invited to prosecute these cases locally. And I don't know whether in those circumstances, do the attorney generals collaborate with the state's attorney? Do the state's attorneys in any way help your assistant attorney generals come into the jurisdiction to prepare these cases, or does that not happen at all?
I will allow, when Dana Mulhauser comes up, she can speak more to that. She's on the IID, but she works closer with the criminal division. Or she is familiar with the operation of the criminal division, I should say that way, not works closer, familiar. I'll let her speak to that. What I will tell you is that we are, particularly on these multi-jurisdictional organized crime. I mean, we are one of the units of choice where, it's the local law enforcement, whether it's, Howard County, Baltimore County, Prince George's, Baltimore, to name a few, FBI, ATF. And we don't do anything in a local jurisdiction without talking to the local state's attorneys. We just don't. Now,
And there's a reason I'm asking
Right.
this, because that's not, the reason I'm asking that is I think there's a valid issue about coming into all these jurisdictions without some collaboration locally. And so I had two thoughts. I don't know what the amendment is here, whether it is to collaborate with the local state's attorney. Another idea would be to have your assistant attorney generals specifically assigned to certain counties and expect them to immerse themselves in some way to get to know that jurisdiction, to deal with the issue of whether they're familiar or not. But just that's another amendment I'm thinking about, how we could ensure from the worry I hear is that you are not familiar with local juries, local communities, the way things work in a particular jurisdiction, much like we use local counsel all the time with out-of-state attorneys. Some kind of idea where there would be some collaboration for you all when you come into a jurisdiction that you're not in very often, and or require that your people to get familiar with that jurisdiction and have that familiarity in some way.
On that one, I just want to reject really the premise of question or suggestion about an amendment in that area, in that, as I stated earlier, this idea that we don't understand the communities, the customs, the courtesies, and the potential jurors, there's just no basis in that whatsoever. We today are called upon by law enforcement around this state to come participate in investigations, whether with local law enforcement, with federal partners, and to prosecute cases around the state. The state's attorneys would not be looking to us, nor would local law enforcement, if they didn't think we could bring a successful prosecution in Harford
I
County.
think we're talking past each other because I'm not suggesting that. But you do collaborate, as you just said, with the state's attorneys when you come into
Right.
that jurisdiction.
We're not going to be able to collaborate with the state's
I know.
attorney on these.
That's
For
right.
the very
But I'm
reason
thinking
why we're
of
here.
that loss and how we could replace it in some other way if this bill comes into fruition. And then just sort of one other question. Just give me 1 second to find my notes on it. I guess, and you weren't here either, so I don't think you have to answer this now, but I do want to understand, Mr. Chairman, why 2 years ago, so I'm not sure it's fair to ask the current Attorney General, but why 2 years ago we didn't do this, and then, and now we are, and I don't know if that means that things have happened in those 2 years that makes us want to do it now. So, I want to look into that as well, but I won't ask you that question.
I wasn't here either.
Yeah, I read that. Thank you. Thank you. Thank you.
All right, excellent. I can give you that answer. I mean, look, I tried, but we'll go.
We'll talk about it later.
We'll talk about it
Thank
later.
you.
But also, I think, again, looking at the Office of State Prosecutor is instructive in terms of how an independent body goes into jurisdiction that's responsible for the entire state, collaborates. Senator Sidnor.
Thank you. So I am looking at page 5, lines 24 through 26. And the way that I'm reading this bill, the state's, the Attorney General is simply seeking primary jurisdiction over police-involved incidents resulting in injury. And it's your office that has that right of first refusal. So if you all decide that you don't want to move forward with the case, you can hand it off to a state's attorney to prosecute. Is that correct?
No,
Am I not reading
I
it
don't
correctly?
read it that way.
So could you tell me how you're reading lines 24 through 26?
Oh, I was looking at line 7. I don't know if I have a different version of the bill. I was looking on is that page 5, line 17 to 18?
Right, it says a state's attorney may prosecute a criminal offense described in subsection A1 of this section only if the Attorney General requests that the state's
Oh.
attorney prosecute the offense.
Got it. Okay. Yeah, that's a different provision. So let me explain that. And I know a question came up earlier about to the chairman about sort of blowing wide open the door to offenses that could be referred to us. So you may have a scenario today where it's a police involved incident where you don't have death or the likelihood of death, because that's the current types of incidents where we have jurisdiction. The provision that you read would be a scenario where you don't have loss of life or the likelihood of loss of life, but the state's attorney says, in that police involved incident, I'd like for you to take that case as well. Okay, it's only upon referral from the state's attorney. We don't have the jurisdiction. We can't go in and get it. I think after speaking with some stakeholders, and maybe they'll testify, and I really don't want to misrepresent them, I think we need an amendment there, because what we're really talking about is when there's substantial bodily injury, right? Where there's cases where you don't have death, you don't have a likelihood of death, But you could have substantial bodily injury and the state's attorney says, hey, we want you to take that one as well. That's what that provision is trying to get after. The referral, not exclusive jurisdiction, not primary jurisdiction, but secondary in the sense that the state's attorney can refer to us those types of incidents. I think that provision needs some amendment, some work.
Yes, I'm not reading it that way, so I
Okay.
appreciate that. Thank you.
Yeah, just, so lines 24, we move this along, but lines 24 through 25 refer back up to lines, you know, to lines 13 through 18. So it's talking about that optional, whether they can refer, and the Attorney General is absolutely right. Because the only thing under the purview right now is the result in death or likely to result in death. So these other things can be captured here if the state's attorneys refer. Senator Folden, you're up.
I'm going to try to wrap this up real quick, Mr. Attorney General. I know you've been on the hot seat for a little bit, but I appreciate you coming out and answering.
Great to be back in
It's great.
Annapolis.
Yeah, it's always good to be back, have a healthy dialogue. When you talked about the slippery slope that you weren't really, when Senator West was talking about, and you brought up about the PIN numbers. He asked you about if it was going to get, potentially spill over into other areas. It's a great question. And your answer was, you talked about PIN numbers. You didn't answer the question like that you believe that, no, this is going to be limited to this. You talked about how much it would cost to take the PIN numbers. So I want to ask it again. Are you saying here that there's a chance that you would take this on if
No.
it was brought? Or are you saying, so you're saying now today, no, that this is where it's limited to, regardless of the cost of the PIN numbers for the AG to employ those employees?
Right. So what we're trying to do is extend the prosecutorial authority for police involved shootings that result in death, the likelihood of death, or if we have that amendment where we get a referral from the state's attorney when it involves bodily injury. That's all we want.
Okay.
That's all that's in 290 or the, and we're not looking to come, but keep in mind, the state's attorney. I mean, this is the only reason why I said the PIN, and maybe I should. We got 600 lawyers in the state's attorney's office.
Yeah,
We
no,
do
I understand.
Antitrust and securities and consumer protection, and so we're not trying to be the 25th state's attorney.
Totally understand. Just wanted to get clarity on that because it wasn't, and I didn't think it was fully answered. I just wanted to make
And
sure
I
we got.
apologize for that. That is clear. We're not looking to take on that authority.
Okay, and then the part about when we were talking about the collaboration with the local state's attorney's office, should this power be transferred to you for these types of incidents, and you seemed that wasn't altogether necessary because you're also a prosecutorial element within the state. My concern with that is don't you consider that to be a myopic lens at that point, that we're not looking at the diversity of the state across, because we constantly want to look at things, but would you say that policing in Baltimore City and the situations they encounter are the same as what a deputy sheriff in Wycomico County would have to deal with?
So you were referring to my response to the question about cooperating with local
Correct.
prosecutors.
Yes.
So let me answer it this way, okay? And I really, this is not punting, but Dana Mulhouse, who runs this division, she can give you better.
I can ask her.
But let me just say this. What I was trying to convey in the question is, in the answer is, what we can't do is cooperate around the decisions to prosecute, because then it's not independent. Okay. Now Dana can talk to you more about okay, once we make the decision, we're in Hartford County, we're in whatever county, and we say to the state's attorney, hey, we got this jury pool here. What do you think about in terms of selecting a jury pool? She can better answer whether or not, whether that's something we can do or not. I was trying to go after the larger sort of a concept of
Understood.
It's got to be independent, but on the tactics, I think Dana can speak more with experience on how we might be able to work with the local state attorney once the decision is made on the case.
And then kind of piggybacking on that and rounding this out is, 23 of the 24 state's attorneys in the state oppose this, correct? oppose this.
Yeah, that's what I
was-
read in the
Okay.
MSAA's.
And then
And I think that was probably the same number maybe that opposed
who,
the investigation 2 years ago.
do we know what the one was that was for this?
You'll have to ask them. I don't.
Okay. Montgomery County? They said nothing. So we have 23 opposed, one that remains silent in the chairman's local jurisdiction. Okay, irony. Oh, I'm sorry. Was that out loud, Mr. Chairman? Ironic. Okay, and then the Office of the Public Defender, they all were in support of this. Correct? Across the state, is my understanding, correct? So do we know, do you see the same difference that I see between these two bodies, these two responsibilities? One's held accountable by the members, the citizens that they serve, they're elected. The others are appointed or they're put into a position by someone else. There's no election. So isn't it true that the responsibility of having that power transferred and being held by the citizens that they serve is important? Because we entrust the state's attorneys to do their due diligence and prosecute according to law. So by this bill, by its inference, by its mere appearance, to me indicates that there's a belief by your office that the state's attorneys are incapable of being unbiased.
Well, Senator, going back to my original testimony, I mean, I acknowledge the competence, the capability, the effectiveness of state's attorneys. I'm not questioning their ability to do their job. What I'm testifying to today and why I support this bill is because this is about public confidence in a system right now where there has been an erosion of public confidence when it comes to police involved deaths. And when you have a impartial, independent, so I'm going to focus on independent, okay, and impartial in the sense of what the testimony from the 37-year veteran, when you have that close relationship, okay, the public questions the impartiality of it. And I think, for example, the example that Senator Carter gave, and again, I'm not speaking to what the recommendation could have, should have, or would have been in the Rochester case. We didn't make it. And I certainly don't question the decision by the state's attorney. But I can tell you right now, and Senator Carter is from Baltimore City. She heard the response when the decision was made. If that decision was made by the Attorney General, I think that builds even greater trust, not just in the system, in the process. So I think it's about public confidence in the process and not questioning the ability of state's attorneys to do their job.
I agree with that, or I understand that. I don't agree wholeheartedly. I mean, we can agree, disagree. I just think that it's a slippery slope that we engage in this type of attempted takeover of responsibility that's already clearly delineated in the law. And by virtue of this bill, it would lead those to believe, to say that you and your office are above and beyond reproach, that no one's going to have the clarity of thought like your office. No other state's attorney is going to have that thought because your office is the only independent office. But if I look at the scales of justice, they're level. And they're level because the responsibility of the state's attorney's office is their job to be the impartial, not to side with law enforcement. It's their job to also be a part of that investigation and to adjudicate things according to law. Is it not?
All right, so the Attorney General's give you an opportunity to answer that question, and then we've got Senator West. Are you next? You still have your question? Okay, all right.
Like I said, the state's attorneys around this state do a fantastic job in the work that they do. The issue before this committee, when I say it's simple, it's not easy, but it's, do you want independent prosecution as perceived by the public to build public confidence that I think helps improve the law enforcement effort or not? It's similar, if not identical, to the difficult decision you made 2 years ago.
Well, I wasn't here 2 years ago. I got
Nor was
fired in
I.
18.
Nor
But
was I.
I appreciate your time. Again, we'll agree to disagree on that. I just wanted to point out that the scales of justice aren't only held at the state level and higher. They're all state offices. They're all elected to do the same job. and they do it very well. If you could show me one incident of this occurrence, or the chairman could show me one incident where this type of the current law that's in place, even working in conjunction with the AG's office on their independent investigation unit, was not properly working, you could create some buy-in on this. But without having any facts to necessitate this change, I just find it highly insulting to the state's attorneys who do an outstanding job. So I thank you, Mr. Attorney General.
All right, thank you very much. The Attorney General's been up there for close to 40 minutes now. We appreciate the effort. Thank you for coming down.
Thank you,
Pleasure
Mr.
to have
Chairman. Thank you, members of the committee.
Thanks. Excellent. All right. Next, we'll have our next panel. The Chief of the IID, Dana Mulhauser, Ms. Warnken, Dwight Broughton, and our Public Defender.
I will go ahead and start us off. Good afternoon, Chair Smith, Vice Chair Waltricker, and members of the committee. My name is Dana Mulhauser, and I'm the Chief of the Independent Investigations Division at the Office of the Attorney General. I feel privileged to lead a team of dedicated professionals whose job is to investigate these incidents with independence, with thoroughness, and with transparency. We're now in our second year of operation. We've conducted 29 investigations, and we have done so with care, with neutrality, and with the attention to detail that Marylanders deserve. We are, as we promised to be, to the extent we can be, an open book. You can read all of our completed case reports on our website, which describe every investigative step we've taken, every witness we've spoken to, and every piece of evidence we've analyzed. I'd like to give you some facts from our first year and a half, which you can find in our annual report in front of you, and some of which have been updated for this testimony. Our average time of arrival on a scene is 1 hour and 14 minutes. Our partners at the State Police Crime Lab have analyzed 5,800 microscopic pieces of evidence. 55% of the fatalities we investigated were shootings. The remainder were in custody deaths and vehicle fatalities. More than 80% of the cases involved camera footage, all of which we have made public. I tell you all of this so you can know what these fatalities look like, what we do to investigate them, and why we are here supporting this bill as a best practice. We believe firmly in the best practice that you all instituted 2 years ago in creating the IID. This is about extending that best practice to prosecution authority. It is about treating police officers the same way we do everybody else, by making sure there is a distance between the person who is doing the investigating and prosecuting decisions and the person who is being investigated or potentially prosecuted. No one would think that it is best practice for a prosecutor to decide whether charges should be brought against their neighbor, against their friends, or against their coworkers. Neither is it best practice for them to be asked to consider charges of this magnitude against a police officer who they work with regularly and whose testimony they rely on. This body overwhelmingly agreed on that independence when it created the IID 2 years ago and when it solidified that authority last year. That same principle should be implemented with respect to prosecutions as well. This bill also contains 2 smaller changes. It allows the state's attorney's office to voluntarily, only at their discretion, refer a non-fatal excessive force case to the attorney general. And it clarifies that the IID would investigate in the event of a friendly fire fatality. I'm happy to answer questions.
Good afternoon, members of the committee. My name is Heather Warnken, and I am the Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law. I am grateful for this opportunity today on behalf of our center to testify in support of Senate Bill 290. Impartial, independent investigations are the bedrock of the American legal system. Few incidents challenge the integrity and legitimacy of this system more than the decision to prosecute or decline to charge a death involving a police officer based on those investigations. As will be discussed at length today, an inherent conflict of interest exists when states' attorneys investigate and prosecute officers from the same police agencies. This conflict of interest casts doubt not only on the capacity and effectiveness of local prosecutions of officers when needed and warranted, but it also undermines their credibility when those offices legitimately determine that a prosecution is unwarranted. SB 290 represents an important step toward the legitimacy and viability of a legal system already notoriously rife with systemic racism and which has been continually damaged by the litany of police violence and misconduct cases that have given rise to some of the strongest social movements in recent memory. By taking this important step, aligned with best practices as discussed in our written testimony, vesting prosecution authority in the Attorney General's office, SB 290 will help ensure that cases warranting a criminal charge are pursued and that the decision not to prosecute are also accepted by the public as the product of a legitimate and unbiased evaluation of both the facts and the law. For these reasons, we urge a favorable report. Thank you.
Good afternoon, and thank you for having me. My name is Dwight Drohan. I'm a partner at Steptoe & Johnson in DC. Prior to that, I was an assistant United States attorney in Greenbelt, Maryland, and also in that capacity, the civil rights coordinator, where I prosecuted and investigated matters involving police officers in several of the counties that I looked at. There are three reasons that I want to focus on as to why I support the bill. The first is the decentralization of police investigations and prosecutions would allow for a development of a mastery. Fortunately, there aren't that many of these instances that come up, and a particular county won't have the volume to understand the nuances that will go to an investigation that's this complicated. Having an entity that will do it repeatedly gives them that sort of expertise, and also provides equity, because you might have a prosecution in Prince George's County and a prosecution in Somerset County. You want to make sure that police officers are being treated fairly, and having an office that will consider how the different prosecutions can lay out and what the sentencing guidelines could look like would be important. The second thing, which was brought up earlier, trial attorneys want to have control of the investigation from the beginning to the end. I don't want somebody developing a case theory and thinking about investigations based off of their case theory that wouldn't align with how I would try the case. And I got to tell you, a lot of prosecutors, a lot of trial attorneys generally will always criticize someone else's work. We just think that we do it better. So being able to investigate the case yourself allows you to have the vision to think about all of the steps that you would need to persuade a jury. And the third has been talked about a lot, public trust. The reality is that oftentimes, and it's sort of silly for me to tell you this, public perception is reality. And when you have a situation in which there are such closely tied entities, it's not going to be when they're prosecuted. It's going to be when there's a declination. That's when there's going to be uproar. There's going to be questions about the integrity. So being able to say we separate ourselves from this and we made sure that an independent party looked at this helps a lot. Time is running out. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, committee members. I am Natasha Dartigue, Maryland Public Defender. The Office of the Public Defender is in strong support of SB 290. Thank you, Mr. Chair, for your leadership in bringing forth this bill and sponsoring a bill that enhances police accountability through independent investigation and, where necessary, prosecution of police-related deaths. There are few acts committed by local government that draw more controversy than a police department's use of lethal force. Broad cross-sections of the public, and I highlight the Black and Brown communities throughout Maryland, have lost trust in local law enforcement agencies, due in part to their perception of biased investigations of such deadly force incidents. Civilian distrust can be traced to the perception of a cycle of impunity by which reluctance of local government to prosecute bad cops empowers future misconduct and drives communities to regard the police as adversaries instead of protectors. Maryland is among a list of states known for lethal force, homicide by police. From October 2021 to September 2022, a total of 23 police-involved fatal deaths occurred in Maryland, and this was across 11 counties. Anne Arundel, Baltimore City, Baltimore County, Charles, Frederick, Hartford, Montgomery, Prince George's, Queen Anne's, Somerset, and Wycomico. 0 of the 13 deaths were prosecuted by local state's attorney's offices. The benefits of a thorough and unbiased investigation is far-reaching. It sends the message that the law applies to everyone, and all Marylanders benefit from enhanced police accountability. Thank you.
All right, thank you very much. Questions from the committee. I see Senator Washington and then Senator West.
Yeah, thank you, Mr. Chairman, and Mr. Attorney General. Thank you for this bill as well and for supporting it. Just for some background, see, my colleague, Senator James just left, but this bill wasn't just only introduced in 2020, it was introduced back in 2016 by multiple members of the House and the Senate as well. So this has been a discussion that has been ongoing for years. And I'm actually really proud of this, of your work here. And I have a question for you, so you could just hop up, but because we passed a bill just before Freddie Gray died that actually collected this, that required the state and all of our local jurisdictions to collect this information. And I was the lead sponsor of that bill. And so this makes me proud that we actually have this information readily available so that your office can actually make these investigations and these determinations. The question I have for you is just, we haven't talked enough about the actual data and your process in which you go through the investigations for these incidents. And I'm not sure if our state's attorneys have this process written out like this, where it's publicly founded, but can you just explain how that process works and why you decided to make it a transparent process so that everyone can see it?
I appreciate the question. I'm happy to do that. So when we were putting all of this together, I was hired in August of 2021, and our chief investigator, Tony Shartner, who came out of Prince George's County, was hired around the same time. And when we were talking to law enforcement and to state's attorneys around the state, what they said to us is the most important thing for us to understand is certainty. The most important thing for us to understand is how all of this will play out so that nobody is standing at a crime scene trying to decide what this will look like. And so we worked with state's attorney's offices, we worked with police departments, but I think it's also important to say we worked with community members, and we met with community members to talk about what was important to them and what types of information they felt like they needed to see in order to have confidence in an investigation. To be clear, not to affect in any way the substance of the investigation, but to say what types of transparency and what types of predictability are helpful to give this process a sense of regularity and a sense of confidence. So when the state police run a 24-hour hotline, and so we are typically notified, within an hour of one of these things happening. The departments have been great about notifying us. So, their phones all go off in the middle of the night, and there's a long phone tree, and our investigators show up on scene. We always have a lawyer show up on scene in case there are any problems. The Maryland State Police show up on scene, both their investigative units, but also their crime scene unit, so that we can be involved in the investigation as early as possible, because like Mr. Drawn said, it is the sooner you can be involved, the more confidence you can have in making sure that things were not tampered with, and making sure that things are being processed properly, things like that. So we begin that investigation that day, and then we go on to officer interviews, witness interviews, the rest of it. I think you can probably see from our processes that we have a body camera release footage policy, and we have not only tried to be as transparent as possible in releasing that footage, but in talking about why we don't when we don't. So for example, there are times when an investigation requires that we can't release it right away, right? If we're going to interview police officers or other witnesses, we need to do that before they've seen that footage. And so that's really important. And we have found that when we say to the public, listen, our default is 14 days, but we have investigative reasons why we can't release this footage yet, that they have understood that because it is all laid out. So I hope that answered your question.
No, it does. And thank you for that. Thank you for the answer. As I'm reading this, and this bill is a bill that I sponsored many years ago, but I'm looking at this report, and what I'm finding is that it doesn't really have it has a lot of data in it and a lot of things about your process. But what's missing here is an analysis of like what could be done differently moving forward with these police involved deaths or even the change of the investigations. And I wondered if there are any recommendations that have been made based on the year that you've reviewed that you've had these investigations, investigatory powers. What recommendations would be made based on this?
So that's a really fair question. And it is because it was not in our brief and in the statute that you guys passed, it is not analysis that we have done. And so I want to be careful not to overstep because I wouldn't want to make a conclusion off the cuff. And, you know, I recognize that the people of Maryland are listening and I'm appreciative of that. And so because of that, I want to be cautious about that.
Yeah, no, I think that would be helpful for us. When we say that we want to collect this data, but we collect the data and we have it, but there's nothing else that comes with it, right? No other direction other than this bill, which I think is a good one that we should eventually pass at some point. But I wondered, my last question for you on this is that I'm looking at the data, I'm looking at the police involved deaths, I'm looking at the race of these descendants, I'm looking at the age of the descendants. You know, it's awfully familiar about what's happening around this country and what's happening today. And I wondered how many, because of the disparities that we see here of at least 85%, 90% of these cases or these descendants are Black or brown men, majority Black men. How many of these investigations have led to actual prosecutions? I know that's not your role, but you obviously keep track of it. How many have led to prosecutions?
So I will answer that question. I want to go back to your other question.
Sure.
to talk about the question of systemic problems, because
Correct.
all of us who do this work, I apologize. All of us who do this work, you know, have a moment when you are looking at individual cases and you're looking at them fact specifically.
Correct.
But there are questions I think that everybody in this on this committee has and that everybody in the community has about some of these larger patterns. And I will say that the Attorney General has introduced a second bill this year talking about pattern or practice of policing. And the goal of that bill, and he will have the chance to talk to you about that further, is to be able to address these things when they become patterns, because that right now isn't our job. And I think it is important for us to keep to doing what our job is. But I am very sympathetic to the question.
I like that.
And the second question was about prosecutions. And so as the annual report shows, the state's attorneys have not prosecuted those cases. And that is factually current up till today, although I do want to echo the Attorney General in saying that every case is fact specific and that we do not second guess the state's attorneys on whether they are choosing to prosecute or not prosecute a case, because that's not our job
Correct.
to do, right? So, yeah.
But just to be clear here, Mr. Chairman, last question. If you could repeat what you said, of the, I think it's 23, I think I saw 23 incidences that occurred of police involved deaths, not one was prosecuted. Is that right?
That is correct.
Thank you.
Just to clarify that the report that you published was not required by statute. This is something you did as a proactive measure. And I think that the results are instructive for other areas of policymaking. You know, the who, the where, and the how. And I think that's instructive for all of us as we move forward, you know, and as more data is collected. And then also there's some intersectionality. We're going to talk about PABs later on, and PABs, part of their role is to make recommendations. So they have now another source to draw upon. Sure, yeah, go ahead.
I just think that the what and the while, the who, the what, and the how is being collected right now. And that is data held by GOCAP, and that's within this too. And so, you know, I think that we can still move some of these things now versus waiting until we have to make additional changes, but I appreciate that.
Thank you, Mr. Chair. My questions are for Heather Warnken. Thank you. I read your testimony carefully, and in fact, you read your testimony again when you orally testified. So here's the sentence that I'm interested in. You say, an inherent conflict of interest exists when state's attorneys investigate and prosecute officers from the same police departments that they work with and rely upon every day. The fact is, police officers do lots of things that may warrant prosecution. One of them is getting involved in police-involved deaths, but there are lots of others. I'm thinking, for example, of corruption, the Gun Trace Task Force in Baltimore City being a leading example, fraud, assault. There are any number of things that policemen are involved in. So do you believe that an inherent conflict of interest exists when state's attorneys investigate and prosecute officers from the same police department that they work with and rely on every day for anything, or only for situations which result in a death?
Well, I would start by honing in on something that I've been tracking closely in the conversation today, which is the fact that perception of conflict of interest or bias is just as significant here as actual bias. So again, it comes back to this concept of the importance of public confidence in this process. But I will also say that, yes, I'm referring to, with that statement of inherent conflict of interest, of the pressures and tensions that get created when the officer is the subject of the actual prosecution. And we have these cases, not just in Maryland, but across the country, where the fallout and the damage to the working relationship moving forward in these uniquely high profile and uniquely painful prosecutions for the community play out within parties that have that daily working relationship. So yes, I think there is an inherent conflict of interest, but when the officer is the subject of the prosecution.
Right. Well, let's take the Gun Trace Task Force as an example. So Marilyn Mosby handled the situation with the officers involved in the Gun Trace Task Force. Do you think that was an inherent conflict of interest? Should that have been taken out of her hands and vested in the Attorney General of Maryland?
Well, so I know, for example, a very important role that the local state's attorney's office had in the aftermath was looking back and deciding which cases that involved those officers needed to be re-examined, needed to be thrown out based on that new information. And my understanding is that was handled by prosecutors in her office that had a designated ability and focus on that type of work.
But they were prosecutors in her office. The prosecutorial function was not removed from her office and vested in the Attorney General, even though the people in her office worked with and relied upon every day the police officers. So my question of the Attorney General earlier and of you now is, where does this stop? We started 2 years ago letting the attorney, giving sole power of investigation to the Attorney General in the case of deaths or near-death experiences. Now today, we're asked to extend that and give the Attorney General the power to prosecute all such cases. Now you're talking about the Gun Trace Task Force, which didn't involve any deaths of any individuals that I'm aware of. It may have been, but I'm just not aware of it. We're talking about corrupt officers. And you think also that there's an inherent conflict of interest between Marilyn Mosby's office and her prosecutors on the one hand, prosecuting these people with whom they have worked on a daily basis. So where do you think we need to draw the line between where we're going to invade the prerogatives of the state's attorneys of Maryland and take power away from them and vest it in the Attorney General, and where we should leave the power in the state's attorney's offices?
I appreciate the question. And I will also reiterate a point made by the Attorney General and others, which is that I believe that it is very possible and a regular occurrence that the local state's attorney's office actors are capable of doing work with integrity, focused on the job that is in the purview of their office.
But you described it as an inherent conflict of interest. How do you jibe the two?
I think that definitely it is preferable, once again, in the instances where the officer is the subject of the prosecution, to have a level of separation that ensures that public confidence, that inherent working relationship and conflict of interest isn't getting in the way. To go back to your example,
Gun Trace Task Force then.
I'd love to revisit that example.
Sure.
So the role of the U.S. Attorney's Office as being the one to actually prosecute those cases was significant. The role of the local state's attorney's office and prosecutors that worked with and under Marilyn Mosby to look back and revisit it once there was already this substantial evidence, and then certainly after the conviction phase of the corrupt acts the criminal acts of those officers is different than determining to bring the prosecution when we don't know the outcome, when we don't know if a conviction is going to be secured, especially, and we talk about this in our written testimony as well. These are uniquely difficult cases so often. They involve, and especially when it's a shooting compared to, for example, a beating, when you have a split-second decision that ultimately the results of that prosecution is going to depend on convincing a jury. And there's evidence here, including in our testimony, about the large swaths of the public that don't want to, for very good reason, question the split-second decisions of officers. That whole process, one, the unique nature of these cases and how difficult the assessment is that one, that the decisions that get made about whether to prosecute and that juries have in deciding these cases. And again, the unique nature when they are so high profile and when officers are the subject of the prosecution. That is not to be confused with me suggesting that there is an inherent bias, that local prosecutors can't do work with integrity.
Well, you've discussed an inherent conflict of interest. I guess in your view, there's a difference between that and a bias. So let me just finish with this. Is there any likelihood that in a future year, the University of Baltimore Center for Criminal Justice Reform will come to this committee and urge, if we pass this bill today or shortly, that this bill be expanded upon and that more power be taken away from state's attorneys elected by the voters of their jurisdictions and vested in the Attorney General of Maryland?
No, and I think I really appreciated the responses that the Attorney General has already given on those questions. And I would certainly reiterate and repeat a lot of his testimony there. Again, I think the really important difference here are that the police, the members of the local law enforcement agency, are the subject of the prosecution. They are the ones who are alleged to have committed
Again, in the
criminal
case of the
acts.
gun trace task force, the police that committed the acts would be the subject of the prosecution.
Right, which is why the U.S. attorney was an appropriate party to bring the prosecution.
Okay, thank you very much.
Thank you.
Thank you, Mr. Chair. Is it Ms. Mulhauser? Ms. Mulhauser? Let me start off by saying, because apparently Mr. Attorney General did call me out pretty well. Happy Valentine's Day.
Thank you so much.
You're welcome. Ms. Mulhauser, so I wanted to kind of round back to the idea of when Senator Washington asked you about, he said of 23 police custody deaths, but I'm talking about the 16, I believe, is the number that were use of force, not vehicle crashes or anything like that, but were pursuit related, but 16 hands-on use of force or shooting related that resulted in the deaths. And he asked you how many of those were prosecuted, and your answer was?
My answer was 0.
None. And then of those, I asked a similar question, and I don't know that he asked the same question, but I think it's a fair ask. Then of the 16 police involved fatalities, how many would your office have investigated?
I really just don't think that is an appropriate question for us to answer. If this committee wants us to have that authority, then we'll have that authority. But in the interim, it's not appropriate for us to second guess state's attorneys on that.
Doesn't it appear, though, prejudicial to answer that way when that none were charged? So you're answering that side to say none were charged to make your half of the argument, but to not answer how many you would have charged. Isn't that exactly what we're trying to prevent here, is a bias, an appearance of bias? Because now you're unwilling to answer the question to the other side. So this office wants to have the utmost entrusted authority that we're going to get the honest answer, and I can't get it from you.
So the question that I answered is an objective fact that any member of the public can look up, and it would be disingenuous of me to say, I won't tell you the answer, but wink, wink, you can find it on our website, right? If the answer is 0, I will do my best to assist the committee by saying, you don't have to go look it up. The answer is 0.
So you can't tell me by the fact gathering, you're the fact finding body that investigated these police involved shootings and police involved fatalities, that handed that report back to each affected jurisdiction, You can't tell us with any type of reasonable certainty on which way, how many your department, your agency would have prosecuted.
It is not an appropriate question for me to answer in the
Okay.
same way that my boss chose not to answer. it.
Okay, so, and then I'm sorry, Ms. Mulhauser, what is your title again? I
The
apologize.
chief of the Independent Investigations.
You're the chief of the
Yeah.
independent investigation. And how long have you been practicing law, ma'am?
Between 15 and 20 years.
And in that 15 or 20 years, how many criminal cases have you tried?
I don't keep a number. I was at the Civil Rights Division of the Justice Department for a dozen years. And then after that, I worked actually at a county attorney's office, starting up one of these specialized units that we have talked about.
So how many criminal cases have you tried then? Because if you were
I
at the civil rights side of it, how many criminal type cases with use of force involved have you tried?
I do not keep a trial stat sheet.
Have you tried any?
I have.
But you don't know roughly how many? Because
I do not keep count.
I'd be curious to see how many. I'd be curious to see how many, because my data doesn't show the same type of things that you're saying today. So I think there is a way to track some of it to have an idea, because you would know how many cases you were involved in that involve criminal prosecution. So,
Senator, all right.
all right. So
Senator, just, I don't mind the line of questioning. Just let's keep it respectful.
Yeah.
Certain level of quorum. She's answered the question. Let's move on to the next one.
at what point does this new responsibility that's going to be yielded to the states or the Office of the Attorney General in opposition by the state's attorneys, but in support of all the public defenders, at what point do we believe that do we continue or try to rebuild the trust of our law enforcement community back in, because we're seeing a hemorrhaging of law enforcement leaving the profession. And this is just another kind of broad overreach by a state level office when there's already a means in place with no factual data, and you're not announcing or answering any to support this change. I just find it really hard to believe. Do you agree with that?
I'm not sure what the factual data you're looking for is. So we have some folks who I believe will be testifying later that come from different community organizations or community groups that can talk about what their perception is. So I don't know if their testimony will be considered facts to you. I mean, I would like to know so that I can answer the question. I would like to know sort of what evidence.
So
would
a
be.
fact would be something that's not generated on feeling.
What is fact or what is feeling? Explain to me what it is that you would like to know
Fact is
from us.
proven,
Okay,
is
whatever.
shown, and feeling is something that you may feel a certain way, you may feel this way, you may feel like there's no factual data behind the feeling.
Now that you've explained it, I appreciate that, because we in fact have not only here in our report, but up on our website, you can find, we have all the facts that you would so desire. So I was limited to some degree in time in my initial statement, but I can give you some more facts. So I can talk to you about jurisdictions where we had cases. I can talk to you about the number of completed investigations we have. We've had 16 shootings. We've had 10 vehicle incidents. We've had 3 in custody deaths. We've had 24 cases with camera footage. We've had 13 cases that involve a weapon.
Man, we've had all the data,
Yep.
the facts there. You haven't answered any of the questioning about the fact being that your office investigated these same cases. You answered that none were prosecuted by my good friend, Senator Washington, but you're not answering anything about if there is a fact that the Office of the Attorney General's office felt, but found facts supporting the prosecution. Would it not be the responsibility of the Office of the Attorney General's office to then take possession of that case and prosecute it? Thereby, that would lend one to believe that there was no finding of wrongdoing in the facts of the case.
You know, it's a good question, and I will tell you why I don't speak to individual cases. And it goes to your question about respect for law enforcement, right? These officers are being investigated, and the state's attorney chooses not to prosecute them. And who am I to stand here at this body and say something different, and to say I think that somebody should have been prosecuted, to say, I think there should have been a different outcome, and to prevent that person from having the opportunity to defend themselves in court that they would have. So it's not appropriate for me to do that because of law enforcement and out of respect for law enforcement.
But is it not the Office of the Attorney General's job that if there was an act that the Office of the Attorney General felt was inappropriate, unlawful by the officer, wouldn't it be within their purview to take over that case?
Not at this moment, only if we are given.
You couldn't come in on it as a civil rights issue?
We could not. Not right now, not today.
Okay, thank you.
All right, thank you very much, Ms. Mulhauser. Senator Waldstreicher has a question, then I have one question. Mr. Vice Chair.
Thank you, Mr. Chairman. Ms. Mulhauser, this question is for you. I had a hearing in another committee when Senator James was exploring this issue with the Attorney General, so I thought I would do so with you as well as the chief of the division. So the investigatory power is very different than the prosecutory power, and the values that drive those two things are different as well. When I was at the U.S. Attorney's Office, and I know you were at the same, what was clear to me from my United States Attorney is that the only value that we had was the interest of justice. The investigatory authority is really about what happened. The prosecutorial authority deals less with what happened and more about what can I prove beyond a reasonable doubt to a jury of 12 people? And is that outcome in the interest of justice? And so I want to understand your response to the concern about the firewall of the investigatory authority being under the same umbrella as the prosecutorial authority, where there's a risk at not having that check between two different bodies, between at a U.S. Attorney's Office, the FBI and the AUSA or SAUSA in your case, or at the local level between the police and the prosecutor's office. There is a pause, a check between those where those two values are different. What happened, and based on what happened, what is the next step in the interest of justice? And is there a risk here of momentum overtaking us in a way that that limits that check if they were under the same umbrella?
I really appreciate that question. And I think coming from a U.S. Attorney's Office, you have experience in ways that is not always the case. Let me start by saying, I don't think the values are different. And I don't think that's what you were saying either, right? I think in both cases, the values are to find facts and to do justice. And I think those are similar. But I very much respect your point that those two parts of the process are different. But I think there are times when those two parts are really intertwined. And I think Mr. Drawn could probably talk about this in police prosecution cases, and I could as well, right? Where the potential prosecution is so intertwined with the investigation that prosecutors really are deeply involved at the investigative stage. I think that is true in certain areas of law and in really diverse areas of law. It's true in sex crimes, for instance, that you often have a prosecutor really involved from the early level, or it's true in organized crime or RICO investigations where they are often attorney involved, or I never liked the phrase attorney-led, attorney involved investigations. And so I would worry that a firewall would mean that you would have some sort of separation that you don't have in reality in these more complex prosecutions. But I do very much respect the need and respect the desire to have those roles separately. And that is why we have an investigative unit within our division that is run by our chief investigator. And they really do run those investigations in consultation with the attorneys and with the involvement of the attorneys. But I'm so respectful of those investigators and their roles.
All right, seeing no further questions, thank you all very much. All right, well, next we'll hear from Mr. Willie Flowers, Mr. Flowers from the NAACP, Nicole Henson from Out for Justice, Joshua Hatch, and Mr. Bob Rudy.
Good afternoon, Mr. Chairman, members of the committee. I'm very proud to be here. I sent in my testimony, and I it's according to what we learned today, I was not correct in explaining that this bill was followed by the death of George Floyd. So I want to apologize for that. And I was happy to hear that Senator Washington had kickstarted this some years ago. And that shows a valuable amount of responsibility. But the most important thing about the bill is that not just your committee, but this country responded to something that we all were heartened by 2 years ago with the death of George Floyd, and before that, Freddie Gray. And what that means to me is that this committee responded strongly and put forth this bill, the initial bill, but what was left out when we received the information about IID report was that there was no power to prosecute. And we think that the community thinks that that power should be given to the Attorney General's office. So, and there was a discussion earlier about the MOU with Howard County and also Montgomery County. And I know there was some banter about that. But the reality is that it is a case consistent with what everyone has said here today, that it's always going to be hard for the Attorney General, State's Attorney's Office to prosecute their friends. And the evidence of that is that there are no prosecutions. Nobody was ever charged. And we think that should be the case. I want to close because I have a limited amount of time, just by saying that the evidence of the negative community outcry to Freddie Gray in 2014 is what will happen if these bills don't change. When State's Attorney Marilyn Mosby made the decision to prosecute, the fire and the explosion in Baltimore City stopped. And if we give the power to the Attorney General from the outside to do it, reduce that type of fire moving forward. Thank you for the opportunity to testify.
Mr. Chairman, members, I'm Bob Rudy. I'm a member of the Executive Council and Board of Directors of Maryland Alliance for Justice Reform. I'm also a resident of Harford County and was formerly Executive Director of Maryland Legal Services Corporation. Maryland Alliance for Justice Reform strongly supports this bill for its practical solution to a serious crisis in public confidence. According to a fairly recent survey, 85% of Marylanders support the concept of an independent prosecutor when police conduct like this is alleged. That's a Gloucester College poll in October 2020. Similar support is shown by national surveys across the United States and across the political spectrum. That's a Cato Institute poll in January 2017. Plato asked about 2,300 years ago, who will police the police? Maryland's version of this problem today is obvious. Under current Maryland law, even though an independent investigations unit may find misconduct, current law still relies on local prosecutors to decide the sufficiency of the evidence, B, whether they should do a prosecution themselves and on what charges, and C, whether to seek outside special prosecutor. However, the local prosecutor themselves are conflicted because they often work with the same police officers. Because the Attorney General's relationship with local prosecutors and local police is limited, this plan should provide sufficient independence for more reliable outcomes. In other jurisdictions around the country, independent civilian oversight has resulted in a 78% increase in findings of misconduct. This bill, as you know, those killed by police in Maryland and across the country are disproportionately people of color. Such cases historically are more likely, like Freddie Gray, George Floyd, Breonna Taylor, and others, are most likely to result in strong public protests. We encourage a favorable report. Thank you.
Good afternoon, Mr. Chair and committee members. My name is Nicole Hanson Mundell. I am the Executive Director of Out for Justice, a grassroots nonprofit organization that represents formerly and currently incarcerated people, in particular, the very population of people we're talking about today. Senator, you asked a really important question. Where's the facts, right? Where are the facts? You're looking at a fact. In 2014, while driving in Baltimore on Bonaparte Avenue, I made a left-hand turn and I was pulled over by a Baltimore City police officer. And this police officer felt the need at a traffic stop when I could have just left there with a ticket. My license was not suspended. Nothing was wrong with my tags. He decided because I had called my husband to make sure that he knew I was getting stopped and I, set the phone on the side. He did not like that. And he told me to get the F off the phone. And I indicated, sir, I don't really feel safe. I'm a Black woman. I'm here with my child. I just have my husband on the line so he can hear what's happening. And that officer decided to drag me out of my car in front of my 8-month-old baby and throw me up against the hood of my trunk in front of ongoing traffic. Nothing happened to him. I went to the investigative arm in Baltimore City that happens to be on Kirk Avenue at that time. Nothing happened. And so I wish that an agency like this, that we had an attorney general's office like this at that time that was willing to step up and investigate that law enforcement officer because of the fact that that particular state's attorney at that time was not willing to investigate that particular police officer. That officer was left for another decade to wreak havoc on Black and brown women in Baltimore City and young men. And so I am the facts that we need an office that is removed from the local state's attorney's office that can give an objective objective analysis about what is happening in local police departments all across Maryland.
Excellent.
In particular
Thank you
places
very-
like Baltimore County, where we
Excellent.
have a
Thank you
state's
very much,
attorney that do
Ms.
not
Hanson.
prosecute law
Ms.
enforcement
Hanson
officers.
Mundell.
Thank you.
Thank you very much.
Any questions?
And we're going to take questions at the end of the panel. So Mr. Hatch will go and then we'll take questions.
Okay.
Mr. Hatch, you're up. Welcome.
Thank you. Can everyone hear me?
We can.
Okay, thank you. So my name is Joshua Hatch, and I'm the chairman for the Public Safety Committee for the Caucus of African American Leaders. I'd like to thank you, Mr. Chairman, and this esteemed body for giving me an opportunity to speak. Should have said that first. Over the past year, I've had the opportunity to go around the state as the chairman of public safety and speak with state's attorneys, as well as police chiefs, to discuss complaints that the caucus have received from residents here in Maryland. There's a common thread, there's a common theme, and that is Marylanders do not feel safe with the very people that are charged with public safety. People have witnessed the horrific tragedies from rogue police officers who decide to do the very things that Ms. Nicole Hansen just said, taking actions above and beyond prescribed measures given to them by the law. This proposed legislation does not inhibit our criminal justice system, but yet it sends a clear message that rogue officers will be held accountable, they will be prosecuted, and they will be prosecuted at the highest levels of government. To restore public confidence, people must have faith in the outcomes of investigations. And allowing the Attorney General to conduct such investigations and to prosecute will restore the faith in our criminal justice system. Attorney Brown has pledged to restore public confidence in the police across the state, and this legislation will give him the tool that his office actually needs.
Excellent. Thank you very much, Mr. Hatch. Now we'll turn to the committee for questions. Senator Folden.
Thank you, Mr. Chair. Ma'am, I just wanted to respond to your statement. Look, I'm sorry for what happened to you as a police officer. That's completely inappropriate. I'm not sure of the exact circumstances of it, but from what you're saying, doesn't sound appropriate at all. I don't condone those type of actions. I never have. I'm not saying there aren't going to be at times bad actors in any profession, let alone law enforcement. So I understand that part, and I am deeply bothered by that you had to go through that as a police officer. But this bill wouldn't change anything, unfortunately, that happened in your situation. Now, you do know that, correct, ma'am? I'm sorry.
I would have to disagree with you about this bill not being able to change the situation, but you can continue.
Okay, so this bill, as I understand it, would be for police involved shootings or use or in custody deaths. Is that correct, Mr. Chair?
So officer involved deaths or injuries likely to cause death.
Yeah. So officer involved deaths or injuries likely to cause death. So I'm hopeful that none of your injuries, if you received any, were to that nature, ma'am. But I do want to say that perhaps as a result of your incidents, that there has been something that come positively out of that, because, you know, I guess last year or the year before, this body passed that officers are now allowed to be recorded while in the public in engaging with the public. So I feel for your situation, and I'm appalled that happened to you, especially in front of your young child. And I'm hopeful that you can at least find some solace in the idea that hopefully that'll never happen again, because now it is written that the citizens are allowed to record their police, and you should have been allowed to have your husband on speakerphone there or whatever listening, because if it's a legal stop, it's a legal stop, and it shouldn't have mattered who was listening. So
Can I respond?
yes, ma'am.
What happened to me could have involved some sort of death, right? The way that he knocked me up against that trunk, anything could have happened. And so I think what I'm certain of is that, one, we have an attorney general's office who is willing to investigate police involved shootings and incidents that could result in death. And I think that's something that you should support and the rest of this committee should support, because things like that happen all the time in Baltimore City and in Baltimore County. And not often do the public have places that they feel they can go to report these type of incidents. And so when you remove the particular jurisdiction out of the equation, like my colleague said, you're offering opportunity for the public to feel safe enough to go and even report the incident. And so I think this is an important bill.
Yeah.
Also, just to clarify,
understand.
sorry, I want to clarify my statement. Also, like with the language, it's also injury if it's referred
Right.
by the state's attorney. So
Yes.
I want to clarify the language.
Thank you.
Injury, so it doesn't have to be life-threatening injury.
No, that's what the discussion with Senator Sidnor was about earlier. We were talking about there's a referral process that's built in. It's an optional thing. And so anything that's not likely to result in death or death, so injury, could
Again,
potentially fall
so-
under that gambit if the state's attorney in the jurisdiction refers.
So we
May
do,
investigate any other crimes related to police misconduct that are discovered during the investigation under item 1 subsection. So this is page 3.
so this bill is a lot broader than what we discussed with the Attorney General initially, was that it was claimed to be that it was for police use of force that involves in may result in death or death. And now we are expanding this, just like we discussed, being worried about that we're now expanding this to include whichever local may be referred. And we're saying that referred, but the way this bill is written and the way I understand it is it wouldn't even have to be referred if the body.
This is already
something
something that the Attorney General's office can, this is
Yes.
from last year's language.
Yes,
just,
ma'am.
just to be clear, right?
So if
It's-
she had made the complaint directly and
consistent.
usurped the state's attorney's local authority, can they still investigate it by this bill?
So
You want me to call up one
I
of the
want to
attorneys
make sure,
to
I want
answer
to make
your
sure,
question?
Ms. Hanson, I got this. So just to
I appreciate your help.
Thanks, Ms.
Thank you.
Hanson. So it's consistent with the Attorney General's testimony and with Ms. Mulhauser's testimony. They were consistent because you brought up the example of these things like that. There are certain incidents which a state's attorney may say, hey, look, this could involve some conflict. I'm going to refer. So the testimony has been consistent, and the language And this testimony now, this colloquy is not more expansive than what was testified to earlier.
But no one once testified. The only thing you're hearing is that it's a use of force that results in serious bodily injury that could result in death or death. So
I know, but the
Ms.
bill is.
Ms. Hanson, Ms.
disagree.
Hanson, please.
Oh.
Thank you.
I disagree with you, Mr. Chairman, in the idea that this bill now, by that slight addition to what we just heard,
Okay.
would allow for someone, if they got, I mean, of what would be considered a relatively minor injury during handcuffing, no result of death, no serious bodily injury, but a result of
So
by handcuffing, a scuff on their wrist, that they could refer this to the Attorney General's office.
So just, I will literally read you from my testimony that I said earlier today. First, it enables the state's attorney to refer a police involved incident resulting in injury to an individual that is not otherwise within the jurisdiction of the division. And then I said, example, injury is not likely to result in death. That's exactly what I read into the record. The Attorney General did the same thing, and Ms. Mulhauser testified and answered questions along the same lines. I do want to move us along.
Okay, thank you.
Thank you very much. All right. We will now move to, I think, is Nancy Soreg here? Welcome.
Chairman Smith and members of the committee, I'm Nancy Soring with the League of Women Voters of Maryland. The League of Voters supports a criminal justice system that's just, effective, equitable, transparent, and that fosters public trust at all stages. I will not read my testimony. I did quote from Senator Frost, just as the chairman of the committee did, so I'm not going to go over that again. And I know many of you wanted to hear about data and what happened to the investigations. And I respect the fact that the Attorney General's mandate was not to make recommendations about prosecution, but to do an investigation and turn over their results. The excellent website that you referred us to showed that 6 cases referred in 2021 where they forwarded the results of their investigation to the state attorney. All state's attorneys declined to prosecute. Of the cases that were referred in 2022, 9 were still ongoing, so the prosecution decision was unavailable. 2 investigations have been completed and referred, but the decision on whether to prosecute has not been made. However, 8 other cases were referred to the state's attorney and all were declined for prosecutions. It's hard to accept that none of the 14 cases referred to the state's attorney merited prosecution. It was not their job to make a recommendation, but they did thorough investigations. I'm not an attorney. I couldn't say either, but something's fishy. We also note that of the 21 witnesses who testified on SB 896 in 2022, which was similar to this bill, all of the 12 unfavorable witnesses were from law enforcement or local state's attorneys. We know that our system for holding police accountable for their actions is not working, and that those who are fighting the reform have been proven to be part of the problem. SB 290 can remedy this situation, and we urge a favorable report. And thank you for the time to share my thoughts.
Excellent. Thank you very much for your testimony. And thank you for hanging in there with us. We have one question from Senator West, and I'm not, you're ready?
Thank you, Mr. Chair. Now I say this as a member of the League of Women Voters. I'm not a woman, but you take men. And I
We
joined the
welcome
league
men.
some years ago. So you said, I wasn't going to say anything, but you read the part of your testimony that I found difficult. Namely, it is hard to accept that, all in capital letters, none of the 14 cases referred to the state's attorney merited prosecution. How many of these 14 cases does the League of Women Voters believe merited prosecution?
I said I'm not a lawyer. I don't know that. I didn't say that. I said it's hard to accept. I could not unequivocally say that they merited or didn't merit. I just said it's difficult to believe that 14 cases of severe bodily damage or death, none of those were, that's all I'm saying. It's up to you. If you want to, you're a lawyer, you can read the cases and make your own decision.
But you're
I'm not gonna
speaking
go
for the state League of Women Voters of Maryland. I find it pretty incredible that the League of Women Voters is stating to this committee on camera in the General Assembly of Maryland that you believe that it's hard to accept that none of the 14 cases merited prosecution. Suppose none of them merited prosecution.
So
why would the League of Women Voters be arguing that some should have been prosecuted?
What I also said is that the League of Women Voters supports a criminal justice system that fosters public trust. And I am here to say that I don't believe that the way these have been handled is fostering public trust. It certainly didn't foster my trust when I read that not a single one of those cases.
Would you have been
investigated.
happier if 5 of the policemen had been tried and found innocent at the end of their trials? Would that have made you happier?
I believe that the Attorney General believes that if he had, that if their office had this power, that probably that more cases would be prosecuted. They can't say that.
Well, they didn't say that. The
Right,
simple
because they
answer is
can't,
they didn't
because
say that.
They can't because that's not their mission. And they also, he said that he promised the state's attorneys he wouldn't go there. I'm going there because I think it's important for the public to know.
Thank you for your testimony.
All right, thank you, Senator West. Mr. Kemmer, I had you signed up. Did you? Okay, you got it. Just want to make sure. All right, then we have two more people that are participating virtually. Are they ready to go? Let's see. Okay. You're up, Mr. Viega.
Okay, thanks. I am Dr. Robert Vega, a 45+ year resident of Silver Spring in District 20, testifying as co-chair of the Silver Spring Justice Coalition, in support of SB 290 with amendments. The coalition is committed to eliminating harm caused by police and empowering those communities most affected by policing. In furtherance of this goal, we support giving the Attorney General's Independent Investigations Division the authority to prosecute police-involved killings and injuries likely to result in death. Our current system of accountability for police violence, particularly violence against Black men, is not working and requires a structural change. Police violence is rarely prosecuted. The Mapping Police Violence Project reports that less than 2% of all police killings from 2013 to 20 resulted in prosecutions. In Montgomery County, police killed 10 people in the past 5 years, overwhelming majority Black men, with 0% resulting in any prosecution, principally under the MOA with Howard County. The only prosecution we've had was an officer from a law enforcement agency outside of the county who killed 2 people when he was off duty and acting in a private capacity. Since the formation of the IID in 2021, unfortunately, nothing has changed. Of the 29 police-involved killings that IID has investigated and sent to the local state attorneys, not a single one has resulted in a prosecution by such, 0% in other words. Not surprisingly, over 60% of these police killings have been of Black persons who make up only 30% of the population. While we have no illusions that the IID power to prosecute police will suddenly reverse our shameful history, we believe that an independent office whose sole job is to investigate and prosecute these cases would be more likely to bend the arc of moral justice towards for our communities. But we believe that an amendment to allow local state attorneys to allow prosecution of a case if IID decides not to. And we ask the sponsor to amend this bill to add this critical backstop. It's an essential that every option remain available to the community to make it whole. This is a fundamental matter of racial equity and public safety. Thank you for your time.
Thank you very much. All right, now we'll hear from Mr. McKesson. DeRay, what's going on? You're up. Good to see you.
Hey, hi everybody. It's an honor to be here. I'm DeRay. I lead Campaign Zero, a group that is focused on ending police violence and mass incarceration. I just want to voice my support for this bill. So the previous legislation that allowed the Maryland Attorney General to review and report out instances of police killing was a good first step. This will be the next logical step to make sure that they can actually do some sort of enforcement to hold officers accountable. We think that the Attorney General is uniquely qualified to take action on these issues, bypassing the natural conflict of interest inherent with the local prosecutors and their traditional partners, the local police. Specifically, they have a holistic understanding and view of what's happening, not just in one locale, but across the state. They can help ensure that accountability is applied consistently, regardless of the jurisdiction, and they're free from local political pressures that often plague local elected officials. I'm proud of the work that this legislature did a couple years ago with regard to police reform. And like I said, I think this is the next logical step. And shout out to the Attorney General for supporting this legislation. I know that some of the local state's attorneys have been against this. And I would say that I don't think about this as taking away their power so much as ensuring that every community, regardless of the local jurisdiction, has fair processes and that the law is applied justly to the police as well to other citizens. So I'll just end there and again support this bill wholeheartedly. Excited to see this come up as the next step in what was passed previously.
Excellent. Thank you, Mr. Viega and Mr. McKesson. We'll now hear from Ashley Devon Johnson. Is Ashley Devon Johnson there? Okay, so Ashley's not there. All right, and with that, that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and we'll start off with let's do Mr. Gibson. Is Mr. Kroll here? Steve Kroll? Mr. Schellenberger? Scott Schellenberger? No, Mr. Bates. Are there any other state's attorneys in the room that I've missed?
Bill Meyer.
Okay. All right, you'll be in the next panel. We'll get you. All right. Mr. Gibson, if you'd like to start, thanks.
Thank you very much. Good afternoon. My name is Rich Gibson. Thank you for the opportunity to speak with the Judicial Committee today. My name is Rich Gibson, State's Attorney for Howard County and President of Maryland State's Attorney Association. I've been a prosecutor for 19 years in multiple jurisdictions throughout the state. And we took a vote as a body, and 23 of the 24 state's attorneys voted to oppose this bill for several reasons. One thing that's been said a lot about is about the public trust. I'd like to point out that we have recently been elected and we have the public trust. We have the public confidence, and it's evidenced by the fact that we're here and in these positions. Secondly, there's an unsubstantiated assumption that we will not prosecute police officers. I can tell you that my first term, my office prosecuted a police officer who pointed a gun at a bunch of kids who were making noise in a pool. Right? We found that objectable. We prosecuted him. We were effective in the prosecution. He's convicted. He's no longer a police officer. And so we have the ability to prosecute these cases. The other issue relates to the dilution of the public's voice. We are directly elected by the communities we serve. They have access to us and ability to address us and concerns with us. And every 4 years, they can vote us out. With the Attorney General as a statewide entity, they don't have the same control or access or ability to affect change if they don't agree with the way in which they're enacting justice. I happen to have a great deal of respect for our Attorney General, Anthony Brown. I think he's phenomenal. And I think that I do trust him. However, this will be given to the Attorney General as a position. There will be other Attorney Generals other than Anthony Brown that will have this power. And I don't know how they will wield it. And the community will not have the ability to affect change if they disagree with the way that individual wields it. Finally, related to expertise, prosecuting these cases relates to understanding of what beyond reasonable doubt means in the given jurisdiction you're in. And beyond reasonable doubt, although it's a standard that applies across the nation, in fact, looks and is different in each jurisdiction. Having that local knowledge of what this jury pool looks like and feels would meet that burden is essential. And they don't have that granular knowledge at the Attorney General's office. And one final point, which is the skill set required to try these cases. It's not just any attorney that can do it. It requires a great deal of experience and skill to handle these matters. And where would the Attorney General get the resources to handle these cases? But from the local offices where we have developed internally those skilled attorneys. If they leave our offices and go to work in the Attorney General's office, one, you depleted the ability to actually handle cases at the local level, at the highest level with highly skilled people. And two, the same bias that existed in our state's attorney's office isn't magically removed when they enter the Attorney General's office. And so for the aforementioned reasons, I would ask you to give this bill an unfavorable review. I welcome any questions and thank you for your time.
So just one just housekeeping note. Usually don't time elected officials, but because nearly all of you are here today, I'm just going to afford just for balance. Our Attorney General was not timed, and so Mr. Gibson, you were not timed because you're the chair of the State's Attorneys Association. But we're going to adhere to 2 minutes for the rest of.
Yeah, I tried to go as fast as I could.
No, I hear you. I just want to make sure that on balance we give everyone equal time. And I see some stern faces looking up at me, but we'd be here forever. So
Appreciate it.
I
Thank
don't
you.
get an hour and 20.
Yeah. And I forgot to ask Ms. Mulhauser that question about the expertise, but I'll get it in writing and make sure the members have it. But all right, whoever's next.
Good afternoon, Chairman Smith and members of the committee. My name is Ivan Bates. I'm State's Attorney for Baltimore City. I probably have more experience than anybody in this room prosecuting, dealing with these types of matters involving police. I was involved with Freddie Gray and I saw what not understanding the law will do to a jurisdiction. I also played a major role in helping the gun trace task force be brought down. Books, movies, everything is there. So I understand truly what is needed with these cases. There's a level of expertise that is needed. And as Mr. Gibson talked about, that will tear apart what we're doing in Baltimore City. When I looked around first time with the bill, and a number of the things that the Attorney General's office has also received in terms of prosecution power, took 20 prosecutors out of the State's Attorney's Office of Baltimore City. Right now, if you took 20 prosecutors from us, public safety would fail in Baltimore City. So expanding this bill and other bills hurts Baltimore City and the citizens. We also have to look at it from a standpoint of, we are already doing that. We know the law. There's a level of expertise when you do these cases that is at a point that you do not necessarily understand. I've received a lot of heat and brushback for Donnell Rochester. However, when I looked at that report, one of the things I saw was the Attorney General's office didn't, as I saw, they didn't do the analysis. They didn't talk about a number of defenses. They didn't even list the individual's criminal background and history because that lists defenses that are there. And that's important. Now, what I do understand is this. Something needs to be done, and we are doing it. Baltimore City's on a consent decree, and I have seen more and more citizens when I go around are happy about what's going on. We will prosecute the police, and we will hold them accountable. I still have a PIU, a police investigation unit. Right now, it's 6 positions. We only have 3. The other night, there was a police-involved car chase, allegedly, and they called the Attorney General's office. They said they weren't going. My office went. Based on that information, they turned it over to the Attorney General's office. Now they have decided to investigate that. We work collaboratively with the Attorney General's office. We will continue to do that. We're elected locally, and we ask to continue to be able to do that job. Thank you.
Good afternoon. Normally, judges don't have a time limit, but I'll do the best I can. I'm retired now. After 40 years of service, I'm going to summarize in brief. You have my testimony. It's important that I get you to understand that although Mr. Bates may be the one that's most qualified and background in terms of prosecuting cases involving police, I'm both able to talk about prosecution and sitting as a judge. I was in the Attorney General's office for the state of Maryland. I believe that expanding the role of the Maryland Attorney General in this purely investigative role is one thing, but to a prosecutor role, that's primarily what you'd be doing in criminal cases is a mistake. If this bill is passed, it will place charging decision and the prosecution of certain very crucial cases in untrained hands. And I'm saying untrained hands, not because they're not the best in the civil department, not because they're not the best in criminal appeals and other complex cases that extend across the state of Maryland. They are like the giant law firm, civil law firm for the state of Maryland. But you have an abundance of experienced prosecutors in jurisdictions around the state whose sole responsibility is to do criminal litigation. And they don't start in the homicide unit. They start in units less than that, where that experience is not required. Day in and day out, they learn to judge the credibility of witnesses, and that includes the police officers. You think that there haven't been cases in the state of Maryland against police officers? In Baltimore City, I know there were, because I tried those cases, criminal cases, where a variety of different state's attorneys, from Pat Jessamy to Marilyn Mosby, charged defendants who were police officers for criminal conduct. It doesn't only mean that it's important for homicide cases and death cases. It is important to the citizens of those jurisdictions for any interactions that they have with the police, that the state's attorney be trusted and able to prosecute those cases.
and when.
Ma'am, might we have your name for the record? I'm sorry.
And for the record,
Yes.
my name is Judge Wanda Keys
There you go.
Hurd. I'm a retired circuit court judge, formerly the chief judge in the 8th Judicial Circuit of Maryland.
Thank you, Judge.
Okay, Scott Schellenberger, State's Attorney for Baltimore County. I was in the room 3 years ago when we all made this decision. And I think I'm the only one up here who was in this room. We all sat in this room, we all sat in the back, and we made a conscious decision to write this law the way it is. The AG's office had an independent unit, but then it would go back to the state's attorney who had jurisdiction over the case. And the reason we made that decision was because I looked at all of you and I said, this is why I'm elected. And if I make wrong decisions, I will not be elected. Now, I can tell you that in the last 10 years, in Baltimore County alone, we have prosecuted 19 police officers for various crimes, including a recent one who didn't get very much jail time, and I was complaining about it for having committed a sexual offense. But even though I'm not the smartest guy in the room, I can count. And what I would suggest, Mr. Chairman, is this. There was a third option on the table when we had this bill several years ago. And that third option was that the independent investigation unit would investigate. It would then give the case to the state's attorney, the local state's attorney, to make the decision. If they decided not to go forward, it would give the Attorney General's office the option to go forward with the case. I think that's perhaps a middle ground. I don't think we should do this at all. And my friend Rich Gibson just groaned when I said that. I can count, Rich. And because of that, I think that there could be a third option between having us completely decide and completely taking away. There can be a middle ground that we discussed, and I'm more than happy to talk to all of you about it. I don't think we should do this at all. But if you are going to do it, this is why we all get elected, to make these decisions. And if we make them wrong, we're gone. So we would ask you to, I say it's unfavorable, but if you want to talk, I'm happy to discuss it.
Always happy to talk. All right. We're going to start off with Senator Folden, then Senator West.
Thank you, Mr. Chair. State Attorney Bates, could you please come to the microphone?
Yes, sir. Senator.
So in regards to, there's been a little bit of discussion about, and I didn't know the exact name at the time, but in the Rochester case with the OAG did, or the IID did their own investigation. I'm curious because the way I look at it, isn't it their report that created the issues, the perceptive issues that you're potentially dealing with? And can you elaborate on that?
Yeah. And if I may, without a doubt, specifically, there was a part in the report that said, in addition to addressing reasonableness, the state must and likely could prove that Officer Murray fired a fatal shot, and that was intentional. Now, remember, the Attorney General's office doesn't make recommendations. However, when you look at their analysis, the reason I say it was wrong, because when you look at these types of cases, what would a reasonable officer do in those shoes? The case law, and this is one of the problems we have, is we really want to focus on these issues, let's focus on the case law. Case law says out of 50 officers, if 49 of them do it one way and one does it another, that separate way, then that's a reasonable officer. So do you understand now some of the difficulties that we're going to have in prosecuting these cases? One of the things also in my particular case, one of the issues you look at is, do you have defense of others? Because we have to look at the defenses of the officers. I know defenses, I was a defense attorney, so I know those really well. One of the things you look at in terms of defenses is what an officer has the opportunity to defend the other officer. Now, from my analysis of looking at the case, you had an individual, from my understanding, that had a prior arrest for carjacking, was sent to juvenile court, cut off his ankle bracelet. And then this young individual now has another warrant for the arrest for robbery of both of them are Uber drivers. At this moment in time, the police see a vehicle, they do the LPR license plate reader, they drive up beside this individual, make eye contact, see who this individual is, then this individual flees from them. They don't do a high-speed chase or anything.
That this individual then parks the vehicles, they park the vehicle, he gets out with the young lady sees the police and runs. He runs to the vehicle. The one officer, Murray, is running toward the vehicle. About 20 feet away, this individual hits the gas. Officer Murray is 20 feet. Now remember, in Baltimore County 4 years ago, there was a murder of another officer in a vehicle approaching him as well. That officer fires 3 shots. His partner is over to his right side. He begins to fire as well. Officer Murray jumps and fires one last shot. That shot is 1 in a million shot that unfortunately killed that young man. However, Officer Murray knew that his partner was over to his right. So you have defense of others. But then also you have what the Supreme Court has said, a fleeing felon. And the police are allowed to use that force that is reasonable and necessary because the vehicle is a dangerous, deadly weapon, no dangerous, more deadly than a handgun. And so when you look at that analysis, that's the expertise that I and my office bring. Now, we talked to Ms. Mulhauser. She had never tried a case like this in the state of Maryland. And that is the difference that you get with local jurisdictions that you will not have with the Attorney General's office. But they can get that experience at the expense of our offices, which will only weaken us as we try to do public safety for everyone. So why you always have to make a deal? Maybe what State's Attorney Schellenberger said is maybe the best thing. You give us the opportunity to look at it. If we don't want to prosecute it, we don't have a press conference, we don't talk about it, we can give it to Attorney General's office and Attorney General's office. If they feel they want to prosecute it, they can. But I do believe, understand the nuances of these cases is very difficult. Understanding Maryland law, it's very, very difficult in doing these cases. I've done it for a long time. I've sued a lot of police and been very blessed in doing that process. And what I will say is that, yes, the people want something different, but the people also want the police to be held accountable. So I understand what we're doing, but understanding the laws and how difficult it is, learning the general orders in a way that most people don't know them is part of the confusion and frustration that we have in prosecuting these cases. It's an exact science. And for us, if it was brain surgery, we would be the surgeons. Trust the surgeons to do the job and we'll get it done.
Thank you, Mr. Bates. I just have one more follow-up, and that is, didn't the investigation itself also come, in my opinion, it comes in direct conflict with Graham v. Connor, which says you cannot review an incident, a critical incident like this in 2020 hindsight. Doesn't this report take it literally by a frame, not as fast as the brain can process, because the brain can only process so many thoughts per second, but doesn't this take and almost throw that ruling of Graham v. Connor to the wind and saying, well, this is how it should have been perfectly done, and he should not have fired the 4th shot.
And that is the U.S. Supreme Court, and that is exactly what it does. And the problem that you have with a case like this is that you're doing hindsight's 2020. We'd all want to do everything 2020. Yes. I agree. But that's why we began to look also to see the officer's actions. Young man crashed his vehicle into a pole. Then the officer went over there. He told the young man to get his hands up, got his hands up, went to the ground, put cuffs on him, turned him over, began to see he was injured because the bullet went, I believe, under the armpit, turned him over, immediately began to render medical aid. Look, I was involved in Freddie Gray, and I saw what this does to law enforcement, and I saw what it does to the community. We have to get it right. The last thing we want to do is shut down law enforcement throughout the entire state. The last thing we want to do is make sure this entire state doesn't believe. This is really hard. But once again, it's the level of expertise that you bring to these cases that allow us to make sure we get the job done properly.
Thank you, Mr. Bates. I don't have anything else. Thank you. Thank you, Mr. Chair.
I know, Mr. Bates, your office has been depleted over the course of many years, but I suspect that'll be a priority to refresh and restore and attract and retain top talent. And we're all counting on you to do it. So, all right. Senator West and then Senator Carter.
Thank you, Mr. Chairman. Judge Hurd, could I talk to you for a moment? Could you come up to the podium? You may recall, were you here earlier in the day when I talked to the Attorney General and I read a portion of your written testimony to him in which you said an experienced trial prosecutor knows that in addition to legal knowledge and their trial experience, knowledge of the jurisdiction and its people who serve as jurors is essential to every prosecution. And I got some words, I can't remember the exact words from the Attorney General to the effect of, don't worry, we're going to be able to effectively try these cases in whatever part of the state we have to try them. I mentioned Somerset County as an example. So the Office of the Attorney General goes down to Somerset County to try a Somerset County police officer and try to convict the police officer in front of a local judge, local jurors. Now, you with your experience as a prosecutor, can you tell me whether, in your opinion, it would be an intelligent move to have a case in Somerset County tried by an attorney out of the Attorney General's office in Baltimore City with no prior experience in Somerset County?
Well, I would have just first, I'd like to say that it's not just as a prosecutor. As a judge, I sat and watched how difficult it was to pick jurors for certain types of cases in Baltimore City. And in fact, had to have an overcall of additional jurors sent to my courtroom whenever I knew that there was a defendant that was a police officer involved, or if there were some issues about whether there was abuse of authority by the police. It is, as Mr. Bates was trying to explain, it isn't just about the trial itself and the elements and the evidence that you find. You have to find a way, you have to know how to present that case in that jurisdiction in order to get a conviction. You need to know the things to say and what not to say. You need to know how to do that opening statement. You need to know the jurors that the judges that you're arguing those cases in front of and how to get to those. I immediately, Judge Elspeth Bothy came to my head. Some of you may not know who she is, but I tried cases in front of her in Baltimore City as a prosecutor. And I knew I had to step very carefully. I had to figure out a way to get her to listen to me, but I had tried cases in front of her before. And I knew that doing certain things would get her attention. Those are the types of subtle nuances that a statewide prosecutor may not know, not knowing their jurisdiction. In fact, I have a statewide prosecutor here. I was the victim of a crime, and he called me and asked me questions about the process. You know, he's going into Baltimore City to try a case where I was the victim. And what he was trying to do was get the nuances that he didn't know that I knew, because I was a judge in that jurisdiction for 21 years. So it's very important that we not undermine that this is a very intense portion of an analysis that takes place when prosecutors in a jurisdiction decide not only what they're going to charge, how they're going to charge it, what witnesses they're going to call. It's important that they know the community where the particular event occurred. West Baltimore is not South Baltimore. East Baltimore is not downtown by the harbor. You know, when you bring the case, that you are going to have to consider issues that are unrelated to just the facts and just the evidence. And if you don't know that, then you've never served on jury duty, because you've sat in the courtroom and watched people get out of jury duty or try to get out of jury, or you've never had a ticket and gone in front of one judge and then go into a different courtroom in front of another judge, or get a ticket in Baltimore County and then get another ticket on the Eastern Shore. We can pretend that everything is the same, like milk, but it's not, because sometimes it's sour and sometimes it's 2% and sometimes it's whole milk. It's not all the same. And so if you want to know how to do those kind of cases, you've got to go to the jurisdiction, and those are the people that you need to trust. And now, last but not least, that's the whole fundamental thing we're all talking about, aren't we? We're talking about trust. How do we tell the citizens they should trust the people they elected, but yet we don't, as the legislature, trust them, and we take the case and send it somewhere else? Aren't we saying that only in death cases we're going to take that seriously? Well, what about the rape cases where the defendant is the police officer? What about the assault cases where the defendant is a police officer? I had a case in my courtroom. A police officer spat on a citizen. Is that not serious? It was prosecuted. The state's attorneys in Baltimore City prosecuted him, and I sent him to jail. What about another case I had where a police officer shot a citizen in front of two other police, an unarmed person who was already on the ground and ready to go in custody, and he shot him. State's attorney's office prosecuted that man, and I sent him to jail. Don't tell me we don't have the capacity. We do have the capacity, but we need to use our capacity to ensure our citizens that the people they have elected to prosecute the criminal cases in their jurisdiction are the ones we're going to trust. And if we're not going to trust them, that you were elected by your citizens to ensure that the laws are on the books, but those that took the oath to defend them and to protect them
Thank you.
are also trustworthy.
Thank you very much for your testimony.
And I apologize for my lengthy answer.
That's okay. It was a good answer. Also, I just wanted to thank you for your years of service on the board of the Baltimore Library, Bar Library. Thank you much.
Thank you, Senator Westwell. Judge Hurd, you just took us to church. That was good. I really appreciate that. And it was good to hear from you. And I'm not sure I quite agree with everything, but I really do appreciate it. I'd love to sit down with you on this and some other things. I see these other guys all the time, so I'd love to grab coffee with you at some point. There you go. Granddaughters first. But I do have one question just with the statewide and the local expertise question. So I brought this up a little bit earlier about the one, we have kind of a template, which is the Office of State Prosecutor.
Right.
And the office, I was looking at it. So they can prosecutor may investigate, so a criminal offense under the state election law, criminal offense under the state public ethics law, violation of state bribery, basically public corruption, misconduct in office, all the above. And so they go into all 24 jurisdictions and do this. And so I wonder, what's the distinction? I mean, are they not doing a good job? Are they not capable of doing this job?
Well, I think the prosecutor had my case, did a good job. It was a referral from the state's attorney's office. And I liked actually Mr. Schellenberg's suggestion that I think that the attorney general can do that investigation thoroughly and completely. I like the standards that are laid out as to how open and transparent their process is. I think that's an excellent way to ensure that those investigations are done. But I don't think we would be here having this objection if it stopped at the collection of information and the investigation. Because as you see in my statement that I submitted, I think that what's happening is there's a motion to usurp the role and the responsibility of the state's attorney and begin doing prosecutions. And I don't agree that it's going to stop here. Because so when are you going to decide what's more serious? When you have police officers that are corrupt and taking money and fraud is going on rampant, and you're going to tell me that the attorney general's office is not going to be interested in that? I tell you what, the U.S. Attorney's Office, they have a separate division at DOJ that does civil rights cases and fraud cases. There's nothing wrong with having a separate division of your Attorney General's office that does that. But the primary responsibility of prosecution is with the U.S. Attorney in the jurisdiction that is outlined. And that is what I think what the State's Attorney's Office, let us do our job. Let us earn the trust of the community that elected us, just like you have earned the trust of the citizens that elected you to come in here and make laws. That's all they're asking. Let us do our job. And if we're not doing our job, then I guess the Maryland Attorney General and the U.S. Attorney can come take a look. But and we all know how that goes, right? But it's not about a singular attempt to say that I, as a prosecutor, can't go to another jurisdiction. I shouldn't. The prosecutor of that jurisdiction should be handling it if it's appropriate. And if it's not, then it's not. But you can't sit Monday morning and tell me, oh, we did a report, and on seconds, I'll just tell you my opinion, legally, my opinion, and I'm now retired, so I can say what I want to say. That was a textbook stop by Murray and Mari. They did everything right. If I could write out what they should have done, They did every single thing. They pulled alongside that vehicle and double checked to make sure that the driver was in fact a person wanted on the warrants. They got them away from Hillen and Harford Road. By the way, I know about that because I live in the city and I serve the citizens of Baltimore City in the city. And the mistake would have been to go out on Harford Road or Hillen because there are too many places that that vehicle could go. But they followed him onto a small street where they could corner him. And they did. And in the facts, by the way, he got out of the vehicle and so did the woman and started to go away. But when he saw the backup that the officers had called, which they should have done, he got back in the car and took off. Shades of what happened to the officer in Baltimore County who got run over and then backed over. That car became a deadly weapon. And so now you have a fleeing felon, as Mr. Bates has said, 2 warrants. I know, I'm going to tell you, the bottom line is 2 warrants, and they now tell him, get out of the car. He refuses. 20 feet. We learn that 20 feet can be crossed by a human being fast. A vehicle, even faster. He shoots 3. And as he goes down, and we don't really know whether he was hit or he fell, but the bottom line is he sees his partner in danger, defense of others. And he fires. And the officer who might have gotten hit, he misses because he hits a bumper and the hood of a car. Now, they do everything right when he gets out of the car. They give him first aid. They cut him up, his clothes off of him. What else would you have the officers do? I'm telling you, on a motion for judgment of acquittal at the end of the state's case, I would have dismissed it if they had charged it. And
You
that's
are
what
a
I'm saying.
great raconteur, that's for sure. Yeah, this is so I appreciate the testimony, and we'll continue the dialogue. Additional questions, Senator Sidnor, then Senator Carter. All right. All right, do you want to go first, Senator Carter? I'm sorry, Senator Carter first.
For today, you may be hoping that she takes me on, I'm not sure. But basically, you know, in just listening to all of the testimony, first of all, we can all present specific facts in order to the side of the argument that we'd like to present. There's usually the state side, the other side, and then something in the middle. I can't sit here and say I know all of the facts of that particular case, but I do know that what was presented in the AG's opinion, some of it slightly differs from what was just presented. I don't know. But my real question, I suppose it could be for anyone, but I guess I'll direct it to you, State's Attorney Bates. And earlier today, another senator brought up Graham versus Connor. What strikes me is that in 2021, when we did pass the Police Accountability Act, we updated our specific Maryland use of force law, and we were specific about when we expect use of force to be used. We also created new crimes for the failure to intervene, the failure to report. And so again, based on the facts as just presented by Judge Hurd, it's different than what the facts presented by the AG. But one of the things that struck me, and first of all, I believe Donna Rochester was killed prior to the effective date of the law, which I think was July 2022. But my question is, in the future, would the analysis necessarily stop at whether I can charge or approve this homicide, or might it also extend to the new law as we've taken in effect? Because perhaps you might not feel you can prove a homicide, but there may be a violation of the law. And as the Attorney General said, there was definitely, according to the Attorney General in that case, a violation of the standard of training. So I guess that's my question. Like, we did create, in our wisdom in creating the new law on use of force, we knew that sometimes state's attorneys, historically, not all, but some, had been reluctant to charge homicides for officers killing civilians. But we felt that this was another way to ensure accountability, even where that can't be done.
Well, I think we'd have, definitely with Rochester, you did not have the time, the law hadn't wasn't there. And so what it basically says is if you violate a general order, it's not violating the law. You can't charge. We definitely would look at the analysis in a different light. However, I think the problem that we have is, okay, let's say we charge, but then the case law from the US Supreme Court says something totally different. I'm bound by the case law from the US Supreme Court. And so I think part of the problem is so confusing to everybody. And this is what I tried to really get to the point. If you really, let's look at the law itself, looking at the law and then understanding how frustrating it is from our point of view, because sometimes you do want to say, you know, I feel like it should be charged because that's what your gut says being a person when you see something. However, once you look at the law, the case law, then you realize how many prosecutors, our hands are quote unquote tied behind our back because we have to follow the law. That was the oath we had. Look, I hate to bring it up, Freddie Gray, a perfect example. I was on the side, but I understood what the law was, and that's before it even happened. I said, this is the law, and this is what is going to happen. At the end of the day, it went before the court. People are frustrated, people are angry, but the judge had to follow the law. And we as prosecutors have to follow the law. Even Attorney General's office, they're going to have to follow the law. It's easy to be Monday morning quarterback and say we should have, could have, would have done that until you stand in the hot seat. When you stand there looking at a jury and you have the people upset because they're protesting because they want you to do A, B, C, and D, but those are the people that don't elect you. So it's easy to sit down and be Monday morning quarterback, but when you're sitting there in the hot seat, it's hard to do the right thing. It's very, very difficult. But we took an oath as prosecutors to follow the law and do the right thing. I don't always agree with the law. I don't make the law. You guys make the laws, but I still will have to follow it. I would do that analysis, and I'd also have to look at the law.
State's Attorney Bates, thank you. One quick other question, and you don't have to necessarily give me an answer because it's really just it's not a rhetorical question. It's actually a pragmatic question. But I've heard a lot of testimony today from everyone, and especially Judge Hurd saying, oh, I would have ruled for a motion for judgment of acquittal. But it's not my experience that when state's attorneys in all other cases make a decision of what to charge and whether to charge, that they anticipate the globalness of the entire case, including all potential defenses. Generally, in my experience, charges are brought, and then as they go down the line, they make a decision whether to add to the charges, detract from the charges, whether or not to move forward with certain things, but not in any situation that I've seen, unless you're going to be, this is a philosophy you have, to anticipate the entirety of the case and what potential defenses there might be before you even decide to charge. My question is, we're not talking about whether you're going to get a guilty or not guilty. We're talking about the very outside of a case here.
Well, we have to look at it from an ethical point of view to see whether or not we can proceed. So the state's attorney, I must look at those potential defenses. And specifically when you look at the police and police cases, they're totally different than anything else. And this one I'm really trying to get across is that you have to look at what a reasonable officer would do in that situation. And if that reasonable officer does what they're supposed to do in that situation, it may be ugly. But if that's what the law says, then no, you cannot charge in that regard. You know, one of the things also, I think, look, you got to make hard decisions in this position. You know, look, I got rid of Keith Davis Jr. A lot of people are very angry, but I also understood to me what my job as a state's attorney was to do and look at it. Every case we look at in a holistic point of view. We have to look at everything that we do with a particular case.
Thank you. I'm glad you brought that up. I'll be bringing that up in my later testimony on my bill later. Appreciate that.
Thank you, Senator, from my city.
Thank you. And good afternoon, everyone. I've been taking as much in as I can, and as you all were testifying, I'm looking at Article 5 of the Constitution, which talks about the authority of both attorney generals and prosecutors. So in Section 3A2, it says the attorney general shall investigate, commence, and prosecute or defend any civil or criminal suit or action or category of such suits or actions in any of the federal courts or in the court of this state or before administrative agencies and quasi-legislative bodies on the part of the state or in the state or in which the state may be interested, which the General Assembly by law or joint resolution or the governor shall have directed or shall direct to be investigated, commenced, and prosecuted or defended. that's our Attorney General's constitutional duty. Later on in section 9, it says the state's attorney shall perform such duties and receive such salary as shall be prescribed by the General Assembly. So I'm seeing a much broader swath, and it specifically talks about criminal prosecution by our Attorney General. So from section 9, I go to our code book, and under 15-102, it says, subject to Title 14 of this article, a state's attorney shall, in the county served by the state's attorney, prosecute and defend on the part of the state all cases in which the state may be interested. So that subject to Title 14 is in essence carving out a portion of the law where we talk about the Office of State Prosecutors, where our chairman kind of talked about earlier. And under section 14-107, it lists about 5 different areas where the Office of State Prosecutors has authority that you all don't have. Laying that all out, I'm trying to understand why you all feel that this is so different than the carve out here with the Office of State Prosecutors Office. I mean, why should this minute portion, I mean, I think earlier it was testified there were maybe 16 cases across the state. Why are you all getting so up in arms about this is what I'm curious about. And so I'm gonna give a little in section, and later on today I have a Senate Bill 295 where I'm trying to give you authority and you all are fighting that. But here you're fighting authority that you all have characterized as us trying to take from you.
Yes. So the distinction, Senator Sidnor, the distinction is as follows. So historically speaking, criminal prosecutions have been handled at the local level by state's attorneys. The Attorney General handles mostly civil, and they still do handle mostly civil matters overwhelmingly. There are some areas, historically, actually, the Attorney General would handle cases that crossed over jurisdictions. So if a crime happened, they say there was a string of I don't know, home invasions that occurred in Howard County and Baltimore County, right? And we wanted to build a collective case encapsulating both. We might enlist the help of the Attorney General's office in that matter because it doesn't fall uniquely within my jurisdiction or within Scott's. And so that's a key distinction. This is an incident that happens wholly within one jurisdiction, right? That is of unique local importance because, of course, public safety is going to be impacted, and the perception of fairness for the police and the perception of fairness for the community is at stake. And our communities have direct say in our approaches to these issues, how we handle them, how we effectuate our policies, how we prosecute them. All of it is uniquely important to the community in which the incident occurs. And our communities have the ability to say, as a whole, if enough of them are impacted, we disagree with the way you've handled this, and we want someone new to take that seat and handle it, or we approve the way you've enacted the laws, we approve the way you've handled it, and we support you going further in this role. With the Attorney General, there's a dilution of that voice, of that vote. There's a dilution of the accessibility by the local community that's impacted, and there's a dilution of the ability to seek redress. Montgomery County is the most populous jurisdiction in the state, 1.2 million people thereabouts. And if the community of Montgomery County was outraged with the way the Attorney General handled the case, and they were absolutely furious about it. There's 6 million people in the state of Maryland, and if the other communities did not share their concern, they would have no way of seeking redress. Whereas with us, every 4 years, the local community can say, we're done with the way you've done things, we want someone new. And so part of it is about giving the community who put their faith in us, who trust us and voted for us, as they voted for all of you, the ability to retain control over these local instances that involve the loss of life.
To be clear, they also voted for the Attorney General.
They did.
And so I'm curious. So I'm a resident of Baltimore County. my vote and most of my family's vote can only impact one state's attorney, and that's Mr. Schellenberger. So let's say I go to some other county and I'm involved in one of these situations. That county isn't necessarily affected. My people in Baltimore County and my family is the one that's affected. And I raise that because we're a transient type of a state. So I mean,
So
why not have the Attorney General who has that larger view deal with it?
So a few things. One, if you happen to be in my community, Howard County, and you were harmed, right? Even though you're not a resident of Howard County, the intersection of your activity and the police encounter happened in our jurisdiction. And regardless of whether you live in Howard County or not, my community is going to be very involved in the police officers that were local that interacted with you. The community is going to be very, very involved with that. The local police force is going to be involved with that. And so just because you're not a resident of the community doesn't mean that we disregard the harm that happens to you in our unique space. And again, yes, Attorney General Brown was elected by the entire state against 6 million voters. One voice or 100 voices or 1,000 voices among 6 million is very different than 100 voices or 1,000 voices among 300,000, which is roughly the population of Howard County. So the ability for the community to impact the change as it relates to the issue that directly impacts their space is being diluted when you give that authority to a state at a state level versus a local level.
Thank you.
Thank you, Mr. Chair. Judge Hurd, can I ask you to come back up, ma'am, please? I too want to thank you for all your years of service on the bench. I am in awe of your wisdom and the way that you're able to very well articulate. And it's obviously you've earned that seat and that position very well and deservingly so. So I appreciate your insight and candor. I do want to point, you read the report, I guess, that the AG put out about.
I read all of them, actually.
Okay.
Thanks to Mr. Bates, I actually got their reports as well as the AG's reports. And I tabbed them, I read them thoroughly. And then I looked at them globally. I wasn't looking at what their opinions were as much as the facts, the photographs, the police reports, the ballistic reports, all of it.
Well, let me ask you this, because I can't seem to get an answer anywhere else. Being that you have 40 years of law experience, was there any that you thought that should have been addressed or that could have been criminally prosecuted or should have been criminally prosecuted?
As I sat down before, I said no. And so what would be my role? Mr. Bates comes in and let's say he charges the officers and he prosecutes it himself.
Right.
The end of the state's case, there's something called a motion for judgment of acquittal. What it means is, considering everything I've heard in the light most favorable to the state, is there enough to meet the elements of the crimes charged? Okay, based on what the Attorney General's talking about, I'm not talking about civil rights violations, because civil rights violations are a preponderance of an evidence. That's a slight tipping of the scales. That's all you need.
Correct.
In civil rights and civil litigation. But in criminal litigation, before it even gets to the jury, the judge has to decide, did they make their little burden on the crimes charged?
Sure.
If not, my job as a judge is to dismiss those counts. So let's say I say, okay, no, I'll let you go further. I'm going to deny the motion for judgment of acquittal. Defense gets up. That's what Mr. Bates was talking about. The defense of others. They present their evidence. Now, the defense is now making the motion again. Only the burden is different.
Right.
And this case in my courtroom, with what I read, would never get to the jury. Because at the moment they made those arguments, I would have granted the motion. And I think that's what Mr. Bates was saying about Freddie Gray. It's difficult for lay people to sometimes get it. It's a terrible set of facts. A man died, but that does not always mean that there was a crime that occurred. That goes to the trier of fact where the burden has to now be beyond a reasonable doubt.
Yes, ma'am.
And that's what I was trying to say as I sat down before. And Mr. Bates is right. It's hard.
Right.
And it's not only hard on the prosecutors. I know it was hard on Judge Williams. But we take oaths.
Right.
We take oaths to follow the law, the Constitution of the United States, the case law, as Mr. Bates again pointed out. You don't just get to do what's in your heart.
Right.
What feels good.
Right.
What might make someone happy. We take that oath. Y'all don't pay us a lot.
I just want to make, thank
So
you.
we're not in it for the money.
So
I'm sorry.
No, we're good. We're good. If we could just make our answers a little bit more succinct, because we are on bill number 1 of 11.
I'm sorry.
So
So
let me just follow
You all
up
get
with
to go
this,
home, but
Your
we have to
Honor.
be here, all right? So.
Let me ask you this. So there was a comment made by another senator that there seemed to be some reference in this report about that there was acts contrary to police training and standards. In your opinion, or actually in your experience, because you have pretty vast experience in dealing with police related brutality matters and the such, was there anything in that report that made such an inference that there was some type of police training and standards violation by the officers?
Well,
And if there was, is that part of the problem that having this investigative body already has created and presents itself?
I think that the Maryland Attorney General's report was thorough. Where I have a problem is where they reach conclusions.
Correct.
And I'm not only talking about the conclusions that they make criminally, but the conclusions they make civilly.
Correct.
If they're going to prosecute civil rights claims, then they need to have their discussion about how those facts that they have accumulated could give rise to a civil rights case.
Correct.
And if they think it should go to the Department of Justice, a U.S. Attorney's Office for a prosecution there, then so be it. But where it relates to the conclusion as to whether or not and what to prosecute criminally, if you're going to do the investigation, turn it over to the state's attorney's office and let them make those conclusions.
Very good.
Because I have sat as a judge in civil cases where there were injuries
Yes.
by officers, different standards, deadly force experts came in and testified. You had the battle of the experts,
Right.
but that was a civil case.
Yes, ma'am.
And I've done criminal cases. So the answer to your question is no conclusion. If you want to let them do this, let them do their investigation. It was an excellent investigation.
Sure.
So, thank you very much.
But then
So,
stop there.
Thank you.
in the military, we have a phrase called bluff, bottom line up front. So let's try to get the bottom line up front answers as we move on, because we got a lot of people coming up.
I apologize.
No,
Thank you.
No worries, Judge. Thank you. All right, let us continue on. Thank you for the panelists. Thank you all. This is high level. Really appreciate it, the dialogue. Thank you. All right, anyone else that I missed? The state's attorneys, come on up. Whomever would like to go. Hey.
Mr. Chairman. Good to be before you. I'm Haven Shoemaker. I am the state's attorney for Carroll County, and I won't rehash what I submitted to you all in the form of my written testimony, but I do want to highlight a couple of points. As many of you will recall, up until about 6 weeks ago, when I became state's attorney, I served 2 terms across the street over in the House. And generally speaking, I have to tell you, when I saw a bill come before us that had pretty much uniform opposition from the elected officials that the bill would impact, and that opposition was across party lines, it served as a red flag for me. And that's what we have here, Mr. Chairman, with regard to Senate Bill 290. You know, each of the 24 state's attorneys in Maryland has a constituency. In Carroll County, I'm responsible to the 173,000 folks I serve for the way in which I exercise my prosecutorial discretion. And each of us is accountable for the way in which we exercise that authority. Anecdotally, I can tell you that two previous state's attorneys in my county have been voted out of office in the last 20+ years because of the way in which they did their jobs or didn't do it. And that's the way it ought to be. You know, one size fits all approach by vesting prosecutorial decisions in the Attorney General was certainly not a good idea, seems to fly in the face of Maryland's delineation of powers between the statewide elected Attorney General and the locally elected state's attorneys. And respectfully, I would request an unfavorable report. Thank you very much, Mr. Chairman.
Mr. Chairman, Mr. Vice Chair, members of this committee, good afternoon, almost good evening. I am James Delmeyer from Cecil County. Here to ask you to report unfavorable on legislation SB 290. Trying to whittle these arguments down since you've heard duplicitous testimony, I believe. I'm going to approach this from two perspectives. One, philosophically, the fundamental idea behind this bill is a flawed one. It is violative of a separation of the way this prosecution is structured. Police agencies should investigate. They should make those referrals to state's attorneys who are locally elected for an ultimate prosecutorial decision. I support an independent investigative unit. I believe, and I had in place prior to this legislation being passed originally in my county, a system where all of our local law enforcement referred out these types of investigations so they would be independent. So for example, Maryland State Police, some of the same homicide investigators who are now working with the IID would investigate a sheriff's office case, for example. So we had that independence, and I believe in that independence. That serves an important function. That, however, is where it should stop. After the IID does their investigation and completes that report should go to me as the state's attorney. I know my constituency. I have been elected by that constituency to serve them in public safety, and they trust me to do that. A vote in support of this bill is saying that other elected officials, not from my county, don't trust my judgment. And I can say that I very much believe in the importance of a vigorous prosecution when a police officer commits a crime, just like I believe in a vigorous prosecution of all crime that occurs in my jurisdiction. They should not be treated differently, but justice should apply to all equally. And I believe that this legislation gets away from that concept. One final point, Mr. Chairman, is that this is not the solution to the problem you've all identified. I'd suggest an alternative solution in the form of appropriation, which would fund local state's attorneys to have a resource at the state level in a budget so we can make sure we vigorously can prosecute these types of cases, make sure we can hire the experienced prosecutors, and make sure that we maintain the integrity of convictions when police commit crimes. That's the most important thing. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Allison Healy, and I am the Hartford County State's Attorney. First and foremost, I want to apologize for my typo. Mr. Gibson's name, actually, the quote you read earlier was from mine. I was like, I think that's mine. First and foremost, I want to start with that, which is that there is absolutely no facts that are founded that suggest that me or any other of the state's attorneys in this room cannot act without bias when it comes to these cases. I'm not sure that there's a state's attorney in this room who can stand here and say that they have prosecuted law enforcement within their community. I myself have prosecuted law enforcement for domestic violence charges. We have indicted police officers within our office over the years for discharging a firearm in a moving vehicle, many things. So no one in this room is incapable of acting without bias and in determining whether these cases should be charged. Like my colleagues have said, our citizens elected us. We stand before these juries in our courtrooms every day. And I think the point is well founded about knowing the jurors, the courtrooms, the procedures that happen in each jurisdiction. I was in private practice and I can tell you from jurisdiction to jurisdiction, everything is different. And so I can tell you that I can stand and I can imagine Mr. Bates will tell you that what his jurors would do is very different than what my jurors would do and vice versa. So it is very important to have the experienced prosecutors who know their jurisdiction handling these cases. Lastly, I will tell you that, again, the experience of the prosecutors. We all have tried countless homicides, attempted homicides, and we are the experienced prosecutors who know the defenses. And I disagree with the assertion that we don't look at these cases from a holistic standpoint, that we don't think about defenses before we charge them. We absolutely do. We have to look at that to determine whether we ethically can prove these cases beyond a reasonable doubt. That is our job when we consider whether to charge a case. Stop there. So I urge you to a favorable report for SB 290. Thank you.
Good afternoon. I'm Jamie Dykes. I'm the elected state's attorney in Wycomico County. I'm a member of the MSAA and I urge your unfavorable report. For those who have never prosecuted, it sounds like Vice Chair Waldstreicher is an exception here. It is difficult to elucidate our responsibility, our obligations. Our motivation is justice and justice alone. We sit with victims, their families, and on occasion defendants. From that perspective, we clearly see how the work we do impacts them and our communities generally, all the residents of our communities. Most of the work I have done in my 16 years as a prosecutor has been fighting the abuse of power, whether that's prosecuting sexual abuse of children cases by those who are charged with protecting them, or armed robberies and murders, crimes of violence whose weapons are abuses of power. Personally, I myself have prosecuted 2 law enforcement officers for abuses of power. They were both sent to prison, and I, without hesitation, made that request to the court. My office is now prosecuting a law enforcement officer charged with reprehensible and repeated abuses of power that occurred on duty. He faces several life sentences. Prosecutors prosecute when the evidence warrants it. Among all of us here today, we have careers and centuries full of trying challenging cases, making tough decisions, and being tested in ways that would be difficult for those who have never prosecuted to understand. We have lived to see the effect of those cases and those decisions that they've had on our communities and the people in our communities. Local prosecutors uniquely understand how the decisions we make affect our communities. SB 290 puts state politics above justice, and I urge your unfavorable report. Thank you.
Excellent. Thank you very much. Seeing no questions from the committee, as Senator Folden's not here. Joke. That'll be it. Thank you all very much. Thank you. Is Ms. Koldlitis here? Okay. Want to make sure we get, did I miss any of the other state's attorneys? Okay, thank you very much. Roger that. All right. If we could hear from Mr. Lewis. Yep, come on up, and then just trying to get through this. Ari, or Mr. Plout, you're here. Mr. Kroll, you've already come. Got it. Excellent. And Mr. Davey. I think I saw Mr. Davey here earlier.
He's outside, sir.
Okay, great. We'll wait up. There you go. And Mr. Boatwright. Thought I saw him in back there. All right. All right.
Mr. Chair, good afternoon, sir. Distinguished members of the committee. I'm here today representing both the Maryland Chiefs of Police Association and the Maryland Sheriff's Association in opposition of Senate Bill 290. This bill expands the types of law enforcement related incidents that may be investigated by the Office of Attorney General, and it provides for the exclusive authority of the Attorney General to prosecute these incidents should the investigation provide sufficient grounds. 2 years ago, the Attorney General's office was given the authority to investigate those law enforcement involved incidents resulting in death or injuries likely to result in death. While the chiefs of police and the Maryland elected sheriffs opposed the legislation because it erodes the authority of the law enforcement agency, we've been able to work closely with Independent Investigation Division to establish protocols that have been adopted statewide by all law enforcement agencies. Maryland's chiefs and elected sheriffs see absolutely no reason to broaden the investigative division's investigative or prosecutorial authority. Further, the manner specified does not appear to be based on factual results of any prior investigations and would not be sound justification for doing so. Under current operational practices, law enforcement agencies may seek the assistance of an outside agency or investigative officer involved shootings. Many of our smaller agencies today routinely seek the assistance of the Maryland State Police or other larger policing agencies. This discretion allows an agency to determine the most effective approach for these additional investigations and to discuss matters of process, both administrative and criminal, as appropriate with the investigative agency. Maryland's chiefs of police and Maryland's elected sheriffs strongly oppose any additional legislation that further diminishes the responsibility of the chief or the elected sheriff by expanding the investigative authority of the IID and limits their ability to hold officers accountable. It certainly limits my ability to hold my own officers accountable. For these reasons, the chiefs of police and the sheriffs oppose Senate Bill 290 and urge an unfavorable committee response. Thank you, sir.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, honorable members of the committee. My name is Ari Plout, and I'm here on behalf of the Maryland State Fraternal Order of Police, respectfully opposing Senate Bill 290. We don't believe that an independent investigation unit should also have the ability to prosecute. We believe that the power to investigate independently should remain a separate entity from prosecutorial power. We fear that if the Attorney General performs both duties, that this may produce impartiality. These powers should be separate. We would propose what Mr. Schellenberger had discussed, the right of first refusal, propose giving the state's attorney the right of first refusal. We feel like that would be potentially a compromise. But we would urge the committee to limit the scope of what the investigations would be. But I would like to, at this time, I would yield my time and defer to the experts to my right, Mr. Davey, Mr. Boatwright. Thank you for the opportunity to speak, and I respectfully urge an unfavorable report. Thank you.
Good afternoon, Mr. Chair, members of the committee. For the record, my name is Clyde Boatwright, and I'm the president of the Maryland State Fraternal Order of Police. I represent over 21,000 men and women in uniform throughout the state of Maryland. We all stand in opposition, as our legislative attorney, Ari Plout, said. We stand in opposition of Senate Bill 290. I would have liked to use my 2 minutes to just say me too, because there's been a lot of testimony from the state's attorneys that we agree with, and our attorney Mike Davies here. But I would like to pose a number of questions for you that have to make a decision in this case on this bill. Think about these questions as you decide your vote. Is this bill about holding police officers accountable, or is it an opportunity to quiet angry mobs? Are we looking to criminally prosecute police officers for violating policy? Are we really saying that the public trust will not be restored unless we indict police officers? What message are we sending the men and women that wear the uniform every day? We've had historic we've had historic police reform passed in this body over the last few years, and we would like to see some of it bear some fruit and work. So as the representative of the men and women throughout the state that wear the uniform, we're asking you for an unfavorable report for this bill. And I'll turn my rest of my time over to my attorney, Mike Davey.
Good afternoon, Mr. Chair, Vice Chair. My name is Michael Davey. I'm General Counsel to the State Fraternal Order of Maryland, the Maryland State Fraternal Order of Police, and we are requesting an unfavorable report on Senate Bill 290. Here we are again. As we well know, in 2021, the General Assembly granted the authority of the police to investigate police-involved incidents resulting in the death of a citizen to the Office of the Attorney General's Independent Investigation Division. 2022, we're back again. The Maryland General Assembly amended the authority to include investigations of police-involved incidents that are likely to result in the death of citizens. And today, we're back again for additional authority to the OAG. The bill would allow for them to accept referral investigations from the state's attorney's office for police-involved incidents resulting in an injury to a citizen, the authority to investigate other crimes related to police misconduct that are discovered during an authorized investigation, and finally, exclusive authority to prosecute police officers for any crime within their authorized scope of authority. The FOP believes that this additional authority to prosecute these cases is a conflict of interest by having one division both be the investigator and the prosecutor in these very high-profile cases. We believe there are no checks and balances on that division. We believe it robs the local state's attorneys of their ability to perform their duties in their elected office. And just so we're clear, when we're talking about the statistics, since 2021, October of 2021, the Independent Investigation Division has investigated or currently investigating a total of 29 cases. There's been a lot of talk that nobody's been prosecuted in 29 cases. That's not true. So in the 29 cases, they've only completed the report on 16 of them. So there's 13 investigations that are still out there that have never been reviewed by a state's attorney and are still pending. So for us to look at this now and say 29 cases, nobody's been prosecuted, we're not even close to that. Those are still being investigated and under review. Based on the true statistics in this matter, we believe that an amendment to this law in this nature is not ripe and should wait till we have a better idea down the road of where we are. Thank you.
Excellent. Thank you, Mr. Davey. I'll say that we don't always agree, but I've always enjoyed working with you. So it's always a pleasure. Yeah. All right. Seeing no further questions, thank you all very much. Thank you. And with that, that'll conclude the panel, the opposition panel, and the testimony for Senate Bill 290. All right. Deep breath. And we go on to Senator Bailey, who's here with Senate Bill 208. Senator Bailey, you're up.
No, we won't go. We won't go very long. Are you ready? Okay. Good afternoon, Mr. Chairman and other distinguished members of the committee. Senate Bill 2080. Senator Bailey, District 29, representing St. Mary's and Calvert County. Senate Bill 208 would provide for enhanced penalties for indecent exposure in cases where the act is done within the sight of a minor. Under current law, all cases of indecent exposure are subject to a maximum penalty of 3 years in prison and $1,000 fine. This bill increases those to a maximum of 5 years in prison and a fine up to $10,000 when individuals commit indecent exposure with purient intent within the sight of a minor who is at least 2 years old and where the victim is more than 4 years younger than the offender. This bill is narrowly written to ensure that we are only capturing those who would commit this crime with the intent that causes harm to a child. This issue came to light after an incident that occurred to a constituent whose child was a victim of indecent exposure. The existing penalties were insufficient to cause the offender to become ineligible for a security clearance. At least 15 other states have enhanced penalties for indecent exposure against or within the sight of a minor. Maryland law already recognizes the importance of this issue and provides judges the option to require perpetrators to register as sex offenders if they commit indecent exposure against a minor as a deterrent. This bill does not require any new minimum sentences, only gives the judges the discretion to apply these higher penalties to offenders. This Senate Bill 208 is identical to House Bill 34, which passed over, and it actually passed this committee unanimously last year, but did not receive final passage before the end of the session. I respectfully request a favorable report on Senate Bill 208. Thank you for your consideration.
Excellent. Thank you, Senator. Questions from the committee? Senator Sidnor.
Quick question. I'm curious why you are saying that shall not commit the crime of the common law crime of indecent exposure rather than trying to define what indecent exposure is within the statute. But I'm wondering, I mean, technically, if the statute continues to refer to common law change, meaning that the statute isn't what's the word I'm looking for? It's ever moving, I guess is what I'm thinking.
Well, not being an attorney, but sitting here with you for some years, Senator, we are a common law state and we have the common law crime. But this just puts it in more distinct terms, more succinct terms, and that is how we can move forward. And we, as you remember, we actually had this bill exactly in this same form last year.
I'm also happy to let the courts decide that definition, unless you want to sit in the work group to define all of these things. Yeah. You can be on that work group. All right. All right, Senator Bailey, thank you very much. I'm gonna bring up your witnesses.
Thank you.
Okay, is Ms. Jordan's here? I see Ms. King. Hormione Morgan. Oh, and Ms. Taylor, I saw you. Is Ms. Taylor? Yeah, come on up. Oh, sorry, my apologies, my apologies. I think that's it. Okay.
Good evening, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of Senate Bill 208. It is a carefully balanced bill. There absolutely are plenty of cases involving indecent exposure that are not virulent and are not the sorts of things that we are worried about. However, we should also be aware that indecent exposure is kind of a gateway crime for sex offenders. So it really is important to be able to look at people who are purposefully with prurient intent. So this is not, someone relieving themselves outside. This is with prurient intent in front of a child, exposing themselves and have that higher penalty just available to the court, not mandatory, of course. So it has been a long day and I'm sure will be longer. So I'm happy to answer questions, but urge a favorable report.
All right, Senator West.
Thank you, Mr. Chair. Not to belabor this, but I see an amendment to the bill that says it's also illegal to expose any costume or covering that gives the appearance of or simulates the genitals. I don't think I've ever seen such a costume, but I can see in some college kid's mind the thought that this would be funny to do. And the penalty for this is years in jail. Doesn't that seem like overkill?
Senator, I'm not familiar with that proposed amendment, and without viewing it, hesitate to comment, but my instinct is that you are probably correct. That would be overkill.
Thank you.
Oh, actually, I have a question for you, Ms. Jordan. Let's. And there were a number of years ago, there was a prosecutor, I think it was in Ocean City, who was prosecuted for exposing himself. So I'm curious, under this legislation, does there have to be some sort of an intent there that you intend to expose yourself to children, or is it the fact that a child may have seen you?
No, I think that's an excellent question. I think that's dealt with by requiring the prurient intent. So it doesn't say prurient intent to, to have the minor there. So you certainly could add that. But I think I don't recall that scenario down in Ocean City. But if it was prurient intent and there were children there, I think that there's an assumption that if you're making that act with prurient intent, you should be aware if there are kids around.
So then your read of the legislation is just the fact that you had this prurient intent to expose yourself. That's enough.
That's enough if the minor is there. That would be my read of the way this is written. Although I would also point out that you also have to have a 4-year age difference between the two people. And that was to kind of avoid like live sexting, basically. And, that sort of college kid type thing.
Thank you.
I missed this, I was out of the room and I just came in and realized this was an important bill that I wanted to pay attention to. So you may have already covered it and I apologize if you did. When I looked at the bill, of course, anybody can agree with like the intent, but does the bill cover, because sometimes there are these, the streaker site situation where maybe there's a child in the group, in the audience at the street parade. Would that be covered under this bill? Or are you talking about a specific exposure to a specific child?
I'm talking about a specific exposure with prurient intent, and I would say that streaking would absolutely not qualify as a prurient intent.
So I will go back and look. So the language of the bill is clear about that? Okay, thank you.
I believe so. Yeah. I mean, certainly if you want the legislative history, no one's trying to get streaking, right? Streaking is not a prurient intent. These are people who are acting kind of for sexual gratification and children are around, and it's just permitting some additional time. And it was particularly relevant in St. Mary's County, where they had someone who in front of several children was exposing himself, was convicted, and the sentence that was available was insufficient to affect his security clearance. So there was that element of what prompted this as well.
So the exposer would be charged with knowing the age of the audience?
No, the charger would
recipient?
be charged with prurient intent. And as you'll recall, you've already passed this bill out of this committee last year. It failed on the floor, I believe, on third reader on sine die.
So this isn't person on subway pulls pants down. This is person in car, maybe Uber driver, picks up a child and specifically does it to the specific child.
If someone on the subway pulled his pants down with prurient intent, so for sexual gratification, and a child was there, that would be the case. If someone on the subway pulled his pants down to relieve himself, that's not prurient intent. It would not apply.
I understand. I think we're getting that kind of like, first of all, I don't condone that behavior, having, when I was a child, myself been the recipient of such a horrific, disgusting, and vile act. But again, I don't know that the person that did it had any idea around them who was there and what the ages were. I guess that's what I'm getting at.
Well, it's certainly a policy call for you, but I would respectfully suggest to the committee that if we have people who are exposing themselves for sexual gratification, so for prurient intent, out in the public where children could be around, or specifically to a child in a classroom or on a subway, that is something that merits some additional tools for the prosecutor and the judge to impose. And I think it's also notable that this leaves intact the non-prurient intent crime. And so that gives some recognition of the lower level, relieving themselves outside, that sort of thing. Homeless people who maybe can't conceal themselves as much.
I think there's sometimes just a gray line where we don't really always know what the intent is. There is, like, I remember one of the famous cases that came out, and one of the people that was mentioned that was a non-suspect in the case, but some people thought should have been a suspect, was a person that habitually apparently went into the park and habitually exposed themselves to people. So in a situation like that, I don't know what whether that person has period intent or not. And
Exactly why we have beyond a reasonable doubt, right? I mean, and certainly in that sort of case, you would expect that the judge would perhaps find the lower level type of indecent exposure, but the state would be unable to meet their burden of proof for the higher level of indecent exposure to children.
I understand your intent. Thank you.
I have questions, but
You're sure? I mean, because it is Valentine's Day and I know
Yeah.
no one has anything. to do.
yeah. Yeah, I mean, okay, yeah, we'll talk later. I mean, it's just about the,
You did pass it before.
I know that. It's just the intent, the pure intent, does it have to be directed or derived from the subject, or is it just? Because the streaking example is actually interesting, because what if someone, I mean, people get excited about all sorts of different things. And so if you were one that got excited about running on a, soccer field during the middle of the game, and there was a 2-year-old there, does it have to be directed toward the subject of am I deriving like pleasure from the general exercise, or the fact that it's directed specifically toward an individual?
I will double check the case law to see if there's
We're
any
talking about
additional guidance on that, but I don't believe so. Although I do think in that situation, it would be very difficult to
Understood.
prove beyond a reasonable
Well, they
doubt.
catch the guy and they're like, why'd you do that? Well, I love doing this stuff because it gets me excited.
Well, and if he did that at the circus with a whole bunch of children there, then, it's a reasonable public policy to have a higher sentence available.
Got it. All right. Thank you very much. Great subject for Valentine's Day. All right. Thank you, Miss. Oh, sorry, Senator Carter's got it.
Since I missed the beginning, did you have some specifics on specific cases where the current penalty under law was inadequate, where this happened? Did you already present that information, or is it in your testimony?
I don't believe it's in my testimony, but I believe it may be in Senator Bailey's testimony, as this stemmed from a case in St. Mary's County.
Thank you.
Good evening, Mr. Chair, Mr. Vice Chair, committee members. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office. I'm here on behalf of the Maryland State's Attorneys Association in support of SB 208. 15 states have distinguished between typical exposure versus something that we're talking about here today, which is indecent exposure in front of minors, which with period and intent. I think it's an important categorization that Ms. Jordan talks about. I have cases that I've handled as a child exploitation prosecutor for almost 10 years, that this is a gateway sex offense. That to Senator Carter's questions, or I think the general questions, is what we're trying to capture here is not streaking. What we're trying to capture here are individuals who masturbate in front of public schools, of individuals who wait at the bus stops for kids to get off of the bus to expose themselves, to get erect. So I'm going to be very blunt. I mean, pure intent is very clear. It's when an individual is having a sexual arousal or masturbating in front of children. And that's what we're trying to capture here. And I believe that is very distinguished from just a flashing or streaking. So I'll take any questions regarding that distinction and, why this is an important policy decision, I believe, before the legislature. So the MSAA would support an SB 208.
No, thank you. Senator Sidner, the clarification is helpful. Thank you.
Actually, to his question, I needed the clarification, because when you talk about masturbation, that's an act. That's not necessarily the intent. So but to his question though, he was asking, is it about the person deriving the pleasure from the act, or from running out on the field, or knowing that that person is going to be seen by children? Could you talk to that a little?
I think in our case examples and what we've seen in our offices is that I don't distinguish that. I think if someone is getting a sexual arousal from exposing themselves before children, then that's the pure intent that we're trying to capture.
Not necessarily the
streaking itself, no.
Thank you.
I just asked, does it have to be in public?
I guess, yes. It does in a public place.
That's where I'm going. Oh, it does.
Yes.
Okay, got it.
Yes.
Well, and then the next one is, I know exactly where Senator West is gonna go with this, but go ahead, Senator West, go ahead.
I don't see anything in here that says has to be done in public. I would think if a uncle were in a house and did this in front of a younger minor child, that the uncle would be just as guilty as doing it in public. Wouldn't that be right?
So Senator, I'm looking at Wisniewski versus State 398 Maryland 578, which is cited in my written testimony. And the then Court of Appeal said indecent exposure means a defendant intentionally exposed his penis or other body part that should not have been exhibited in a public place.
Okay. All right. So that's part of the definition of the common law crime of indecent exposure. Okay, fine. I didn't see it in the bill, so that's the
Yeah,
answer.
I think the uncle would probably be covered perhaps under 3602 because he's a family member and that would fall under child sexual abuse.
Okay, thank you.
All right. Thank you very much. All right. I called Mr. or Miss Hermine Morgan. Okay, so then now that concludes the testimony for the proponents of the bill. We'll switch to the opposition panel, and Miss Taylor, come on up. Tamara Stofa and Mr. Four. Hey, there you go. And then we'll wrap up with our virtual testimony from Ms. Feinstein.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. Thank you for listening to me today and my opposition to the bill. I'm Tamara Stoff. I'm the District Public Defender for District 3, which is on the Upper Eastern Shore. I'm here on behalf of the Office of the Public Defender. My opposition to the bill is what I've heard each of you referring to previously is the broad language of this bill. First, I would start with my concern of the fact that you don't identify the unit of prosecution in this case. You don't identify whether it's the act that we're prosecuting such that we're limiting the crime to 5 years, or if it's as to each individual minor, which then of course would expand the exposure to someone in this particular case. And so I would ask the court to the committee to consider that, because the unit of prosecution should be fair everywhere. It shouldn't be based on an individual prosecutor's decision to decide how they're going to charge this crime, as often happens in cases when the additional specific instance of a minor has been included in a charge. Additionally, you heard specific instances of when a minor has been exposed. The opponents in this case said in front of the child saw. They give examples of classrooms, of subways. What this statute actually says is in the sight of a minor. It does not identify the fact that the intention of the person or that the minor even saw this. In the examples that we gave, we can all understand and appreciate that, but that is not how this bill is written. And the streaking example is the exact example that I thought of when I thought of the fact that we did not define well what it meant within the sight of the child. This child the age starts at age 2. It doesn't even require the child saw the event and or that the child was aware of what was happening. So we could have 100 minors that were unaware or not even looking, who can't even testify that they were affected by this. And based on this, I'm asking for urging an unfavorable report.
Good afternoon, Senator Smith and all the other senators on the committee today who hung around to hear us. The Public Defender's Office is not in favor of this bill, and as has previously been stated, but I will tell you, I actually thought about what has been said before, and this is an enhanced penalty. And other than the one example given by the sponsor of someone being able to still get a clearance, security clearance to complete their employment, there really haven't been any examples that this current statute is not sufficient to cover what needs to be covered. In fact, already in this statute talks about sexual gratification. This addition does not talk about sexual gratification. It talks about prurient. I actually looked it up because I didn't know what it meant, to tell you the truth. So it says having or encouraging an excessive interest in sexual matters. How are you going to know that? This bill is very broadly written, and I believe it's an enhanced penalty, and it does cover the standards of people who are homeless, someone who's having an emergency situation, or even someone who's intoxicated. There are videos all the time, people intoxicated, going to the bathroom on the side of the roads, in front of clubs, wherever. But then we have the toss me some beads for Mardi Gras. Is that covered? Because a child may be nearby? Is it covered when somebody gets mad and they throw up their skirt or pull down their pants and say, kiss my boom boom? Is that covered? All of this would be covered under this particular writing of the bill. There is no definition of what does within sight mean. There's nothing that says that there was any harm to a child. When we do enhanced penalties, it's because there's a particular harm that we believe is above the ordinary, which is why we're doing an enhanced penalty. There is no words that would say that there was some harm to a child, just within sight.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Christine Dufour with the law firm of Jezik and Moyes. I'm here on behalf of the Maryland Criminal Attorneys Association, and we would urge an unfavorable report. Here, I echo what my esteemed former colleagues from the Public Defender's Office said. I think it's very broad, and I think it's also doesn't include the situation where a child may not have even seen the perpetrator pull down his pants. Within the sight of a minor, you've heard, as Ms. Stofa indicated, 3 different arguments that the proponent made. Well, the child is in front of the individual. The children are around. The children could be around. So even the proponents are acknowledging that the language is not really defined. I'll harken back. I've been around long enough. In 2014, this committee worked on both sides of the House and the Senate worked on crimes of violence committed in front of a minor. It took quite a back and forth to tweak that legislation to really denote, well, where does that minor have to be in the house? Do they have to be within hearing, within sight? Do they have to be a certain age? And I think that's what's needed here, that this bill, we all obviously don't want children exposed to individuals with prurient or nefarious intent. But again, the definition of prurient intent, the definition of spatiality, whether or not the child is in the sign of light, in the sight of a minor, when the individual in the sight of a minor, I think there needs to be work done in order to make this less broad. And certainly Ms. Stofa's comment on the unit of prosecution should be well taken. With that, we'd urge an unfavorable report.
All right, thank you very much. Just one
Good to see you
question,
again.
maybe. Thank you. It's good to be back. Good to see you all. When you say it's too broad, okay, are there amendments that you would pose that would streamline it more, or is there something you can get to us that will say, well, if we went with this, here's a way to streamline it based on your testimony, so that it's not as broad, that I would,
On behalf of the
entertain.
Maryland Criminal Defense Attorneys Association, I really signed up as informative. I defer to the colleagues at the public
Sure.
defenders as to if.
And one other for any of you, and it's my last question here. The penalties as they are now, is that sufficient? Is it something that's and I'll ask others, is it not working? We're making it an enhanced penalty because there are more and more of these incidents. I'm trying to.
I can say in my experience, and I've practiced in Montgomery County, Caroline County, Talbot, now all over the Eastern Shore. I've seen these cases. I've rarely seen someone get 3 years unless they
Right, that's
violate
my
their
point, right.
probation. A typical sentence might be 6 months or 18 months, but I think it really is determinative, as Ms. Taylor said, was there harm to the child? This bill contemplates, we don't even know if the child saw the act. So
Okay.
I think, so I defer again to the public defenders if they want to offer amendments.
And we
that-
can talk, if we come by off, we can talk, but thank you so very much.
Thank you.
Thank you.
Okay, well, Senator Meade, I would say that
Yes.
this bill really needs to be,
Okay,
it really needs to be, because it is overbroad.
okay,
And it does not, its tenor is not the commonplace reason why we do enhanced penalties is because there's a harm. And we want to reduce that harm. There's nothing in this bill that demonstrates a harm when it just says within sight, whether the child sees it or not. Is it 10 feet, 15 feet, 20 feet? Was the child even anywhere close to the individual? So this bill, good idea, but it needs to be rewritten.
okay. Thank you. Thank you, Mr. Chair.
Excellent. Thank you very much, Senator. Now we'll switch to Ms. Feinstein. Welcome, joining us
Thank
virtually.
you so much. Good afternoon, members of the committee, Chairman Smith. My name is Debbie Feinstein. I'm the Chief of the Special Victims Division for the Montgomery County State's Attorney's Office, and I'm testifying on behalf of myself, my office, as well as the Maryland State's Attorneys Association. I had intended to say me too to Ms. King and others' testimony, Ms. Jordan's, but I pulled up the case that was referenced by Ms. Jordan. And that case law answers, I think, all of the questions that the committee has had, because there's case law that describes and defines what exactly indecent exposure means. And I'm going to read to you from that case. It includes the information, the quote that Ms. Jordan had in her written testimony. It also states that there are 3 elements of indecent exposure. It must be made willfully and intentionally, as opposed to inadvertent or accidental. It must be a public exposure, and it must be one which is observed or is likely to have been observed by one or more persons, as opposed to have been performed in secret or hidden from the view of others. These are the 3 elements. In addition, and this clarifies a point that was made earlier, it actually can happen in a private home if the exposure meets the 3 elements. So public doesn't necessarily mean that it has to happen outdoors or in view of the public. This case actually is an in-home indecent exposure where it was intentional. It may be inferred from the conduct of the accused and the circumstances and the environment of the occurrence. It becomes indecent when a defendant exposes himself or herself at a time and place that a reasonable person should know or knows that his act will be open to the observation of others. Therefore, public elements depends on the ability to be observed by others. And then lastly, there's also, it says testimony must show the exposure was not merely accidental, and we have to be satisfied that the exposure was intentional at a time and place as a such manner to offend public decency. Intent may be inferred from recklessness. In addition, it says that, I'm done, but I did want to mention one last thing. May I do that, Chair, from the case?
I'm sorry, can you say that one more time?
May I read the last piece of the case that I think is relevant and answers the questions?
Yes, please, very succinctly, but also could you send that to the committee as well?
Absolutely,
Thank
Chair.
you.
I'll send
The
it to you
citation.
right afterwards. So it says that ordinarily intent of the perpetrator is established by evidence of motions, signals, sounds, or other actions by the accused designed to attract attention to his or her exposed condition, or by his display in a place so public and open that it must be reasonably presumed that it was intended to be witnessed. So there is intent that is required by the indecent exposure statute generally. The place is defined, the intent is defined, what signals the intent with respect to the person wanting other people to see it. It's not something that happens accidentally, and this case makes that explicitly clear. Thank you very much for the extra time.
Yeah, thank you very much. That was very helpful. And thank you for sending it. All right, seeing no questions, that'll conclude the testimony and the hearing for Senate Bill 208. We'll now move to Senator Bailey with Senate Bill 336.
Thank you, Mr. Chair. Distinguished members of the committee. Senator Bailey, District 29, St. Mary's and Calvert County for the record. Now I'm going to talk to you about Senate Bill 336, which would establish a waterway incident notification system, WINS, and it would be a work group. We're all familiar with the Amber Alert system. We're all familiar with a Silver Alert system. But where I come from and many of my colleagues, we all are out on the water. When you're in the water, there is no waterway notification system. And what happens is different than on land. The actual response time for the police or the fire is a very long time, usually 25, 30 minutes. By the time somebody's in the water and a 911 call goes in, unfortunately, and doing it for 30 years, by the time the police or the fire get there, we usually get there to calm water. There's nobody on the surface of the water unless they had a life jacket on, right? I will tell you this in my personal experience, the majority of times when I got there and somebody was rescued, it was done by a passerby or somebody that saw the accident. I think if they were able to do it, you'll have some people on here this afternoon that actually saved people's lives. But the thing we had last summer in my district was we had some children that were swimming and they got in trouble. With the current, they called 911. And by the time the rescue boats got there, there was nobody there. The issue was there were commercial watermen that were right outside, right? They were working right outside. If we had had a notification system such as this, they could have potentially been notified, run in there and made a recovery. What this bill does, this work group just sets up the fact that we can save some lives. And so I contacted MIMS. I said, you know, I think this is a good idea. What do you think? Well, there's a lot of different people and a lot of different moving parts. So when it came back, we decided that the best way that this would be a work group. This legislation will bring together representatives from the Department of Emergency Services, the Natural Resource Police, the Department of Information Technology, 911 Board, and local emergency management officials and members of the General Assembly to determine the best way to create and implement such a system. In addition to the bill, because we've been working on this, I'm introducing this bill with an amendment that will add the Department of the Environment to the work group because they wanted to be involved, and add a provision to give the chair of the work group discretion to add other members. This was requested by the emergency department and reflects similar work groups they have had in the past. And I'm also willing to push back the deadline for the final report to September 30th, 2024. Want to make sure that we do this right the first time. I respectfully request a favorable report on Senate Bill 336 with these amendments. Thank you for your consideration.
Excellent. Thank you, Senator. And then the rest of your panel joining us virtually. We'll start off with Mr. Lumpkins. Ryan, you're up.
Hey, everybody. How you doing today? I know I only got 2 minutes. A little bit of background. I'm a commercial fisherman by trade and an HVAC technician by trade. I'll share a story with me that happened as a commercial waterman. I sank a boat off of Dorchester County off of Hooper's Island. I called Mayday, Mayday, Mayday on the radio to the Coast Guard. They did respond before the vessel went down, and they showed up 50 minutes later and by helicopter. However, by then went very bad very quickly. The waterman in Dorchester County, one happened to see me and happened to see me go down. So he was able to contact other watermen on the VHF radio, and they were able to save me. They actually had the boat and me in safe condition before the Coast Guard arrived. Also, I do live on St. George's Island in St. Mary's County. Numerous times I have seen either the Patuxent River helicopter flying around, Coast Guard flying around, fire department boats going everywhere. And I'm just like, man, what is going on? What is going on? And for instance, last year on St. George's Island, 3 kids died off of Camp Maryland, a camping resort. I could see all the emergency personnel, but it's like I have to call through the community to say, hey, what's going on? Does anybody know what's going on? And we have no way of knowing that these people could have been saved, and maybe there was a boater, a waterman, somebody that was there that could just grab these kids that fast. Another time last year on Father's Day weekend, during the weekend, I witnessed 3 boats sink. One crashed into the rocks in the early morning hours. 2 sank in the middle of the day at like 9 a.m. in the morning, and I didn't find out until like 2 o'clock in the afternoon when I saw emergency personnel out there and them getting towed home. So there would be cool thing if Amber Alert could be sent out to the citizens. I think it would save state and local resources because often these searches are conducted for days upon times using valuable tax dollars. And it also takes a lot of time for local authorities to be able to disperse, like the fire department and even the Coast Guard is so far out of range sometimes that we really need the community to be able to save lives. And I think if there's a notification system, it could save lives in the future.
Excellent. Thank you very much, Mr. Lumpkins. Mr. Booth, you're up. Welcome.
Can you hear me?
We can hear you now. Yes.
Oh, sorry about that. Yeah. So, in light of what Ryan said, he brought up all the key points. I have a property. I've been on the water best part of my life. Went around the waterman as well, and it's been many times in cases, where if this was implemented or if this system was put in place, we could definitely had opportunities to get the people quicker than the local fire department or the natural resources. I mean, they can't be at every place, at every particular moment, and time is critical. So just a little story. About 15 years ago, I was on the Patuxent River crabbing with my little children, and we were in a boat, and I seen an accident take place, and I was able to run across the river and get to the folks. They were just coming to the top of the water. The boat was high speed, boat, and they crashed the boat. One of the guys didn't come to the top. He ended up drowning, but me and another gentleman got there fast and was able to get the two gentlemen out of the water, call the emergency folks, and met and put them in the boat and got them underneath the bridge and had the ambulance pick them up. The emergency folks pick them up right there underneath the Solomon's Island Bridge. So I feel just that quick responsiveness. If I hadn't got there, of course, they probably would have drowned. They were disoriented. But if in the world of cell phones, and everybody's got a cell phone, what a great thing this could be, to save lives across not just Maryland, but across the United States, and if something like this were to be put in place, I think it would be very beneficial. We get the Amber Alerts, everybody gets those, and there's a lot of folks and watermen that work on the water, people out, recreational, and just being a support system and extra set of eyes and hands to find people, people can only stay afloat so long, if they're swimming. Time is critical. So yeah, if we could get something like this in place, I think it would be awesome. So hopefully this helped, and we appreciate y'all taking time today to have our input.
Thank you both very much for joining us, and thank you, Senator Bailey. With seeing no questions from the committee, that'll end the testimony and the hearing for Senate Bill 336. Thank you very much, Senator Bailey. We'll now hear from Senator Salling. John Ray Salling, you here? What about Senator Reedy? All right, Senator West, you have two relatively straightforward bills. Can you, are you ready to go? All right, so we'll now hear from Senator West of Senate Bill 209, followed by Senate Bill 236.
Thank you, Mr. Chair. I'm Chris West here presenting Senate Bill 209. And normally I wouldn't include this in my testimony, but my staff prepared this opening sentence and I thought it was charming. So here goes. I hope on this Valentine's Day, I'm presenting a bill you'll fall in love with. So in 2019, the General Assembly created a task force to study the breadth of the state's criminal laws and the penalties associated with them. Unfortunately, COVID intervened and the task force never got very far in its assigned tasks. So Senate Bill 209 seeks to restart the clock and reinitiate the task force. The task force that will consist of 15 members, including 3 state senators, 3 delegates, the executive director of the Maryland Sentencing Commission, several experts on criminal sentencing, a state's attorney, a public defender, a representative of the Attorney General, and several others. The assigned mission of the task force is to review the penalties for all criminal and civil violations throughout the Maryland Code, which you see up there in the bookcases behind the chair. The code is quite extensive, and these penalties are scattered all through the code, not just in the criminal law section. So the study is how those classifications compare to those in Maryland and to make recommendations regarding the current statutory scheme for criminal and civil violations throughout the code, including whether there are violations that should be reclassified as civil offenses, misdemeanors, or felonies, and whether there are penalties that should be altered. So this is a 2-year study because it's expected to be quite a significant amount of work for those who are on the work group. So it won't report its findings and the recommendations until December 31st, 2024. I'm so pleased that I'm joined as co-sponsors in this bill by Senator Smith, Senator Sidner, Senator McKay, and a couple of other senators who are not on this committee. So I appreciate the committee's consideration of Senate Bill 209, and I'll be happy to answer any questions. I did receive from advocates 5 proposed amendments to the bill. Most of the amendments want to add more people to the task force. One amendment wants to also add the Maryland common law to what's going to be studied. What are the penalties under Maryland common law? You'll recall that some of the common law has been codified in statute. Other parts of the common law have never been codified. And so we're dealing with common law dating from the 1600s, 1700s, as well as penalties dating from the 1600s and 1700s. So if we'll talk about the amendments, so I guess when we get into the voting session. But I have no objection to adding more people. I don't want the task force to get too unwieldy. It's 15 people already. So I would think we should cut it off at 20. And with that, I'm happy to take any questions.
Excellent. Thank you very much for bringing the bill forward, Senator. Seeing no questions. Thank you very much. All right, I'll call, we have several witnesses signed up, but I suspect, I hope, folks are enjoying time with their families, but Ms. Hanson is Mr. Sastini, sorry, I butchered that, my apologies. Mr. Giannetti. Got it, okay. And, okay, got it. And that's it.
I suppose while Ms. Hanson's coming in, if I could begin. All right. My name is Brian Saseni. I'm with the Public Defender's Office. The Office of the Public Defender supports this bill for many of the reasons that Senator West has already said. It's our hope that it will bring our criminal law in line with best practices and identify places where it can be improved. We did respectfully suggest as a friendly amendment, adding language that would allow the task force to also review common law offenses. As was said earlier by one of the assistant state's attorneys, Maryland is a common law state. I counted about a dozen laws that are crimes that are common law crimes. As such, they are all classified as misdemeanors, and they have no maximum sentence except what a judge finds is cruel and unusual. Those include conspiracy, 3 types of counterfeiting, affray, rioting, malfeasance or misconduct in office, false imprisonment, conspiracy to commit murder. So it's there's a broad range of these common law crimes that still exist. And while the task force is reviewing the many crimes in the code and trying to address those, we think that it would be helpful to do that for common law crimes as well. Thank you so much. And for that reason, we'd ask for a favorable report with that amendment.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. Christine Dufour with the law firm of Jessica Moyes on behalf of the Maryland Criminal, I'm on so many committees, Maryland Criminal Attorneys Association, Defense Attorneys Association. We suggest a favorable report with an amendment that you include us. We are an organization with over 488 members. We have offices in over 20 states. However, we practice 20 jurisdictions. However, we practice in all of the counties. So for that reason, while our interests are often aligned with our friends at the Public Defender's Office, we do have solo practitioners in larger firms. I am opened up the Eastern Shore office of a larger firm. So our interests aren't always in line, but we certainly agree. And as a former advocate, I was in there when we were discussing the governor's crime bill a few years ago when we discovered there are 4 different definitions of mandatory minimum. And the former chairman of this committee and I went back and forth about all of those different definitions that were included in the code. And so we encourage a real sit down with all the stakeholders to look over and review. And we applaud Senator West for bringing this. And I know that COVID interrupted it, but I think this is now is the right time to look at it. In addition, I would respectfully suggest, and I know Vice Chairman Moon and I spoke about that, once that committee's work is done, perhaps they can look at a holistic view of expungement in line with the codification. I think that would make sense as well. So that would be my humble suggestion. With that, we urge a favorable report and we hope to be included on the committee, on the task force.
Excellent. Thank you very much.
Thank you.
Similar to the work that the General Assembly did in the 70s when pulling a lot of the common law, codifying a lot of the common law crimes. So similar exercise. So thank you, Senator West. All right. Are any of the virtual participants here? Okay. So with that, that'll conclude the hearing for Senate. I'm sorry. Oh, sorry. Senator Walsh-Reagan, you have a question.
I do not. I was just going to add my thanks as well. I think I'm the only member of this committee that sat on the original version of the committee, and the energy and excitement that was there and the bipartisan spirit with which we were working before getting derailed by COVID was amazingly productive and like nothing I've ever seen. So it's nice. Thank you, Senator, for bringing us back and to get us back on track to where we were.
And this iteration will be sanitized of politics and mostly politicians and experts and practitioners in the field and people from the Bar Association. So really excited about this. All right, so that'll conclude the hearing for Senate Bill 209. Senator West, I know I called we have 2 other senators from other committees here. Senator Reedy has very few witnesses. So we're going to Senator Reedy's bill first, Senate Bill 330, then we'll go to Senator Solly.
Mr. President, if it's okay, thank you. I'd like to maybe bring up, I think I have some witnesses here in support. If I could have them just go ahead and come on up. That way we would save you some time. Yeah, good to see you. Okay. I think that's all. Okay, good. Mr. Chairman, Mr. Vice Chair, and members of the committee, I'm excited and delighted to be spending Valentine's early evening with you here to present Senate Bill 330. The Body Worn Camera Appropriation and Financing Act of 2023. This bill comes out of the work of the Law Enforcement Body Worn Camera Task Force, which I was proud to serve on as Senate designee, and I appreciate Senate President Ferguson for appointing me. To that, we were able to work together. Delegate Lewis was the chair. We were able to work together with lots of stakeholders in a very sort of, I would say, nonpartisan way, as opposed to bipartisan, really trying to get at the issue of how to establish cost-efficient ways to scale the use and acquisition of body-worn cameras, among some other things that we worked on with that task force as well, to implement body-worn cameras. Access to body-worn cameras will provide increased accountability in law enforcement, provide transparency, oversight, and most of all, it increases trust and strengthens police and civilian relationships. I like to point out that I have never met a law enforcement officer or agency that didn't want body cameras. Generally speaking, I've never met anybody who didn't think it was a good idea. Question was always, first of all, how to do it the right way as far as how we handle the data and the information and to protect people's privacy. And then, which we did work on in this committee years ago, and then how to pay for it, which is always the question when we have good policy ideas, is how to pay for it. So that was the only issue that could delay full implementation. So that's why I've sponsored Senate Bill 330, and Delegate Lewis has cross-filed the House bill. And it's a common sense bill that will ensure that body camera systems are affordable and accessible for all our law enforcement agencies. Just for the sake of the public record, I think a lot of the members of this committee know the issue with body camera affordability is not so much the actual camera, although that is certainly a cost. It's the data management, storage, and collating of the information. So it's a whole package of things. So this bill, Senate Bill 330, will allow for statewide negotiation of body camera contracts, acquisition of devices and storage of BWCs, which will help eliminate the significant financial barriers that many of our small law enforcement entities and agencies will deal with as they try to implement their body-worn camera programs. It's especially true in some of our smaller towns and less populated counties that have those challenges. And so this is to try to streamline the resources necessary for a successful body worn camera program and have a statewide system that really reflects the needs of law enforcement agencies as a whole. The cost for body worn cameras can often fall between $1,800 and $3,800 per officer and camera. And when you're with an agency in a town like I live in, Manchester, a very small police force, it's a big expense. And so, or a lot of our other towns as well. So this is to allow for them to tag on to state procurements. And that's what the bill will do. And I want to thank all the stakeholders on our task force for working so diligently to try to come up with the best way of the best solutions for this. There are some friendly amendments that we've been working through, as you would expect on a bill like this. I believe we've got at least one amendment that came from MACO, and then we had a DGS amendment to the amendment that's in your packet, and I'd be happy to explain that as needed. Some of it had to do with how people get notified about when a procurement's going, and that was the main thing was focusing and making sure there's communication and availability of information so that our agents, our counties, and our towns know or have the opportunity to know when they can tag on to a procurement. With that, I will stop and I can turn it over to my witness here in support, or I'm happy to answer any questions if there are any.
Good afternoon, Mr. Chair, members of the committee. I'll be brief. I am Scott Adams. I'm Sheriff of Cecil County and also the President of the Maryland Sheriff's Association. I would just like to I'm also speaking for the Maryland Chiefs of Police Association today. I would like to voice our support with the amendments that were referenced to Senate Bill 330. As was mentioned, this is a critical bill to help some smaller agencies across the state to be able to afford the body worn camera programs. That it is certainly a burden on some smaller agencies. The cost, as was referenced, is not so much the body cameras themselves, but data storage and redaction and review of video. So there was an important amendment that was that I'm assuming you have, which talked about it's an opt-in clause for agencies, because some agencies may already have their programs in place and running, which they want to maintain. So with that, we would ask for a favorable report. Thank you.
Man, you're quick, Mr. Chair. So Senator Reedy, I just wanted to thank you for bringing this bill forward. I can just tell you and make others aware that as the assistant chief of another organization in Maryland, we are going through this process right now, and we're purchasing 75 body worn cameras, and the storage, the cameras, and the associated accessories that are required to go with it. The bid is $1,021,000. So thank you. I appreciate it. This isn't that true?
It is true. And I just it's definitely a really important issue for our folks. And again, I think what's exciting is that whenever we've seen them implemented, like my sheriff, for example, Sheriff DeWeese, he talks about how great it is to, generally it actually shows that the officers are doing a good job, but sometimes there are like, hey, we need to, a lot of times it's just update training. Hey, you had a little bit, could have handled that better, and we want to have good training. So it works well both ways, and there's a lot of enthusiasm for it. So we're hoping this is a big help.
Excellent. Thanks for pointing that out. I didn't know that. Sarah Sample, Miss Sample, would you like to come up? Thanks.
All right, thank you everyone for having me today. Thank you to the chair and the members, and of course to Senator Reedy for introducing this bill. So my name is Sarah Sample. I'm from the Maryland Association of Counties, and we are in support of Senate Bill 330. And just to reiterate some of the things that we've already heard, it's not just about the cameras, and I know that we've heard that a couple of times, but I just want to walk you through what this actually looks like from an infrastructure standpoint. It's the cameras, it is the chargers for the cameras, it is the storage. So this is servers and cloud capacity. It's the redaction software. This is the personnel that has to do the redaction. I think most importantly, that hasn't really been touched on yet, is the cybersecurity for implementation of this. This is incredibly sensitive material. And so I just wanted to point that out in terms of what this rollout actually looks like. The centralizing of the contracts, I think, is a great method for getting some of our smaller jurisdictions up and running. It helps avoid some of those redundancies of effort that might happen when everyone's trying to get these systems set up. It also helps them avoid the potential premiums that can come with single user contracts. So we think that's great as well. But overall, we think this is a great bill. We added a little bit of clarifying language that actually Senator Reedy has already touched on in terms of what the amendments would say. But ultimately, what we wanted to clarify was that we don't expect that DGS is going to be, or Department of General Services is going to be doing a custom job for all the counties. We expect to simply ride on the contracts that are established at the state level. So for those reasons, we would support Senate Bill 330. And thank you.
Oh, I didn't turn it on. I'm sorry, Mr. Chair. It must have still been on.
All right. All right, seeing no further questions from the committee, thank you very much, Ms. Sample. That'll conclude the hearing for Senate Bill 330. Thank you, Senator Reedy. All right, we'll now move on to Senator Salling with Senate Bill 226.
I think I might have a couple of witnesses. If they could come up, Mr. Chair, appreciate that. Please come up and make yourself at home. I'm going to thank the chair, the vice chair, and the members of the committee. For the record, I'm Senator John Ray Salling. And today I'm here to ask you to support on this bill that prohibit a person for knowing or intentionally access a visual representation of a child under the age of 16 with the intent of view and access child pornography. This is a big issue in my district, just to let you know, of some child abuse in the 6th District of Baltimore County. The law enforcement investigates, it was found that the alleged perpetrator was regularly watching child pornography. And this intent of the General Assembly for the consumption and watching of child pornography that is to be illegal or a criminally punishable offense. The alleged perpetrator could not be prosecuted because of the law that's applied to download content or not not streaming content. This bill closes the current loophole in law by tweaking the current law. And I respectfully would like a favorable report on this bill. I have people here now that I know could do a better job than me and explain it a lot more in detail. But I thank you for the opportunity. And if you have any questions, I'll be more than happy to answer them.
Excellent. Thank you very much, Senator. We'll
Thank you
jump right in. Ms. Jordan.
Good evening, Mr. Chair, Mr. Vice Chair, members of the committee. Again, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of Senate Bill 226. This is regarding streaming of child pornography, and it's a very technical bill. So the current law in Maryland requires that you retain your the child pornography. It says a person may not knowingly possess and intentionally retain. And so honestly, when a delegate called me about this, I said, you've got to be kidding. Mr. Schellenberger can't prosecute this. And he could not, because the perpetrator had streamed the child pornography. He didn't download it onto his computer. And you'll hear from the prosecutors about why this is a problem. But we all know there are different streaming and downloading and that sort of thing. So it's really it's a technology bill. As the Coalition Against Sexual Assault, I really just want to remind you what you know, and that's just like how terrible these cases are for the victims. I mean, they're not only sexually abused in the first place as kids, but I've talked to survivors who are in their 30s and 40s, and their images are still being circulated. It never goes away. It is a continual thing. And so I think that we really have gone a long way from we used to think of the magazines in the closet, and then we have downloaded images, and now we've got streaming images or streaming images of live performances of children that are then taped. I mean, it's an extremely serious problem. So I urge the committee not to minimize this. The language that proposed is the federal language, knowingly or intentionally access with intent to view. And that would allow prosecutors to also prosecute for streaming of child porn as well as retaining child porn. So for those reasons, we urge a favorable report.
Good evening. I'm Joyce King on behalf of the Frederick County State's Attorney's Office. I'm Chief Counsel and I lead the Frederick County Cyber Crimes Task Force, and I'm here on behalf of the Maryland State's Attorneys Association in support of SB 226. I've been prosecuting child exploitation cases for almost 10 years, specifically possession, distribution, production of child pornography. And this absolutely is a necessary modernization of this statute to align it with the federal statute. Currently, there are platforms such as cloud sharing, cloud storage, dark web, link sharing. These are areas that child pornographers are utilizing, and we are unable to prosecute at this time. When we were before the House, I said it there and I'll say it here. I'm trying to be tactful in my testimony because I don't want to teach people how to get child pornography, but there are artifacts, forensic artifacts within computers and digital devices that law enforcement are able to acquire. However, we are unable to charge at this time. So I echo the sentiments of Ms. Jordan and ask for a favorable report. These are real victims, real children. The harm and victimization and trauma is perpetual, and this is not a victimless crime. So we would hope for a favorable report of your committee.
Good evening, Scott Schellenberger, State's Attorney for Baltimore County. Ditto. It's probably going to be a day where you've heard from me the least, because there are so many other good witnesses who have gone ahead of me, which is great. Current law, you have to intentionally possess or retain. So if you're savvy on the computer, then you can stream it, watch away, and you're not actually retaining or possessing it. And so the folks have gotten very savvy at how to view this and not break the law. And what we need to do is keep up with modern times. This is just making sure our statute is staying up to date with how people are actually viewing the pornography. And remember, there has to be an intentional, it has to be intentional, and I have to prove that. And that is quite the burden, is that the person can't say, oh, it was an accident, I only looked at it for 5 seconds. I have a burden of proof that I have to meet, that they intentionally did this to view it by streaming it. So I think this is a no-brainer, although I've said that before and I've been wrong, but I think it's a very easy bill, and I urge a favorable report.
See, you got me. All right, seeing no further questions, thank you very much, Senator. We have 2 oral participants in favor. We'll hear from them now. And I think first up is Miss Cairns. Welcome.
Thank you. Can you hear me?
Yes, we can.
My name is Peggy Cairns. I'm the education chairperson of the Maryland Coalition Against Pornography. We're a nonprofit educational organization since 1986, and I'm a mother and a grandmother. Thank you, Chairman Smith, Vice Chair Walt Stryker, and the members of the committee for this opportunity. As we have heard, it's the intent of the bill to penalize those who have been found guilty of consuming child sexual abuse material, and I hope we can all agree we still do need to do this. But as the law was originally written, it never anticipated there would be technology that would enable live streaming. So the problem is that we now have technology that's similar to Netflix or Zoom meetings or live webcams, where there is live sexual exploitation, and the viewers are actively in real time watching children who are being sexually abused. Sometimes they are being trafficked live to a viewer, where the viewer is calling in tailor-made instructions to the trafficker to see what he wants to see. These images are not being downloaded or retained, and so we have this problem that there's no retention on the viewer's device. So this abuse is occurring in ways more horrific than ever, and it's hard to get prosecution of these kinds of things. I hope you'll see our testimony that we submitted that has more statistics on this. It has a long Wikipedia article about all the permutations of cybercrime. And the statistics are pretty horrifying. 85 million images last year in 2021, National Center for Missing and Exploited Children received. Thank you for this opportunity. We urge a favorable report.
Excellent. Thank you very much. Now we'll hear from Ms. DeLapp. Welcome.
Hi, thank you so much. I'm Rachel DeLapp. I volunteer with MCAP, and I'm a mother with children ages 3 to 15 who attend schools in Montgomery County. And I know many parents who are extremely concerned about these type of issues. I just want to say thank you to everyone for letting us speak, and this bill and all those who are supporting it really give me hope that there are others out here who really care about our children and the threats they're facing today. Just like with Heather's experience, it's not just about prosecuting people. Child pornography involves real children, real victims who are exploited and then deal with the repercussions for the rest of their lives. And like Peggy was saying about the 85 million images, videos, and other files that were given to the National Center for Missing and Exploited Children, that was in just 2021 alone. Those are only the ones that were detected and reported. So we know there's a lot more going on, and it's a low cost for those paying for it. And it's so sad about these abusive live streams that we haven't been able to detect. And I just want to say that behind every live stream is a real child suffering real trauma, often for years on end, while the abuse goes undetected and unreported, and they're left with serious emotional and physical trauma. And so I feel like this bill will move our Maryland law a crucial step in the right direction to help recognize and right these extreme wrongs. So I urge a favorable vote, and thank you again for letting me talk.
Thank you very much, Ms. DeLapp. All right, so that'll conclude the testimony for the proponents. Oh, sorry. We have a question from Senator Sidnor. Sorry.
Actually, I apologize. As she was talking, a question came up that if possible, I wanted to ask the state's attorney who was here. Thank you. In listening to the testimony, the question that I had is that, all right, with streaming, we're trying to get people who are watching, but obviously if you're streaming, there's somebody who is possessing this stuff. And I'm curious, has it been extremely difficult to prosecute the person who's doing the streaming rather than the recipient?
The facilitator?
Right.
Yes, and to echo those sentiments, those are some of the cases, our live sex stream shows where we have an individual here in Maryland, and often the facilitators in a third world country that's doing the hands-on abuse. And the individual here in Maryland is giving them instructions of how to abuse the child. So I have some of those cases. We work in conjunction with the U.S. Attorney's Office. There are some times where there is enough forensic evidence that we can prosecute that. But again, if there aren't screen captures of that, then we currently are not able to.
I appreciate it. Thank you. Thank you.
All right. So again, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And we will hear from Ms. Taylor. Ms. Taylor. Yes. Oh, yes. Rose. Yes. There you go.
And she's going first. Didn't know that till just now. Good evening, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland. I represent youth and young adults, and I'm here testifying in opposition to SB 226. SB 226 would expand the definition of possession of child pornography to those who knowingly or intentionally access, instead of just those who intentionally retain. This expansion could have unfortunate consequences of the selective criminalization of adolescents for mere curiosity. So I think the committee is well aware that in 2019, Maryland's courts found that a child could be prosecuted for child pornography based solely on an image or video of himself engaged in consensual sexual behavior. In 2021, this body passed legislation to fix this obvious issue. And while that legislation was well-meaning, it instead endorsed the court's finding, leaving the matter of whether or not adolescents should be prosecuted for sexting to the discretion of prosecutors, police, and judges, and allowing teenagers to continue to be charged with distribution, possession, and production of child pornography for sending or receiving images of themselves engaged in that consensual sexual behavior. What the legislature essentially did was endorse the court's finding, still leaving things discretionary. As a result, any expansion of the child pornography laws can lead to disastrous results when it comes to youth, the very children that child pornography laws intend to protect, including those who receive files and just open them out of mere curiosity without knowing the content of their files. We've given some examples in our written testimony of ways in which people can inadvertently access. They're all realistic. They're all based on real situations that we have seen across the state. This isn't about savviness to avoid prosecution, and instead it's about mistakes and inadvertent viewing of these videos, situations such as airdrops at school or Snapchat. Teenage sexting is not child pornography, and until the legislature changed the definition of child pornography to exclude children, any expansion of the definition of child pornography runs the risk of the selective prosecution and criminalization of children, the same people that the bill purports to protect.
Good afternoon, Benita Taylor from the Public Defender's Office. I'm going to make it quick because you guys have had a long day. We are in opposition to Senate Bill 226 because it is broad and it expands the definition, and it also does not get at the root of the problem. The problem is we need to get the people who facilitate, who are the producers and who are the directors of these videos, not the children or people who inadvertently view it. That's a whole different category of folks that we need to figure out how to deal with. But what we need to do is focus on those people. I was asked to testify because I will give you an example of this bill, who it could cover when you talk about access with intent to view. I actually could be charged under this bill. My grandson had my cell phone over the Christmas holiday. He's 11. A friend sent him a video. He then in turn looked at the video, looked at it again, had it on my phone. And I was going through my phone and saw all these TikToks on my phone. I'm like, what in the world is this? Let me go through this and see what this is. Well, I had to close my eyes and blush and call my daughter and say, what is going on with my 11-year-old grandson? What is he watching on these phones and these videos that y'all don't know? And I did purposely look at it because I wanted to know where it came from. So I purposely looked at it and called my daughter about what was going on. I've also had an experience where I unknowingly opened a video that was sent to me that came across my line that I did not look for, I did not ask for, but when I opened it up, there it was with all this stuff that I did not want to see. But I looked through it because I wanted to know who sent it to me and how did I get it? How could I block this information? But this bill says you just knowingly or intentionally access with intent to view. I did those things. I believe that this bill does not get to the root of the problem, which is these facilitators, these directors, and these producers. And that's what we should be doing.
All right, seeing no questions from the committee, thank you both very much. And with that, that'll end the hearing for Senate Bill 226. We'll now move on to Senator West, Senate Bill 236.
Thank you, Mr. Chair. It's a pleasure to be here and present Senate Bill 236. Unlike the last time, I don't have an introductory sentence that's going to cause Senator Folden to move unfavorable. Senate Bill 236 deals with whether the fact that a witness has been convicted of a crime can be used to impeach the credibility of the witness. Maryland Rule 5609 currently provides that the crime must be either an infamous crime or another crime that is relevant to the witness's credibility. Further, evidence of the conviction is not admissible under Rule 5609 if a period of more than 15 years has elapsed since the date of the conviction, except as to a conviction for perjury, for which no time limit applies at all. Section 10-905 of the Courts and Judicial Proceedings article is the statutory predicate to Rule 5609. It states that evidence that a witness has been convicted of perjury shall be admitted for the purpose of attacking the credibility of a witness, regardless of the date of the conviction. Thus, the rule in Maryland is that evidence that the witness cannot be believed due to a perjury conviction is always relevant. So Senate Bill 236 is very simple. It adds 2 words to the existing statute. It adds the offense of forgery to the offense of perjury as being always available to attack the credibility of a witness without a time limitation. Someone who has been convicted for forging a check or other instrument suffers from credibility problems just as much as a person who has been convicted of committing perjury. So Senate Bill 236 is another safeguard to the integrity of the court, acting as an additional filter to catch false testimony. I appreciate the committee's consideration of this bill. I think that Mr. Schellenberger is the only witness, and I'm sure he'll be brief like I was. Thank you.
Good evening, Scott Schellenberger, State's Attorney for Baltimore County. When was the last time I was here during an entire day and voted and said in favor of 2 bills? I'm always against everything. I know. So this is very simple, and it really outlines the interrelationship between Maryland Rule 5609 and Senator West described it all perfectly, and CJ 10905. So the typical situation in Maryland is if you're taking a witness stand and you've been convicted of an infamous crime. And if it's an infamous crime is one that would typically go to your credibility. The best example is theft. You can be convicted of shoplifting and you take the witness stand in another case. I can ask you about that shoplifting. The intent of the rule and the statute is the idea is for me to test your credibility and let the fact finder doubt your credibility because you've previously been convicted of stealing. That rule has existed forever and now is codified. The problem is several years ago, they put a 15-year time limit on it. So they said, okay, if you've gone 15 years without being convicted of something infamous like theft, like forgery, like some others, then we think you should be able to take the witness stand and not have a person ask you about that conviction. They made an exception. The exception was perjury. Makes sense. It's logical. You were convicted of lying under oath. And what they said is that we need a statute that says you can always use perjury. Now, what Senator West's bill is doing, 236, is saying to perjury, we're going to include forgery. If you purposely forge some document and get convicted, there shouldn't be a 15-year limit. It should be unlimited. And that's all we're doing here on 236. Thank you very much.
Excellent. Thank you very much. All right. I remember Judge Dumais, then Delegate Dumais, had a bill on, was it on perjury? Was it, what was that bill? I don't remember. All right. Do the research. This sounded eerily familiar. All right. So with that, that will conclude the hearing for Senate Bill 236. We'll now move on to Senator Sidnor, Senate Bill 295.
Right. Good evening, Senator Charles Sidnor on behalf of Senate Bill 295. Senate Bill 295 provides state's attorney the authority to seek a sentence modification during a person's incarceration if it's in the interest of justice, something that currently doesn't exist under Maryland law. In recent years, California, Washington, Oregon, and Illinois have passed laws similar to this. 295 empowers the state's attorney to seek review. Further, the state's attorney would need to feel that in the light of all of the factors, it would be in the interest of justice to file this particular motion. It has been argued that the ability to reduce a sentence like this legislation seeks is already available under Maryland Rule 4-345. This is true in part. However, the court is only authorized to do this to correct an illegal sentence. Senate Bill 295 goes beyond illegal sentences and focuses on justice. Additionally, Maryland Rule 4-345 allows the court to revise a sentence in the case of fraud, mistake, or irregularity. However, this revisory authority is limited and must be used within 5 years of sentencing. Senate Bill 295 allows courts to reconsider when it is, again, in the best interest of justice to do so without an arbitrary limitation. To determine whether to reduce an incarcerated individual's sentence, Senate Bill 295 states that the courts may consider certain factors. Those factors include disciplinary and rehabilitation records, evidence that age or diminished physical condition or their time served indicates a reduced risk for future violence, and evidence that demonstrates changed circumstances warrant a reduction of sentence and demonstrate that continued incarceration is no longer in the interest of justice. Senate Bill 295 provides state's attorneys an important tool to address the issue of disproportionate and unequal sentencing, or where a strict mandatory minimum sentence is inappropriate. As the law evolves, case review is of the utmost importance and can help deserving Marylanders currently in state prisons. As such, I urge you to vote favorable for 295.
Good evening, Mr. Chair, members of the committee. I'm Doyle Neiman, I'm Assistant State's Attorney in Prince George's County. Speaking on my behalf, as well as that on the State's Attorney, Aisha Brayboy, who was scheduled to testify but is ill today. House Bill 330 fills a gap in our system. The Senator mentioned Rule 4345, which allows for reconsideration, and is fundamentally the only place that allows a reconsideration of a sentence. You'll hear about all sorts of other things. Those are not reconsiderations of a sentence. They're sort of vacating a conviction or changing a conviction. So, but Senate Bill 4345, Rule 4345 expires after 5 years. But people change. People get long sentences. People were sentenced in the past before the 5-year limit were put in place. They're no longer the people they are today. I'm in charge of the unit in Prince George's County that handles sentence reviews. This is a critically needed function because people change and situations change. Now, this bill is narrowly crafted. You could say this is the conservative compromise. You'll hear people wanting to go further than this, who support this, but they want to go further. This bill makes the state's attorney the gatekeeper. It addresses 2 criticisms that came out of other proposals or second looks. One is there would be a flood of cases that everybody, the 15,000 people who are incarcerated in the state of Maryland, a third of whom have sentences of more than 15 years, that they would flood the system and overwhelm it. That's why the Court of Appeals, now the Supreme Court, did not change the rule despite a recommendation from the Rules Committee. It also addresses the reluctance of state's attorneys. You'll hear them, they don't want it. Well, they don't have to use it. This is only enabling for those who want to do it. My jurisdiction is certainly at the top of that list, as are some others. It is a tool that can be used. So I urge you a favorable vote on this measure.
Good evening. My name is May Lim. I am the National Policy Manager at For the People. We are a bipartisan national nonprofit that supports prosecutors who are evaluating certain sentences that may no longer be in the interest of justice. Our organization is led by Hillary Blount, who is a former prosecutor who in 2018 wrote and helped pass the nation's first prosecutor-initiated resentencing, or PIR, law in California. That law is very similar to Senate Bill 295, which gives prosecutors the discretion to look at certain sentences that may no longer be in the interest of justice. These may be sentences that were reasonable and appropriate at the time of sentencing, maybe 10 or 20 years ago, but now may no longer be just today, given changes in sentencing practices and new research that we now have available. In the last 3 years, additional states have passed this law: Washington, Oregon, Illinois, and Louisiana, and 7 states have proposed the bill, ranging from states like Texas to states like Massachusetts. Each PIR law protects victims' rights to be notified and to be heard in the process, and the judge then makes the ultimate decision, which ensures a system of checks and balances. Like other laws, Senate Bill 295 is discretionary, so the state's attorneys can choose to opt in or they can choose to opt out, and they can make decisions that are best tailored to the communities that they've been elected to serve. Across the country, we've seen prosecutors from across the political spectrum opt in, and from a wide range of counties, from large, small, rural, urban. PIR laws do not replace other release or review mechanisms like commutation or parole, but rather they serve to complement those other systems by giving the prosecutor and the court a tool to ensure that sentences are just, both at the time of sentencing and years or maybe even decades later. The bill ensures each prosecutor goes through a methodical review process for each case before moving forward. In the last 4 years of implementation, there have been about 600 people who have been resentenced. So as you can see, the approach has been measured and careful, but the impact has certainly been very meaningful. Thank you, Senators, for your time.
All right, seeing no questions from the committee, thank you all very much. Thank you, Senator.
Thank you.
All right, we'll keep moving on. Is Mr. Giannetti here? Ms. Hanson? Ms. Kirsch? And Sisenti, Mr. Sisenti.
The gentleman is coming.
I've been volunteered. Thank you, Ms. Hanson. Thank you, Chairman Smith, members of the committee, and thank you, Senator Sidnor, for offering this bill. My name is Brian Siseni. I coordinate the representation of public defender clients on motions for reduction of sentence under the Juvenile Restoration Act, which this committee, this body, this legislature passed a couple years ago. The Public Defender's Office supports this bill because there are, in some cases, very good reasons to reduce a sentence. And this gives state's attorneys' offices the ability to seek a reduction when it is in the interest of justice to do so. Now, our concern, frankly, is that this bill doesn't go far enough. We believe that it is important to have, in certain circumstances, defense-initiated motions for reduction of sentence. But that's not what this bill does. It's very clearly not what this bill does. It only gives authority to the state's attorneys. And we support it because it will do some good in some places like Prince George's County, where they are looking at sentences and whether they still, whether people still need to be incarcerated for as long as they have been. One of my, well, I guess what I find mystifying is the fact that you will very shortly hear from state's attorneys who have lined up to oppose this. And these very same state's attorneys come before this committee every day asking for more power to punish, more power to punish more people for longer, for more things. And all this bill does is the ability to give them the ability, the discretion to temper punishment with mercy. So if they want this committee to give them the power to punish, why not also the power to exercise leniency and mercy to give second chances? So for all those reasons, we support this bill and hope to be back in front of you at some point to talk about defense-initiated motions for reduction of sentence. Thank you.
Hi, my name is Ann Bocchini Kirsch, and I am Director of Advocacy for Prepare. We are a parole advocacy organization, and we support this bill, but with With amendments, the amendment that I'm looking for is data. What I'm afraid of when I see something going into the hands of just the state's attorney is that we don't have any way to really see what's going on. So we're talking about a way to right historic wrongs. We're talking about a way to look at long sentences that have no other way to be looked at, because actually parole is powerless in many of these cases to help. As long as Correctional Services Article 7301D3, which is the life without the possibility of parole, stands, these cases are not in the purview of parole all the time, which means that you have a group of people that has no way to have a second look. I like this bill because it allows, and I've seen it work in Baltimore City, I've seen it work in Prince George's County. It allows people to take a second look, which doesn't mean to release the person from prison, but it means to look and see, maybe did we make some kind of historic mistake in the 80s or the 90s when technology was different, when the culture was different, when we know people made mistakes, and without blaming and pointing fingers, we can just fix that mistake and give this person their life back. That is so critical. But it's also so critical that we make sure that that goal is what's actually being served. So as long as we have something that is solely in the power of the state's attorney, which is someone who has been part of an adversarial process up until this day, and now we are engaging them in a collaborative process. So let's take a look at how that works. Let's gather the data and the information that we need to make sure that we're moving Maryland in the direction that we want to move Maryland in. And I thank you for considering my amendment.
Good afternoon, Mr. Chair. My apologies for missing supporting your bill a couple of bills back. Nicole Hanson Mundell, Executive Director of Out for Justice. For the record, we too support this bill with both my colleagues' amendments and the Office of Public Defender's amendments. I don't know if did you all submit your amendment? Yes, so defense initiated option, right? And generally Out for Justice would not be here, advocating to give the state's attorney any additional tools. We too feel like the state's attorneys have more tools than they need to penalize your residents. But they're right. This is an opportunity for us to be on the same side and give them a tool to actually consider individuals who have shown tremendous progress behind those walls. And it is really, really hard to do right behind those walls, given the limited access to resources, given safety concerns. But we do have members who've done phenomenal behind those walls and deserves a reconsideration. And so for those reasons, I ask the committee to vote favorably on the amendments.
Sorry, thank you very much. Seeing no questions from the committee, thank you all very much. Thank you. We'll now switch to the opposition panel and we'll hear from Mr. Gibson, as Mr. Kroll, Mr. Algio. Okay. What about is Mr. Shell? There you go. All right. And is Billy Catstiff still here? Is he? Okay, got it.
Victim of Valentine's Day.
I know. No.
May I? Good evening. Thank you for the opportunity to address the chairman and the committee. My name is Rich Gibson, State's Attorney for Howard County, President of the Maryland State's Attorneys Association. Again, I've been a prosecutor for 19 years, and I'm here today to oppose the bill. We took a vote. 23 to 24 do not want this power for several reasons. One is we interact directly with victims, and there already is a great deal of uncertainty when resolving cases, when dealing with them, when talking with them, and discussing with them outcomes. And that's because there really isn't truth in sentencing in Maryland related to outcomes that we have. And they ask how long is the person going to serve. We can't even answer that question well right now. And this would only exacerbate that issue. Additionally, this bill, if passed, has the potential to both monetize and exacerbate the politicization of the attorney's role. It is possible that some wealthy donor could literally fund a campaign for an individual to run as its attorney with the goal of granting in the interest of justice a modification of a loved one's conviction, and that's a problem. Additionally, we are not a parole commission. Parole commission serves a particular role. We don't serve that role, and they serve a function that is important, and we should not assume that role. Finally, there was discussion about mercy and prosecutors. I want to address that. We aren't just blindly charging cases. We exercise our discretion deciding what to charge, when to charge, if to charge at all. And there is mercy that we exercise when deciding what to do in a case. The idea that there's no mercy in the system is just flatly incorrect and not what I've seen in my experience. However, once a person has been sentenced to a particular outcome, those victims deserve a degree of finality, a degree of certainty in that outcome. And there are numerous mechanisms to modify a conviction: motions for judgment of acquittal, motions for new trial, habeas corpus motions, motions to vacate judgment, writs of actual innocence, motions for modification of sentence, motions for post-conviction relief, and coram nobis motions are all available to defendants who wish to try to undermine their sentence. And for all these reasons, the state opposes this bill, and we hope that you will give it an unfavorable report. And I look forward to any questions you might have. Thank you.
Good evening, Scott Schellenberger, State's Attorney for Baltimore County. I should have gone ahead of Mr. Gibson because that's what my written testimony is about. So a crime is committed against you or your loved one. You see somebody is arrested. You start talking to the state's attorney. You finally, after a year, go to court. Finally, after a couple of weeks, the jury comes back guilty. 3 months later, the defendant gets sentenced and the victim goes, finally, it's over. Wrong. Motion for new trial, motion to modify or reduce sentence. 3-judge panel, appeal to the Court of Appeals, ask for an appeal to the Supreme Court. Post-conviction, you can have more of those, more than one. Writ of coram nobis, writ of habeas corpus, writ of actual innocence, that just came back a few years ago. Motion to vacate judgment, just passed last year. Post-conviction DNA testing, that was passed in the last couple of years. And then we moved to the parole system. And now you have a new state's attorney in office and they say, I think I'm going to take a look at all these cases and start bringing people back. There's no finality. It just never ends. There has to be an ending at some point. And the question was, why do the state's attorneys always come down here and ask for the power to punish, and that the other powers punish is my job? My job is to do the right thing all the time, and that's what we do at the beginning and during the case. But it's also to protect the public. And this is unfair to victims and witnesses because it will bring folks back. And of course, the bill goes in as only the state can do this, but guess what's coming? We already heard it. They want the power of the defense attorney and the defense bar to be able to do it also. So even if you don't do that this year, it's coming next year or the year after that. And therefore, we don't want this. We don't think we need it. We think there are enough laws and avenues for folks to get help. And I urge an unfavorable report.
Mr. Chairman, members of the committee, Mr. Schellenberger said he didn't speak very often and he didn't today. I think it's my first time I've spoken today. So welcome to the committee. Good evening. I'm Stephen Kroll, the State's Attorney Coordinator, the Executive Director of the Maryland States Attorneys Association, and I'm here in opposition and I ask for an unfavorable report to Senate Bill 295. What didn't the proponents mention at all? Victims at all. Not one mention about victims because they don't care about victims. And quite candidly, the bill is anti-victim. The victim has no right to appeal. The victim, according to Mr. Schellenberger, and I counted on my fingers 16 times, a defendant can come to court and try to get his or her verdict modified. 16 times that victim will have to appear post-sentencing. Big donors to get their friends out of jail. The indigent defendant in jail is stuck. It puts politics in the process. Passing this bill puts politics in the process. Please don't do that. The defendant will appear before a new judge who may not know the case from the victim or the witnesses. Every 3 years, the victim has to come back. It's just not fair to victims and witnesses. In conclusion, we ask that we asked for an unfavorable report as to Senate Bill 295, and we're happy to answer any questions. Thank you. It's a long time sitting before you get a chance to speak.
Thank you, Mr. Chairman. This is to anyone who wants to answer it. We spent 3 or 4 hours on earlier today on Senate Bill 290, and it was all predicated on the fact that we should trust not the Attorney General, but we should trust the elected state's attorneys in the local jurisdiction. Now, on this bill, the antithesis is being said as I hear it. They may get elected and decide to do A, B, and C. So now we're saying, don't trust their judgment. So I'm not really sure how to take the testimony. And maybe you can ask, is this an enabling legislation? In other words, does it force a state's attorney to do this?
So two-part question. I'll answer the second part first because it's faster. So it doesn't force us to do anything. It gives the ability to do something.
It gives the ability.
Right.
So if 23 of you say no, and we say, great, you can say whatever you want because we should trust you. The people elected you and the people trusted you.
Mm-hmm.
Well, they also elected that one who disagrees.
Mm-hmm.
And we said, if they don't do, all of 290 was predicated upon, and if they don't do what's right, the people will remove them in 4 years.
Mm-hmm.
And now we're coming in, we're saying, on this, we don't really trust our state's attorneys to make the right decision. Yeah, well, he did, because what they said was, what they just said was, number one, if a new state's attorney is elected and comes in and decides that they're going to review other cases, that it's political, it's wrong. They also said there will be some influenced by big donations to become elected. So yes, in my mind, that's exactly what you said. So either we trust them all or we don't trust them all. We can't go back and forth, but be that as it may, if it's enabling legislation, you said it. All of you said it. Every jurisdiction is different. What they see as right in Howard County, we may in Prince George's County see our situation as different, and we elected them.
Yes.
Why does that not apply here as it did to 290? And
Sure, absolutely. Thank you. So the two bills are distinguishable for the following reasons. In 295, the argument we're making is the state's attorney who is new, that doesn't necessarily have reference point of the actual case,
but still elected by the people in that county.
Yes, if I may, the state's attorney who is new, who is not familiar with the case, may not have access to the victims, may not have knowledge of the actual underlying facts, and is rendering an opinion about the outcome of that matter, is not in the same position as the person who actually handled the case. The other point related to the politicization and monetization influencing our roles is distinguishable because it relates directly to, I'll use an example to highlight it. Wealthy business owner's child is charged with an offense and convicted, right? And wealthy business owner decides, I want to get my kid out. Wealthy business owner has the ability to go to local attorney who's not even interested in running and say, look, I'll fund your campaign. I'll set up a PAC and give you all the money you need to run. And all you have to do is when you get into office, in the interest of justice, grant my child, who I love, a modification of sentence. And so you have created this bill. I don't believe it's the intent of the bill, but the unintended consequence is the potential for money and undue politicization of our roles, right? Our roles are political, but it's not to that extent where you are buying justice. And we should never have justice be something that is a commodity that can be purchased, and that undermines the fairness in the system. And so for that reason, among others, we oppose this bill.
well, and I'll stop with this. We just had the turnover of some state's attorneys. In Baltimore City,
a quarter of us turnover.
In Baltimore City, the new state's attorney who came in decided that he was going to, I think it was in a matter of 2 months, review a case and release someone, right?
Yes.
Okay, that's what he did. Would we be impugning his integrity about that? Because the only example that you're using, anecdotal, which says, well, they could be paid off, they could be, and it's just all day you've been saying two different things. In my opinion,
I understand.
you have two different things, because now you're saying, do we have a right to question? Do I in Prince George's County have a right to question what the Baltimore City State's Attorney did? But he just did the same thing.
There's a distinction.
He just did the same thing.
It's not the same.
Why not?
Because in one instance, the person wasn't convicted. They were charged with an offense and pending charges. In the other instance, they were actually convicted, found guilty, and you're just now coming in and saying, I decide on sua sponte on my own, rid of modification.
So I can trust his judgment on that, but in other situations that you're bringing up about new people, you're saying this has a potential to happen. I just don't.
No, I disagree, Senator. In one instance, you have a person whose guilt has not been defined yet.
I
And
understand.
in another instance, you have a situation where a person's guilt has been defined. Two different animals, completely.
But the same person, I respectfully disagree, because you have the same scenario set up. A state's attorney should be able to do what they were elected to do and what they want to do in the jurisdiction, only judged, as you said, all day by the people in that particular jurisdiction. So we don't need oversight over this. We don't need oversight. It's a different scenario, but same thing applied. Thank you. Okay, thank you.
I was gonna say, well, if you had that, if you were bribed, it would be public corruption, and who would prosecute that?
So
The Office of State Prosecutor.
that
would
would
just stay
be
away.
the Office of State Prosecutor.
No, I'm sorry, man. I couldn't resist. I'm sorry.
About the bribes, Senator Smith.
Yeah, I know.
It's a little difficult to do.
I get it. I'm just, Office of State Prosecutor's already got it. All right.
Thank you all.
Senator Folden, then Senator James.
So, thank you, Mr. Chairman. How 23 of 24 state's attorneys are opposed to this?
Yes,
Who
sir.
was in support of it?
State's Attorney Aisha Braveboy of Prince George's County.
Prince George's County. Okay, and then isn't there already a process in place to facilitate the release of an inmate?
There's to answer that question, there's numerous processes in place depending upon the particular argument being generated.
So if they've gone through the appeals process and they're serving a sentence and they get to a certain point with their DIM credits and everything else, isn't there a process in place?
Yes,
already?
that's called the parole commission.
The
Yes.
parole commission?
Yes, yes.
Are
sir.
the parole commission, are they elected?
No, they're appointed.
They're appointed. So we already have a mechanism in place to facilitate this resolve we're asking for.
Yes, sir.
Okay. In addition to the other
Legal
multiple legal arguments that can be given. And then, and what exactly is the role and responsibility of a state's attorney?
Our job is to pursue the truth and to ensure that we are holding the people in our community accountable, whether it be police officers or the community members itself, to make sure that we follow the laws and we execute the laws in a fair and just way.
And you're the responsible party that prosecutes crimes within your jurisdictional boundaries.
Yes, sir.
Is that correct?
Yes,
That's
sir.
your responsibility.
Yes, sir.
It's an important responsibility because you're looking at things through the optics and the lens of, like you said, fairness and also, but being accountable for one's actions. And that is a part of this as well, correct?
Of course.
Once that trial is completed and there's a sentence or there's a conviction handed down, there's a sentence that comes out. Who does that sentencing?
The judge.
So the judge does the sentencing.
Yes, sir.
So when the judge does the sentencing, it has no direct contact with the state's attorney can make a recommendation prior to sentencing as well as the defense attorney, correct?
That's exactly what happens.
And then, so to not request or to request a review, it seems to me, and correct me if I'm wrong, but it seems to me that it would be wholly inappropriate to have the state's attorney, an elected body, go in and then thereby on their own accord, after their office has been the one that prosecuted the case, to come back sometime later and be like, you know what, I think the judge was a little too hard on this, or the judge got it wrong. we need to make this not such a heavy sentence. And don't they have that opportunity at the time of sentencing to request a shorter sentence if they want to?
Absolutely, and we do. There are times when we will advocate for less than the maximum sentence because we don't think the maximum sentence is warranted.
So does it seem to you, perhaps, that it would be wholly inappropriate to then basically, as our good, the judge that was here earlier, Judge Hurd came out and said, it wouldn't, by virtue of this, doesn't this in a way become an opportunity to usurp the judge's authority?
So I think that I more liken it to the parole commission than the judges, but I understand your point.
Your job is to prosecute the case. You get a conviction, your job is to make a recommendation for sentencing.
Yes.
The defense attorney or the PD, their job is to defend their client.
Yes.
Their job, if a conviction is handed down, is to make sentencing guidelines. To mitigate that, correct?
Yes.
Then the judge, a separate element, separate from you, separate from the AG, separate from everybody else, makes their rulings on the severity that they feel the crime and the resultant punishment that should be associated with that crime.
Correct.
Correct?
Correct.
It would be in direct conflict through you can go through the appeals process, but it would be in direct conflict with the process that has been in place for hundreds of years to then have the state's attorney go back in and say, you know what? We think the judge was wrong, so we want to change. Are you not cutting the judge's authority in their purpose within the legislative process?
Yeah. Yes.
Okay.
Yes. It's so that was my hesitation. We're requesting. This would give us the power to request a hearing based upon our desire to modify judge's action.
Correct.
One of our principal issues, again, is that in Maryland, when we talk to our victims, it's one of the most challenging things that we have to do. When you're looking at a family member of someone who's either, their family member was raped or murdered or just some atrocious thing happened, and you're trying to explain to them what the outcome is. They ask, what's going to happen? What is the sentence?
Yeah.
And our answers are not satisfactory frequently because it is so indeterminate despite having a given number attached to it.
So I'll just close out with this. Isn't it true that generally speaking, that there is one last process that we haven't spoken about yet, which is there's a whole lot of letters that get crafted and sent to an outgoing governor.
Of course.
And that governor has the authority to do what?
Pardon.
To pardon them. They can look at the complexity, the dynamics of the case, and they have the overriding authority over all of it. Do they not?
They do.
Okay, thank you.
You see what I'm saying? I'm sorry, let me defer. Good.
And guess what you all did just last year? In life sentences, you took the governor out of the ability to prevent a parole. So you take the governor out. Now we're just with the parole commission. And now we're going to go right back into court one more time. You get denied at parole commission. Now we're going to come back into court 20, 30 years later and say, I've been a good boy. The parole commission won't let me out because of the way I've been behaving in jail. And now I want the state's attorney to ask the judge to let me out. And so all we keep doing is taking away powers. And Senator Muse, to respond to your first statement, it wasn't that we didn't trust the attorney general. We trust the attorney general greatly. And so I don't want that. Yes. So it wasn't that we don't trust the attorney general on that first bill. It's that we believe the power should be with us. It's not that we don't trust them. So
the lines of argument and the consistency of the logic is like, you're talking about depoliticization, and then you're mad about the governor being out of parole, which is depoliticizing that process. But okay.
Touche.
Yeah. All right. Senator James, let's go. Let's get going.
Covered a lot of it, but not quite the way I would. And I just want to make sure that I kind of understand this. It looks to me like in order for you all, if you were ever to avail yourselves of this, you would have to know an awful lot about this inmate. You would have to know their disciplinary records, physical condition, circumstances that have changed. So to me, one of the challenges would be that this is out of your expertise, out of your lane. we want you singularly focused on the job that you do. Am I not correct about that?
You are correct. You are
'Cause
correct.
I've never heard of any state's attorney sort of having this information. And then if you didn't have it readily available, you'd have to take a lot of time and effort to obtain it, all of which would take you away from, and you all are overtaxed, everybody's overtaxed. So I have an issue with that, but I also think that, let me ask it this way. If a state's attorney was aware of this information or other information and felt greatly moved that they wanted to involve themselves in some way to give somebody a chance to seek a reduction in sentence, is there anything that prohibits you from assisting in that process?
No.
So in other words, this is not a mandatory bill anyway. So you don't have to avail yourselves of it. But if you were so moved without this law, you could engage in this kind of work if you wanted to.
In fact, there's attorneys that have. So we
Right.
have the ability to reach out to defense counsel. And we do that. That does happen on a lesser scale frequently. Like where we find something that, hey, you
Right.
should know this. We discovered this issue.
Yeah,
You
I've
should
read about
examine it
many
from
of
this
these
angle.
cases where it's extraordinary, and I'm sure this is the idea that something extraordinary has happened. But in those circumstances, nothing prohibits you, and then sometimes state's attorneys actually do this.
I
So
would
the
say
bill would
frequent-
almost
Yes.
I almost think the bill's unnecessary in the fact that you already have this ability. If the circumstances warranted, you could assist or bring something forward through one of the other mechanisms, and the person could seek a reduction.
Absolutely.
Okay, that's one thing. The other thing that, hold on for a second. My ears perked up because I'm not as familiar with this, but I heard you all and others say they were worried that this was really a strategy or could lead to an additional kind of bill that would allow defense counsel or somebody else to get involved in this process. Could you elaborate on that?
So the proponents of the bill, when they testified moments ago, indicated that they would be back in the future with a request to expand this to defense counsel. In essence, it would allow defense counsel to sua sponte or just of their own violation, file a motion for modification for a defendant who's been actively or is being actively incarcerated.
But I'm gonna guess that your response would be that given so many different ways a defendant can now seek a reduction in his sentence, the defense counsel already have just as many ways a lot of ways to avail themselves if they want to work with a defendant to seek a reduction.
Yes, we are, just to be clear, we're for justice. So we're for, if someone is actually innocent or is wrongfully convicted, we are for getting them out as fast as possible, provided the evidence supports their innocence. Like that is, no one wants, and every prosecutor fears the idea of incarcerating someone inappropriately. That is something that we, are vigorously aware of and guarding against. For someone who's rightfully committed, they committed a wrongful act and they've been punished for that act, and this punishment has been met out. There are numerous avenues upon which to collaterally attack, which is to undermine the actual guilty conviction that are available to defendants who are incarcerated. And we don't believe, we're not asking for, nor do we want the power to sua sponte on our own decide that we're going to reduce a person's sentence.
Right, but just as I indicated, there are ways in which you could get engaged in the case if you thought it was compelling
Absolutely.
enough. So you have that authority also. Okay, thank you very much, Mr. Chairman.
Thank you, Senator Carter.
Thank you, Mr. Chairman. So let me correct something that was said earlier. I don't conceive of the job of the state's attorney to get convictions. The job of the state's attorney is to do justice.
Yep.
At the end of the day, what you have to do has to be just.
Yep.
And merely putting someone in jail in an unjust way, or who should not be in jail, should certainly not be the paramount objective of the state's attorneys.
Absolutely.
So I'm a guy who almost always supports state's attorneys. I'm looking at this bill. It says the state's attorney may, it's a discretionary, may file a motion for reduction of sentence. And then the court may reduce the duration of the sentence after considering certain factors if the court determines that the interest of justice would be better served by a reduced sentence. So for a state's attorney to invoke this, the state's attorney must himself or herself believe that the interest of justice would be served by a reduced sentence. Without that predicate, you wouldn't use this. And we can come up with 100 different hypotheticals of why a state's attorney might come to the conclusion that in a particular case, the interests of justice would be better served by a reduced sentence. Well, we don't have to go into this hypotheticals this evening. Let's just assume hypothetically that you have come to the conclusion that the interests of justice would be served by a reduced sentence. So I'm looking at the scales of justice here. On the one hand, you have the victims and the victims' families who might feel unhappy, victimized again, if the state's attorney were to go in for one of these sentence reductions. On the other hand, you have to weigh the fact that in the interests of justice, the sentence ought to be reduced. Again, you wouldn't pursue this unless you felt that in the interests of justice, the sentence should be reduced. So tell me why in the world, given those two factors with the scales of justice, you should opt to leave the prisoner in jail, which you believe is not in the interest of justice, for the sake of not causing hardship or unhappiness to the victim's family.
Sure.
I'm very sympathetic to the victim's family.
Sure.
But if it's a question between that and having someone in jail unjustly, I'm sorry, I opt for the latter.
So I want to be very clear. I never said that our goal was getting convictions. I don't know if anyone else said that, but I certainly didn't. But
so I think Senator Fulton asked someone.
So our objective is to always do justice. And here's the issue, right? The prosecutor who handled the case, who's most intimate with the case, who understands the victims, understands all the nuances of the case, studied this thing, learned it inside and out, so that if necessary, they can present it at trial, has the deepest and most direct connection to that case. And they've sussed that out at a granular level already. They've already determined at the charging stage, right, what justice looks like for this particular outcome. To come in,
given the information available to the prosecutor at that time.
Correct.
But again, we talked about 100 different hypotheticals.
Correct.
You could have the two key witnesses, witnesses come in and say, we perjured ourselves. And you conclude that you couldn't possibly have prevailed in the case. You couldn't have won beyond a reasonable doubt.
But there's another avenue for that. So there's, right, that's just it. There's other avenues for that. So you don't, so that hypothetical.
I'm coming up with hypotheticals, but
yes.
But through one of these hypotheticals, you have concluded, you, the state's attorney, not the prosecutor, but I'm sure you've consulted with the prosecutor, have concluded that in the interest of justice, this sentence in this case ought to be reduced.
So if there is information that the person who's been convicted is wrongfully convicted and properly in jail, then we have an obligation to take steps to notify the defense counsel to get them out, right? And we can do that right now, all right? So there's no.
So you're saying you don't need this? There
Correct.
are other options right now which would cover any one of those hypotheticals, which would get the defendant out, and not get out in 5 years, but get out in short order.
Yes, if there's a writ of actual innocence, there'd be a hearing, right? So there's a court proceeding. Right.
Well, this might not be a writ of actual innocence situation. You had a lot of evidence that was introduced to the trial.
You're hypothetical.
Two key witnesses have now recanted, but there's lots of other evidence there. You believe, in fairness, that if the two witnesses had not been at trial, you never would have succeeded in getting a conviction beyond a reasonable doubt.
So if the two key witnesses recanted, and
so that's not actual innocence, right?
Well, it depends on the nature of their testimony, how integral it was. If you're from your hypothetical, you're saying that there is no conviction absent these witnesses, and they're coming in now saying it didn't happen that way, it happened this way, right? Then there is an avenue, and look, the state would join. What would happen is that we'd give the information to the defense counsel, and we'd say, just so you know, we're going to join you in this request that we wouldn't argue. We're not going to just rest. We're not going to make no argument. We would join in the request of defense to have this person released, based upon the fact that the evidence that was provided previously is now found to be completely and wholly unreliable, not credible, and inaccurate. That's I'm working with a hypothetical you created, Senator.
Yeah,
so
right.
obviously different hypothetical, different answer. But with that hypothetical you created, that is the answer to that question.
So it's getting late, but so let me just ask you to do something for us.
Yes, sir.
Could you send us a text, an email or something, which would illustrate 2 or 3 possible scenarios in which this bill, an honest state's attorney could take advantage of this bill, determining that the interests of justice would be served by a reduced sentence that you could not accomplish in any other way. And if your answer is we could accomplish any scenario through other procedures available to us, let me know that too.
It's already in your written testimony, so I already provided that to you. But yes.
So that any possible scenario you could come up with can be dealt with the existing law. That's what you're saying.
Yes. To my knowledge, I've been doing this 19 years and in multiple jurisdictions. I can tell you that there are numerous mechanisms by which we could effectuate getting someone out if we felt that there was an unjust action that occurred. It's different than, and that is different than just I now as a second look person feel differently about the case. That's a different animal. Like if I just on my own second look feel different, that's not what we're talking about. We're talking about evidence that contradicts and undermines our faith in the actual legal outcome.
And let me just finish by imploring the people who testified in favor of this bill, who know what they're talking about, to provide us with information about situations that could occur in which there's no vehicle currently available which would get that prisoner out of jail. Okay, thanks.
Thank you. Not that I'm attempting to rehabilitate a witness, but given Senator James's question to you all, just listening to the line of questions from Senator West, I feel that the witnesses that I brought up are essentially being called liars.
Oh.
And that their testimony was false. Mr. Neiman came up and he said that there are cases where current law don't provide the ability for state's attorneys to do this. In his written testimony, he said, this bill addresses a real and long-standing gap in our criminal justice system whereby the courts are precluded from reviewing sentences once review has been denied, and in most cases, once 5 years have gone by at exactly the time when review may be most appropriate. I believe there was another person who had testified talking about cases where you can't be paroled. So again, I want to make certain that me and the rest of my colleagues that we're hearing, is your testimony in front of us today that this bill doesn't offer anything that you all can't currently do?
No, that's not, to be clear, it's not what was said.
Okay, that's
right?
that's
What was
that's
said-
a response. That's my response. I'm looking for.
No, I want to clarify the
So-
answer you gave Senator Sidnor. All right. So to be clear, the question that was posed to me was a situation where witnesses were found to be liars and they told an untruth that they're now coming clean about, which undermines our faith in the conviction. In that circumstance, there are adequate tools that exist today. This bill creates a blanket power. The new state's attorney looking at it decides, I think that this conviction's too long and I'm going to let you out. I don't want to say random, and I'm not calling anyone a liar. I'm saying that the ability to sua sponte for any reason at all, decide in the interest of justice that this defendant should be granted a modification and I'm going to initiate it is a new power, a power that we don't want. What was testified to, what I said was, if there are facts which come to light that undermine the conviction, we have the tools to make that right.
Does this bill allow the defense to file a motion for reduction of sentence?
No, this is purely for state's attorney, from my understanding.
I just wanted to be certain that was clear to my colleagues as well, because some of you all had some of your witnesses were testifying to something that's not before us. And I just wanted to make certain that we're clear there as well. Thank you.
I think some of the proponents did say that they might want an amendment to that effect. All right, but it is not the bill. You're right. Senator Folder.
Mr. Chairman, I don't want to belabor this any longer than we already have, but I feel necessary to clarify a few points. One is, I said their job is to be the prosecution. And if a conviction or when a conviction is found, that is the appropriate time that there's mechanisms in place for the sentencing. The other thing I want to point out is, I don't think that it was appropriate to impugn people's integrity who are elected officials coming here saying that someone else was basically saying they were lying. There was none of that that happened. So I think that that was wholly inappropriate for that line to be stated in the committee when there was no such reference, and making a jab at these people coming down here and their integrity is wholly inappropriate. Isn't that true? Thank you.
Certainly, since it was raised, again, what's inappropriate is coming at my witnesses and not defending my witnesses.
I just want to be
All right,
clear.
guys,
I
all right.
never attacked any
No one-
people
yeah.
here.
All right, I don't want to spiral. I understand. It is not appropriate for anyone to impugn anyone's character either way around. And for a witness to come up and impugn the character of someone that came prior, or for anyone of this body to impugn the character of anyone before. I think the way he was framing it was that he was saying that the testimony was an opposite, and it seems like you're saying that it's wrong. So
His bill sitting there impugning their integrity, saying that they called it hard.
I didn't perceive it to be that way. So let's move forward. But I appreciate you all being here. Thank you very much for being here.
Thank you. Thank you.
for me.
Appreciate it.
You all know that this committee and I have the utmost respect for the work you do and for your presence here in public service. So,
Thank you. Thank you.
and
Have a good night.
and I know it was not the senator's intent to do that. So, all right. With that, I think that concludes the hearing and the testimony for Senate Bill 295. We'll now move on to Senator Carter with Senate Bill 285. Senator Carter, you're up.
Happy Valentine's Day, JPR. I appreciate your patience. I know that romance awaits, at least I hope it does for some of you. I'll try to make this brief and interesting. It's a really important bill, and I know the hour is late, and I hate that it is, but it is what it is. Okay, I have a panel that I'm asking to come up. My panel on this bill is Davon Love, Beverly John, Yanet Emmanuel, and I think I have the wrong name from the Office of the Public Defender, but if there is someone from the Office of the Public Defender here in support, you're welcome to come up. I had Deborah Levy, but I don't think she's here. Let me just start by speaking from the heart, and then I'll go into the details of my testimony. Mr. Chairman and members of this committee, oftentimes we say here in Annapolis that when people are on two sides of an issue and neither side is happy at the outcome, then we've done good work. Well, sometimes that's true, sometimes it's not. But one of the things that's super important is when we went through the laborious work of police reform in 2021, we did some significant work when it came to accountability, transparency, dealing with the disciplinary process. But we omitted a super important part of it, which is the concept of real civilian oversight. When I came back to the Senate from life outside of being in an elected office, I had worked for years with the Baltimore City Civilian Review Board, and that board had power to investigate police claims of complaints of police misconduct, and it also had some subpoena power. And when I came here, I thought it was a natural progression that we would enhance that type of power. And so we go about the business of creating House bill passing the law 670 in 2021 with the, I thought, legitimate intention of enhancing that civilian power, but we didn't. We actually have limited by the police accountability boards not having any authority to have investigatory powers and subpoena power. And so earlier today, the Attorney General spoke a lot about public trust and confidence. Well, one of the most significant ways that we can actually ensure public trust and confidence is give the public the real right and real ability to oversee the conduct of law enforcement in their jurisdiction. the very existence of civilian oversight serves to offer it to improve the quality of internal investigations. Under our current structure, even though we put civilians or non-law enforcement on administrative charging committees, we did nothing to further the cause of an independent investigation outside of what internal affairs does. So with that, I'm going to try to keep my testimony short because I think I've hit the points I want you to hear, and I want you to hear from the witnesses. But there are some really important things, I think, that we have to consider if we're serious about really wanting to improve the institution of policing. And honestly, if we're serious about wanting to ensure that our people, our constituents, have power and have trust and confidence in us and in law enforcement. So this bill closes the gaps that we left behind in the 2021 Policing Accountability Act. It also, by providing subpoena and investigatory powers, police accountability boards will not be forced to take police investigations at face value, but they will be able to investigate simultaneously with police internal investigations to reach the most honest and accurate response and to prevent and rectify misconduct. Instead of simply awaiting the results of an internal investigations from police, State's Attorney Ivan Bass talked about earlier how, and it's been referenced by members of this committee just now in the last bill, how he came in and he released someone named Keith Davis, who had gotten notoriety and had a whole movement behind, the claims that he was innocent and wrongly arrested to begin with, because law enforcement had shot at him 44 times. Well, let me just tell you, when I went to work in the Civil Rights Office, there was an ongoing investigation that the Civilian Review Board had. Internal Affairs had already dismissed it out of hand that there was no misconduct, but it was the Civilian Review Board, their independent investigatory power, that was able to come up with the result, the conclusion that law enforcement used excessive force. I think that's very significant. Had it not been for that Civilian Review Board's powers, that would have never come out. And that gave the public great satisfaction, trust, and confidence that there was some entity somewhere that they could depend on to investigate and make truthful determinations outside of law enforcement. I've said this before, but it bears repeating. The very concept of civilian oversight and independent investigations improves the quality of internal investigations. That is important because we cannot have true accountability if we restrict civilians' ability to have oversight of their law enforcement. This is an important bill. All it does is give authority to police accountability boards, as we passed, to have investigatory powers and subpoena powers. It does not give them the ability to stand in the stead of the internal administrative process, but to have an outside independent process. And I challenge us. I really believe that only if we allow this will we really see the results that we were striving for in 2021 with the other legislation that we passed. This is a critical bill. It's a critical concept. I think we owe it to the people of Maryland to allow this to happen. Thank you.
Good evening, Chair Smith and members of the committee. My name is Yanetta Emanuel, Public Policy Director of the ACLU of Maryland, here in support of SB 285. And just to clarify, this bill simply just allows local jurisdictions to give their local PABs independent investigatory powers. It does not mandate it. It just clarifies that they do in fact have the authority to do so. You have a written testimony, and you'll hear from dozens of folks today about how critical these powers are to adequately hold police accountable for misconduct and establish trust between the community and law enforcement. So I will focus my remarks on addressing the opposition. First off, there is no provision in the Maryland Police Accountability Act that prohibits local bodies from giving their boards these powers either in place of internal affairs or parallel with them. Furthermore, the MPAA does not have any preemption clause that would indicate that legislators' intention was to bar this implementation of certain police accountability mechanisms and thereby preclude any local innovations or experimentation. Second, giving the PABs independent investigatory powers is not inconsistent with police agencies also having the authority, nor will it unequal the playing field. Baltimore City, like Senator Carter just pointed out, and Prince George's County Complaint Oversight Panel have had similar powers for decades. And although these boards have been significantly underfunded and under resources, the independent investigations performed by the CRB staff have proven to just show how critical it is to have an option of conducting independent civilian-led investigations into complaints. Beyond the increased trust and cooperation of complainants show the CRB investigators, the CRB and the Public Integrity Bureau disagreed in 26% of concurrent investigations. Finally, opponents may argue that giving PABs investigatory authority would undermine the uniform disciplinary process that HB 670 sought to create. And while there's no doubt that the legislators sought to create a uniform process, authorizing PABs to conduct independent investigations does not change the process in any way. It simply just changes the identity of the people engaged in one of the tasks that are in part of the disciplinary process. Taking the position that only the police can investigate the police would treat the repeal of Leo Bohr utterly meaningless. Allowing the PABs to conduct independent investigations, PABs could provide a greater likelihood that investigations will be meaningful and that the public will actually trust the outcomes. And for the foregoing reasons, the ACLU of Maryland urges a favorable report. Thank you.
Good evening, Chairman and committee members. My name is Beverly John. I am currently serving in the Prince George's County Coalition for Police Accountability, which, like many other counties, we are a community-centered coalition of organizations and individuals who will work with our county leadership in implementing HB 670 over the past year. During that exercise, we really came to realize why this particular bill clarification is so important from the state level, because we were very proud of the work that we were able to do with our county leadership in terms of crafting our own local police accountability board. And some of the things like, the membership, we were able to come to agreement on who should be on the PAB, staff and budgeting for the police accountability board so that it could be effective and have the resources that it needs to do the job that it is called to do. Unfortunately, this particular issue of investigatory powers and subpoena powers is really the crux of whether or not this police accountability boards across the state will be effective and successful in doing what we think and know is very important, which is building trust and confidence between the community and law enforcement. That trust and confidence has been broken. It needs to be repaired. And it's not just a perception of the fact. The facts are we have several hundreds of families with lived experience of having loved ones killed, seriously harmed, and traumatized without any accountability, without any recourse given to them. And this is what we see as a first step, in giving the community what it needs. And I urge for a favorable report on this bill. Thank you.
All right, good evening, committee. Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. All industries that are insulated from meaningful oversight are prone for corruption. And when you think about the importance of community oversight of law enforcement, which is actually one of the major policy demands that comes out of the civil rights and Black Power movement, the idea of the community having an independent instrument being able to investigate law enforcement, given the fact that, when we go to the ballot box, the contestation over the ability to deliver public goods, and one of those public goods is public safety. And so the community should have an independent instrument that allows them to engage in investigation. When you look at the DOJ report that I've referenced constantly, the Restoring Trust and Policing Commission from 2020, the Graham report, you'll see that there are lots of unsustained complaints that would otherwise be sustained if they were subject to public scrutiny. And so when you look at all those reports, there are reams of evidence of misconduct and harm that's been done, particularly Black and brown folks in our community around the state. I'm not talking about just killings, but just all the forms of abuse and misconduct that happen constantly that for many of us, we would consider criminal. And if we ask ourselves the question, well, why is it that this kind of violence can be so persistent? It is because there is not an independent mechanism that the community controls. The purpose of the police accountability boards, as they were in the Maryland Police Accountability Act of 2021, was to provide a community an instrument that they control to be able to address many of the concerns around police accountability. And so it's only, and even if you look at the Anton's Law, which made changes to the Maryland Public Information Act, making investigatory records of law enforcement discretionary disclosures, we're seeing law enforcement push back, charging people exorbitant amounts of money for the files needed to look at those records, making it difficult for people to get access, which shows that law enforcement feels threatened by the idea of the community having access to that information. So this is merely just one additional instrument that the community deserves in order to serve its proper oversight function of law enforcement. And every effort to do that, this, the General Assembly has been resistant to it. So for that reason, this bill is particularly important. I urge a favorable vote.
Senator Muse, you look like you're about to dive in, so. All right.
Questions? If not, I'll take my seat.
Seeing no questions from the committee, thank you all very much. All right, we will now hear from Ms. Morris. Ms. Morris here. Sarah Sample. Is Linda Davis here? And Stephen Waddy.
I have to go first, okay. Good afternoon, everyone, and thank you so much, Senator Carter. I'm Reverend Marguerite Morris, and I'm speaking on behalf of the Anne Arundel County Police Accountability Coalition, which represents 20+ organizations around the county, to include United Black Clergy. We support SB 285. Beginning in 2021, we fought like hell for strong boards. We watched many of you come forth with what you could give us, but upon implementation, there was confusion, there was ambiguity, and in some cases, it left counties with reasons to do the bare minimum. In our county, in this county, the one that we're in right now, and I really hope people hear me, I just want to say some things about police misconduct that are going on now, the ugly truth. We've uncovered that some of our local police misconduct, that some of our sons and daughters were being treated like cattle. Poked at roadside traffic stops in the dark by police. It's called subjecting them to illegal body cavity searches. One person equated this to sexual assault. Most likely, no police officer will ever pay for subjecting persons to such heinous acts. And this is a good example of police misconduct. As recently as this morning, I completed a spreadsheet of traffic stops for an officer that was selected as Officer of the Year, because he had championed in part for the most traffic stops. In this county, the 2020 racial demographics are 72.3% white, 19.1% Black. Yet this officer gave out over 1,700 traffic citations. 78% went to Black and brown persons. He was not patrolling a primarily brown and Black community. So in closing, this is for me personally. Some of you have heard me testify about my daughter, Kathy, who died in 2012. We challenged the handling of her death investigation by police for 10 years. Finally, in 2021, and in a victory that resulted in a judge issuing a 58-page opinion that we were right and that we were right, and to change her manner of death to undetermined. Her death certificate now says that they don't know where she died, when she died, nor the manner of death. In 2022, I went to the police chief locally here, not in Anne Arundel County, and as a show of good faith, I asked, list my daughter's death as unsolved. This is when Chief Amala Ward literally put her knee on my neck. She said no. She issued a letter disregarding the judge's ruling and the OCME, the medical examiner's office, stating no, the case was administratively closed 10 years ago. To me, this is a clear abuse of power, and possibly because of my community voice and retaliation. Ladies and gentlemen, I can't breathe. If you've seen my tears in here today, it's bringing all that back. My friends and colleagues, please strengthen this bill that we might move forward with dignity. This is not an anti-police message. This is an anti-bad police message. Thank you for what you're doing, and enjoy the remainder of your evening.
Thank you very much, and thank you for hanging in here with us and sharing your perspective and stories. Thank you. Ms. Sample.
All right, thank you everyone for having me. Thank you to the chair. Thank you to members of the committee. My name is Sarah Sample. I'm here with the Maryland Association of Counties, and we are here in support of this bill. So this authorizes counties to enable their police accountability boards with investigatory and subpoena power as part of their civilian oversight boards. I would say the brilliance in the language of the bill is that it authorizes discretion for the counties. And I think that brings with it sort of an implicit trust that you guys are going to trust the counties to do the right thing when it comes to using this power. And I just think that's super important when we're thinking about the entire process has to have that trust imbued through. We've heard the word trust come up a bunch of times in this hearing. And, you know, when you look at it, it's a hyper local collaboration between local governments and local police agencies. And you've got then, you know, some boards that have 15 plus civilians on them. And then you've got the administrative charging committee that's got 5 civilians on it. And so it's basically neighbors coming together to uphold the continuity of purpose that they share. And so I think that's super important. So I think the way that this legislation is written, and thank you, Senator Carter, for this, is that it allows the counties to be given the trust to make the right decision about this legislation. So we certainly appreciate that, and we think that sets the right tone. I would like to take this opportunity to acknowledge that there are still challenges that have come with the rollout of this process. There are some regulations that are unclear, some legal interpretations that are somewhat confusing. But regardless, we do think that this legislation is a step in the right direction. And so we would urge a favorable report for Senate Bill 285. Thank you.
Hello, my name is Linda Davis, and I'm testifying on behalf of the Anne Arundel County Coalition for Police Accountability in support of SB 285. Thank you, Senator Carter. The Anne Arundel County Coalition for Police Accountability is a coalition of more than 20 diverse intersectional organizations that came together in 2021 to advocate for strong, independent, and robust civilian oversight during the creation of the Anne Arundel County's Police Accountability Board that we knew was legally permissible, but politically impassable. Our coalition organized testimonies during 3 Anne Arundel County Council hearings, while we brought experts, state legislators, lawyers, directly impacted residents, and even former police officers. And while many of us have been studying, researching, surveying, and working directly with civilian oversight agencies for years, our input was dismissed. During this testimony, we presented our priorities, one of which was that the PAB have investigatory and subpoena powers. We were told by the county executive and the county council that this was not permissible under HB 670. And as a result, a PAB was created with no teeth. Now we are back 1 year later requesting that you explicitly authorize PABs to exercise investigatory and subpoena powers. Now that all eyes are on police reform again, in the wake of the murder of Tyree Nichols by police, let's finish the job and give PABs investigatory and subpoena powers. There should not be any more deaths by police. Enough is enough. And lastly, as anti-racist essayist and educator Tim Wise says, Americans, especially white Americans, have the tendency to wake up after a crisis and then hit the snooze alarm and go back to sleep. Let's wake up and never hit the snooze alarm again and create real police accountability now. Thank you.
Good evening, Chairman and committee members. My name is Stephen Waddy. I'm the first Vice President of Anne Arundel County NAACP, and I'm also here on behalf of the Anne Arundel County Coalition for Police Reform. Our message has consistently been that police cannot police themselves. And the need for independent investigations has been a dire one for the Black community and is an ongoing one for all communities interested in truth, fairness, equal protection, justice, and I will say after today, legitimacy. In 2021, the General Assembly failed to properly include the most important element of police accountability in the Police Accountability Act, community oversight. The final version of HB 670 did not properly expressly establish that police accountability boards have the power to investigate police misconduct. As Linda mentioned, this was the Office of Law in Anne Arundel County's determination that they could not provide the legal opinion to our county council members that we could have explicit investigatory powers added. At the moment of the 3 meetings that we talked about, the Anne Arundel County Council had the opportunity to actually vote on giving our PAB investigatory powers, but rejected an amendment to the bill that was drafted by the county executive, offered by Councilwoman Sarah Lacy, on the grounds that the state law did not allow local PABs to investigate complaints. The language in the amendment would have allowed the Police Accountability Board to issue subpoenas, interview witnesses, and use other investigative methods as part of its oversight duties. When the amendment was rejected by our council, advocates knew it was because the Fraternal Order of Police had final say on the bill. It was an election year, and that's what we were heard. That's what we knew. Come to find out, 6 out of the 7 county council members have been funded with over $40,000 in donations by the Fraternal Order of Police. All of them that voted for it, the one that voted against didn't take any money from the FOP. PABs are in the hands of county offices of law. We heard over and over again that the Office of Law did not interpret HB 670 as giving this power. We need this remedy. Thank you, Senator Carter, and I urge a favorable report. Thank you.
Just one question of, and either of you can answer it. I heard you talking about the FOP, and I often hear people saying, well, we want to be fair, we want to be just. I'll use another state and then I'll come back and make it local. And the George Floyd, as horrible as it was, Fraternal Order Police not only stood with him, but paid all the legal bills. I know in Anne Arundel County, my question is, if I'm going to listen, I want to listen to FOP, I want to listen to you, but I want to know that there's a sense of being objective. In your county, and I know you've had a number of situations that involved police officers, and some were bad apples. Have you ever known the FOP to come out and say, even in the most egregious case, and if any of you know, let me know, this was wrong, we stand against, we do not stand with this police officer, and we're not going to support him?
Senator Muse, the one time they've done that is when the officers are Black.
Yep, that's correct.
When the officers are Black, they're willing to say, you know, we're throwing them under the bus. They even issued a statement about Tyree Nichols, the officers in Tyree Nichols' case. Mm-hmm. But when there's the issue that relates to a white officer impacting a Black victim, the FOP generally stands with the officer. I will use an example. We have a woman who was killed in 1989 during a raid, and it was a drug raid by the police officers. A lady named Crystal Nelson, and she was pregnant, 8 months pregnant at the time, and laying on the couch. Officers barged in the house, and one of them shot her and killed her, and she was also a mother. The FOP, and you can go into the Capital Gazette News and go look at the news reports at the time, the FOP supported the officer, and they eventually supported the state's attorney who did not prosecute the officer. And it was reported in the news that it was because the state's attorney supported that officer that the FOP would support the state's attorney. So that was at the time. So the objectivity that we're looking for is something that we've been asking for centuries. And, you know, I don't know if
and I've been looking for it. And let me just say forthrightly, I love our police officers. I have a number of them in my congregation, from FBI to Secret Service to state police, meet with them in the group, listen to their stories. But right is right, and in a sense, wrong is wrong. And what I want to and what I'm looking for, when we say, well, this board, you know, the accountability board shouldn't have it because they won't be objective and it's almost like there's an agenda. I'm going to ask the question then another way based on what you said, and I will ask any FOP to please give me the information. And it's a simple question. I asked you initially, do you know of any FO, in your situation, in your county with a number of things that have happened, have you ever known any of the FOPs to say, you know what, we keep saying we're going to root out bad apples and that we don't want bad apples here either, but it seems to me that every time there's a situation, They stand with their own. And so I put the question another way. You know, you said yes when they are, you know, when they're
The
black,
officers are
they'll
black.
sometimes, you know, like almost like a sacrificial lamb.
We had,
So I can have the facts. Do we know of any, and whether it's my county, your county, and I'm asking my county, I'm sure that there are those who are listening. Give me a situation in which it was a white officer. And you said, we're going to withdraw funds, we're not paying for the defense fund. We're not going to make up the salary and all the other things that I saw them do in other cases, so that I can say I'm being objective. Give me the cases, give me the names, and because as I see it now, the accountability is in the hands of our citizens and boards like this.
yes, I
just
will
tell me
definitely
enough.
look for that information. It's going to be a hard search.
Fine, if it's
I
there,
searched through the press releases of the FOP once before when Tyree Nichols happened. Couldn't find any related to that. We did have a killing last January during the debate about this this bill, the Police Accountability Board's bill. A young man was killed. He was going through a mental health episode, and it was discussed by the AG's office. We didn't hear anything from the FOP at the time. The county is now being sued for civil rights violations under 2 different cases that police have been engaged in. One for that killing, and another one for a young man whose officer committed excessive force. And so, you know, the county, these are the instances that we see constantly in Anne Arundel County. So it's speaks to what Reverend Morris also was saying about the lack of transparency from the police department in itself. I think our chief of staff for our police department used to be a lobbyist for the Sheriff's Association. So, you know, and our police chief comes from Hyattsville. So, you know, we've had these types of these instances where police officers and police chiefs are moving around. They're going from county to county. So I know that the discussion earlier addressed the multi-jurisdictional nature of this entire debate. But we're seeing how police chiefs and police are able to move from county to county, state to state, and there's a lack of uniformity in the laws. And so,
if I can, Mr. Chairman, thank you for your patience, and I'll stop with this. Whether it's Prince George's County, because maybe I missed one. I've been in this for 25 or 30 years. Doesn't matter how horrendous it is. Not only will the FOP, they say they represent the police officers, stand with them every time, they will then withdraw support from whether it's a county executive, whether it's whoever it is, draw support away from anyone who says anything against their officer or against what have happened. I've seen that happen many times. I just want somebody to give me, from any of these FOPs who are sending representatives who are saying, no, we don't need this because of this, show me your objectivity. And that's the question that I'm asking. I'm open, send it to me.
Senator Muse, I think
and I
you heard the
appreciate it. Thank
objectivity
you, sir.
earlier. The FOP representative said that there were violent mobs that you all would be responding to, calling us a violent mob. So
Correct.
just the language that the FOP uses to describe people who are seeking justice and legitimacy within the criminal justice system or the public safety, it speaks to the level of kind of hate that they may have towards the people that they're even asking to protect and serve. We heard those same types of comments when we were debating this Police Accountability Board bill in Anne Arundel County. So it's just been a series of, there's that same issue that you're talking about. There are cases in Prince George's County related to Black officers that, you know, we have issues with that they committed killings about 3 years ago. And so we're still dealing with some of the repercussions based on plea agreements. The state's attorney trying to offer plea agreements in this deal. State's attorney 2 weeks ago dropped a case against officers who had been double dipping. And you know, it's election season for a lot of people. And I definitely think that the comment that, you know, we may see less of this if we pass public campaign finance reform. You know, public campaign finance reform is going to be a major way of helping to eliminate a lot of these issues.
Okay.
Sorry, I appreciate it.
Thank you very much. Me the objectivity, so that we can sit down and as is often said, speak on the facts. And if it's about justice, show me the facts. I've not seen it. Not in my county and others as well. What I have seen is the kind of revenge tactics if you dare to speak up against one of them, and that's what we are. But
I'm sorry, just the revenge tactics in Baltimore City, the revenge tactics that we saw. You know, I'm a realtor as well in Baltimore City, and the revenge tactics where people saw that there was crime happening, but people took a knee. That take a knee commentary just extended the idea that there were revenge tactics, as witnessed by 250 news articles on State's Attorney Mosby by just one television station just in a year, and now she's gone. So the revenge tactics are definitely there, and I appreciate you. Thank you.
Thank you. Thank you.
All right, thank you, Senator. All right, seeing no further question, actually, Senator James has questions, yes.
And I apologize. I stepped out of the room, so if this was already discussed, someone can tell me after the hearing, but I just wanted to make sure I understood the subpoena power. So when I've seen us add subpoena power to something, we usually say something along the lines of, in similar form as issued by the circuit court. And then also with subpoenas, they have to be served. And then, somebody who receives a subpoena can move to quash it or for protective order. So I don't see any of this here, but that might be because it's already somewhere else in the law, or that phrase subpoena power is broadly defined as everything I just said. Is that, and if you already went over this, I apologize.
We didn't, so thank you for your question. And just to clarify, all this bill does is just enable local jurisdictions to give their PABs independent investor powers and subpoena powers. So
I didn't hear that one.
all this bill does is just clarify that local governing bodies can give their local PABs independent and subpoena powers. So that would be something that would be addressed on the local level.
Oh, I see what you're saying. This is just
enabling legislation.
And then the local
Would
government
implement it if
Okay,
they
that's it.
choose to
Thank
do so. Thank you.
Thank you.
Senator Carter, did you?
An answer to what currently exists, but I'm happy to talk offline and keep things moving.
Very good. Are there any other questions from the, all right, do we have any other witnesses? Let's see. The virtual?
Yes.
All right. Can you hear us, Ms.
Yes.
Levy?
Okay.
Oh, now I can. Yes, thank you. Can you hear me?
Yes, we can hear you.
Okay.
Hold on 1 second. And what's your name?
Dio Akincheye, Silver Spring Justice Coalition.
Okay, well, let's go with Ms. Levy and we'll be with you next.
Thank you.
Thank you. All right, Ms. Levy.
Thank you very much, Senators. Good evening. Happy Valentine's Day to everybody. I know it's getting late, so I'm going to stick well within my 2 minutes. I just want to raise a couple points. Number one, I sat here earlier for about 3 hours and a half, and I listened to everybody talk on Senate Bill 290 tonight, which is about independent investigations. And what was interesting is that every person on every side of the aisle agreed, no matter if they were for or against the bill, that independent investigations are important and they are valuable. And that is the same exact concept behind Senate Bill 285, is that the need for independent investigations because, and this is closer than prosecutors investigating police officers. This is police officers investigating police officers, because that's how internal affairs works around the country and particularly in Maryland. As we know from the Steptoe report, that's a difficult ask for police officers to interview police officers and investigate them. In the Steptoe report, the Steptoe law firm found that at least in Maryland, the internal affairs unit was reviled and distrusted by the Baltimore Police Department's rank and file. and as a result had great difficulty recruiting and retaining capable investigators, IA investigators.
I'm going to be on soon, okay? I'm going
No,
upstairs.
no formal training and of any kind, which further degraded its reputation and discredited its work. We know that internal affairs officers, just like you guys would, everybody would have trouble investigating their own. Same thing is happening with police departments in Maryland. Senator Carter mentioned the Keith Davis case. In 2018, the Civilian Review Board found that all of the officers in the Keith Davis case, they said that it was the worst case the board had reviewed with regard to inconsistencies. The Baltimore Police Department did not find that. It was very significant. My client would not have waited almost 7 more years to be sent home. And I think lastly, I just want to say that Anton's law is creating a perverse incentive for law enforcement not to fully investigate their own, and that is creating more of a need for law enforcement investigations. It's creating a perverse incentive to not investigate, and we need community oversight. Thank you very much.
Thank you very much. Ma'am. And if you can, could you give your name again for the record?
My name is Dio Akinche.
Thank you.
Okay, I'm a resident of Silver Spring, District 20. I'm testifying on behalf of the Silver Spring Justice Coalition in support of SB 285. SSJC was the lead community advocacy organization that worked with our county council to pass the legislation that created our PAB and ACC. One of our demands, supported by many in our community, was that our PAB must be able to investigate individual instances of police misconduct in order to effectively do its job as the civilian oversight body for policing in our county. However, we repeatedly heard from council members that they were unwilling to consider this request because the Maryland Police Accountability Act did not expressly give the PABs that authority. This bill clarifies this important issue, removing any doubt that local governing bodies may, if they choose to, give their PABs independent investigatory and subpoena powers. It is enabling legislation and nothing more. While some may argue that giving the PAB independent investigative powers is redundant and unnecessary, our community disagrees. We don't think the ACC should have to rely on the law enforcement agency's investigation, even with the ACC's ability to request additional information. Most fundamentally, we believe that conducting an independent investigation is a critical tool to assess the quality of the law enforcement agency's investigation. It is necessary to end the practice of police policing themselves and to improve policing overall. All this bill would do is make clear that if our council or any other jurisdiction agrees, there is no barrier to moving forward to meet the needs of their constituents on this important issue of community safety and accountability. For these reasons, I respectfully urge you to issue a favorable report. Thank you.
Thank you very much. Ms. Kristen Mink.
Good evening, Chair Smith, Vice Chair Wallstreicher, and committee members. My name is Kristen Mink. I'm a member of the Montgomery County Council, representing District 5. I am speaking today in support of SB 285. The provisions outlined in SB 285 play an essential role in our pursuit of meaningful, independent police accountability structures at the local level. I am grateful for your leadership and the committee's initial support of police accountability measures and the Maryland Police Accountability Act throughout the 2021 session. However, implementation of HB 670 throughout the past year has made it clear that legislation is needed to clarify the scope of the Police Accountability Board's powers. When considering the implementation process for Montgomery County's Police Accountability Board, the Montgomery County Council heard strong and clear support for an independent, community-led body with meaningful powers, particularly from community members who identify as people of color, disabled, and LGBTQIA+. The idea of limiting this new resource to reviewing documents and findings after clearance by the police department undermines the intent of reforms made by the Maryland General Assembly and runs counter to both community recommendations and the national mandate to fix what is broken. Fundamentally, without investigatory and subpoena powers, police accountability boards are largely hamstrung in their ability to fulfill their intended purpose. At the local level, we need this enabling legislation passed to avoid these boards becoming an accountability board in name only. For the foregoing reasons, I urge a favorable report on Senate Bill 285. Thank you for your time and consideration.
Thank you very much. Is Nancy Soaring, is she in the audience? She left. All right, thank you. Jerry, is it, Kickinson?
Yes, good evening. Thank you, Chair Smith Jr., Vice Chair Waldstreicher, and members of the committee for the opportunity to testify in support of Senate Bill 285. My name is Jerry Kickinson. I live in Wheaton, District 18. I am here to testify in support of SB 285 on behalf of Jews United for Justice, which organizes more than 6,000 Jews and allies across Maryland to help win social, racial, and economic justice campaigns. The most sacred text for Jews, Torah, tells us in the book of Deuteronomy to appoint judges and enforcement officials who shall govern the people with due justice. Rabbinic commentary explains that this means our enforcement officials, the police, must act impartially and with knowledge of the law so that the people are not harmed. The General Assembly established police accountability boards to, among other things, review outcomes of disciplinary matters considered by charging committees, and make recommendations on changes to policy that would improve police accountability. SB 285 will provide the boards with the authority, subject to local governing body approval, to exercise investigatory powers, including subpoena power. This authority will allow these boards to fully achieve their purpose as already laid out in law and truly provide police accountability. Recent national news tells us that police accountability is needed as much as ever. Maryland is no exception, nor is my own neighborhood, with multiple incidents of excessive police use of force in Silver Spring and in Aspen Hill, resulting in trauma and death. A recent audit of the Montgomery County Police Department found inadequate data collection, inadequate guidance and use of force policies, and not surprisingly, many kinds of excessive force violations. The same has been true of other jurisdictions in Maryland. We respectfully urge this committee to reach a favorable report on Senate Bill 285. Thank you.
Thank you very much. Julius Living.
Good evening, sir. My name is Julius Levine. And by way of introduction, as a young man, I was drafted in the United States Army out of high school during the Vietnam War and retired after returning from Desert Storm. After retirement, I worked as DOD police officer in the Republic of Panama and at Fort Detrick, Maryland. I applied and was accepted at the Frederick City Police Department, where I served in the Patrol Division, the Community Services Division, and finally the Criminal Investigation Division until my retirement in 2012. And I say all that because I've been a part of the police family for many years. But that's what I did in the military. I did it as a civilian. So, and I request that you support the proposal 285B, or I'm sorry, SB 285, because the Police Accountability Board is necessary. The powers that and give them the powers that they need so they can be effective and not be hampered by outside influences. Now, with the power to investigate and the power of subpoena, you need powers to do certain things. If you can't get those powers, you might as well not be there. And I've heard the police, this board being referred to as, what do you call it? An advisory board, because they had no powers. So we need to give them that power. Police misconduct has been a part of society from the beginning in many forms. It takes forms from minimal invasion of individuals' constitutional rights to the unnecessary taking on an individual's life. I'm not blind. I know about police work, and I know there are inherent dangers in police work, but we need a mechanism where police officers that are conducted in the appropriate way can be held accountable. If they don't want to be held accountable for their actions, they should not be wearing a badge or the uniform. I know that was, thank you.
So thank you very much, Mr. Levine. We'll now go to Ms. Willis. Welcome.
Welcome.
Chair Smith and Vice Chair Wallstriker and members of the committee. My name is Greta Willis, and I am the mother of Kevin L. Cooper, who at the age of 14's life was unjustly taken in my home in front of me by a Baltimore City police officer on August the 12th of 2006. I am a Maryland resident writing in support of SB 285. To provisions outlined in SB 285 playing a central role in our pursuit of meaningful independent police accountability towards the county level. I am grateful for your leadership and your committee's initial support of police accountability measures and the Maryland Police Accountability Act throughout the 2001 session and the Maryland Police Accountability Act. But HB 670 throughout the past year has made it clear that legislation is needed to clarify the authority local governing bodies to have empowered their PABs in order for local PABs to follow through on fundamental goals of the Maryland Police Accountability Act. The legislative may clarify that local body and can give their PABs the power to conduct independent investigations into misconduct complaints. As a mother, as a citizen in Baltimore City, if we had the powers with the PABs, that they would be able to conduct and do their jobs effective and efficiently against the police department on behalf of the citizens, that there will be accountability in the state of Maryland. So I employ all of you for the foregoing reasons. I will say unto you that I urge you to give a favorable report on Senate Bill 285 to protect our children, that they can live another day. Thank you.
Thank you, Ms. Willis. We'll now hear from Mr. Ali. You're up.
Thank you very much. Dear Chair Smith, Vice Chair Wallstriker, and members of the committee, my name is Mir Usman Ali. I'm a Maryland resident and an assistant professor of public policy at the University of Maryland, Baltimore County. I'm testifying in support of SB 285. My research addresses questions of how public organizations may address social inequities with a particular focus on the impact of citizen oversight of police. In a peer-reviewed published study, I examined the impact of police accountability boards in the US over a period of 35 years. I defined PABs with independent investigative authorities as those that can, one, classify complaints, independently investigate complaints, recommend findings, recommend or impose discipline, have paid full-time staff, and have a permanent stable budget. I found that such investigative PABs lead to a 6% annual reduction in racial disparity in police homicides. PABs which lacked such authority did not have any impact on such disparities. In another peer-reviewed study, I found that investigative PABs led to a 21.1% reduction in the violent crime rate and a 9% reduction in line of duty police homicides. These reductions likely occurred because investigative PABs inspire trust in the police among members of the public, which in turn increases their cooperation with police. For local PABs to be effective, the legislature must clarify that county governments can give their PABs the power to conduct independent investigations into misconduct complaints. Without this power, the people of Maryland are forced to accept law enforcement investigations at face value, and the PABs are unduly restricted in their ability to fulfill their role. For the foregoing reasons, I urge a favorable report on SB 285. Thank you very much.
All right, thank you very much. That'll conclude the testimony from our virtual witnesses. When I'll switch back to in-person. And I believe, has everyone that is here in person in favor of the bill already testified? So I've not missed anyone. Don't want you to wait all this time and not to testify. All right. So that concludes the testimony for the proponents of the bill. We'll now switch to the opposition panel. And we'll hear from Mr. Adams, Mr. Davey, Mr. George. And Miss Shatina? Muriel? Information only. Okay, we'll have you come at the end then. All right, thank you.
Good evening again, Mr. Chair, Mr. Vice Chair, members of the committee. I am Scott Adams, Sheriff of Cecil County, and also the President of Maryland Sheriff's Association, here representing the Maryland Chiefs of Police and the Maryland Sheriff's Associations in opposition of SB 285. This bill would authorize a local governing body to provide and police accountability, a PAB with investigative and subpoena powers under local law. Granting these powers is premature, and doing so would complicate and create uncertainty over the investigative process. Local jurisdictions may elect to provide these powers for intended reasons without understanding the unintended negative consequences of those actions. In 2021, the General Assembly passed the Maryland Police Accountability Act, which repealed the Law Enforcement Officer Bill of Rights and imposed historic and sweeping police reforms. Provisions in these painstakingly negotiated reforms mandated that counties establish PABs, administrative charging committees, and trial boards by July 1, 2022. It's important to keep in mind how these new pieces all interact. PABs are established under local law and consist of civilian members that are required to work with local governments to improve policing, appoint members of the ACC and trial boards, receive complaints of police misconduct filed by the public, meet at least quarterly to review disciplinary matters considered by the ACC, and report annually on trends and recommendations to improve police accountability. Complaints of police misconduct can either be received by the PAB or the law enforcement agency for investigation. If received by the PAB, complaints are then forwarded to the law enforcement agency to investigate. The ACC's purpose is to review the law enforcement agency's investigations, recommend whether to file administrative charges, make disciplinary determinations according to the statewide matrix. Members of the ACC must receive specific training before serving on the committee. The goal of this setup is to have a consistent, equitable process to address police misconduct and accountability statewide. Under SB 285, a local jurisdiction could choose to provide its PAB with the power to inadvertently investigate a complaint of police misconduct concurrently with law enforcement agencies investigating. There's much more. I know we filed.
No, don't. You're an elected position, and we generally don't time elected, so we'll give you some more time.
Thank you, Mr. Chair. Investigate a complaint of police misconduct concurrently with the law enforcement agency investigating the complaint. Jurisdictions that choose to exercise the authority will have two separate entities investigating and issue reports on the alleged police misconduct. The ACC will then have two separate investigative reports to review and consider when determining whether to file administrative charges and issue discipline. Given the distinct roles provided to each of the boards, it was not intended under the Police Accountability Act for multiple entities to perform the investigations. Rather, the intent was for the pieces to work together to ensure there was civilian engagement and police oversight and a standardized process for accountability across the state. At best, this duplication in duties is poor use of time and resources. At worst, it injects uncertainty and confusion into the investigative process. The ACC could be presented with conflicting investigative reports with no guidance on how to reconcile the two. This would open the door to criticisms and allegations of unfair treatment by the officers being investigated. Parallel investigations could wreak havoc on investigations where criminal violations are discovered. Law enforcement must work closely with prosecutors and investigators in those cases, and the alleged criminal issues should be addressed before the administrative investigations proceed. PABs performing a concurrent investigation into an administrative complaint could inadvertently derail a covert criminal investigation, especially considering PAB members are not trained and experienced in performing investigations. The bottom line is that it would be premature to grant this authority. The proposed authority raises too many unanswered questions. Due to the scales of the reforms and pace of developing regulations, many jurisdictions were just getting their boards established by the July 1 deadline. Given that the PABs have been in existence for less than a year and are still working out kinks, we are cautious about expanding their responsibilities and authorities. It would fundamentally change the role and responsibilities of certain PABs, transforming them from a board that broadly reviews and reports on trends to one that performs substantive investigations. Altering responsibilities at this stage can create more problems than it presumably solves. It is prudent we allow some time for boards to be in place so that any issues that arise or gaps that need to be filled can thoughtfully be addressed. The Maryland Police Accountability Act of 2021 was a complex and historic piece of legislation. We do not want to undermine its goals by allowing premature piecemeal changes to cause unintended consequences to arise. For these reasons, the MCP and MSA oppose SB 285 and request an unfavorable committee report. Thank you.
Good evening, Chairman. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we're requesting an unfavorable report on Senate Bill 285. The Maryland Police Accountability Act was passed by the General Assembly in 2021 with an effective date of July 1st, 2022. At this point, very few, if any, police accountability boards and their administrative charging committees are even up and running. They haven't received the training. Most of them have not even seen a case yet. So we're here today on this bill trying to change something that we don't know whether it works or it doesn't work because there's no experience as it pertains to this right now. There's been a lot of talk about Anne Arundel County. I'm very familiar with Anne Arundel County's Police Accountability Board and Charging Committee. They have not seen a case because they are not up and running yet. Senate Bill 285 is attempting to fix something that none of us know needs to be fixed, not at this time. Senate Bill 285 is attempting to amend the authority of the Police Accountability Board before any of us have any real experiences with it, pro or con. And remember, the Police Accountability Act took the place of the Law Enforcement Officers' Bill of Rights, and for the first time ever, there's civilian oversight over police discipline. I'm going to just use Baltimore City as an example. This bill, if passed, would now give Baltimore City 3 investigative arms on internal discipline cases. First, they would have the Baltimore Police Department's Public Integrity Bureau, which is being overseen by the Department of Justice and the consent decree. They have the Citizens Review Board, which can investigate abusive language, and excessive force. And now this bill would give a 3rd investigation to the Police Accountability Board. As the law stands today, the Administrative Charging Committee, part of the Maryland Police Accountability Act, made up completely of citizens, do have authority over these cases. Under the law today, they have a right to review the file, the case file, the investigative file. They can review the body-worn camera. They can go back to the police department and request additional investigative steps to be taken. And on top of that, they can call the police officer into their committee, into the charging committee, and ask them questions. They have that right under the law today. That's what civilian oversight is. We believe that is enough right now before we make a determination to change or amend something that hasn't even taken place yet. For those reasons, we would ask for an unfavorable report on Senate Bill 285. Thank you, sir.
Good afternoon, Chair Smith, members of the committee. My name is Bill George. I'm with the Maryland Municipal League today here in opposition to Senate Bill 285. But let me be clear, our opposition is not necessarily with the adding of these specific authorities, but the fact that we're adding new authorities to a county-created entity that oversees municipal employees. This is an issue that MML has raised since 2021 debate over the police reform. And you all are lucky enough next week to hear our priority bill before your committee, so I won't belabor that point. But as we're seeing around the state, as these boards are attempting to get up and running, municipalities are being excluded from the conversations in many, many instances. There are 157 municipalities in the state, 89 of which have police agencies, and in many of these county-created police accountability boards, there has been no discussion with municipal representatives about their thoughts on who should be either the citizen participants or whoever on the police accountability boards and the administrative charging committees. So we see this as an opportunity to discuss a little bit about the municipal representation on these boards and committees. But as I said, you'll hear more from us on that next week. Until then,
We do oppose the idea of adding any new authority to county created boards without some sort of meaningful municipal representation in the process. So with that, we ask for an unfavorable report.
Thank you very much. I was going to ask why Mako was in favor and MML was not, but now I get it. I know he met before, and so we're going to do our level best to ensure that there are municipal representation on the boards. I don't know what that looks like, but I gave you my word that I would do our level best. How many municipalities are there in Maryland? 257?
There are 157 municipalities total in the state.
How many have police for?
89.
89. Right.
89.
Wow.
Yeah.
Senator West.
Thank you, Mr. Chair. Mr. Davey, could I talk to you for a moment?
Yes, sir.
So at the moment, as I understand it, most of the investigations of complaints against police are handled internally by the police department. They all have internal affairs divisions, correct?
Yes, that's correct. So, right. So the Internal Affairs Division will conduct the internal investigations on all complaints.
All
and under the
complaints, not only internal complaints by
and
one policeman against
yes, sir,
another,
and complaints
but
made from the
external
public.
complaints from citizens against police.
Correct. The difference is once the case is done, if the complaint involved the public, that investigative file goes to the Administrative Charging Committee, which is part of the Police Accountability Board.
Right.
If it's just an internal complaint that didn't involve the public, the police chief in that local jurisdiction would handle the discipline. Yes, sir.
Okay. And so can you give me some idea of how much staffing is required to handle properly the investigations that these internal affairs divisions conduct?
So it really depends on the size of the agency.
Right.
Baltimore City has 47 internal affairs investigators.
47. in the
47.
city.
Yes, sir.
Okay.
Anne Arundel County has approximately 550 police officers. They have 6.
So I'm looking at a letter of information from Mayor Scott of Baltimore City, and he describes it as a letter of information, but you don't have to read it too carefully before you realize he is very dubious about this bill. And I guess the fact that he already is paying 47 people to do internal affairs investigations would suggest that if the city PAB were to replicate that, it'd be another 47 people at double the expense that the city is currently being put to, correct?
It's possible. And you have to also know that in Baltimore City, not only that they have these 40 plus investigators, they're now in the process of hiring civilians to also do investigations, because part of the Police Accountability Act now allows civilians to actually conduct those investigations, and they're not locked into just having a law enforcement officer perform that task.
Do you know how many people in statewide are involved in investigations?
I couldn't, I mean, I represent probably 90% of the agencies. I couldn't even tell you, because it really depends on the size of the agency.
If we set up parallel investigations, so that we're having 2 separate groups investigating the same problem, or suggested in here, 3 separate groups investigating the same problem. We're talking about, I guess, a lot of money.
I'm sure it is. And then taking out the financial impact, you have to look at the conflicts that are going to occur. Say one internal affairs determines that their charges should be preferred against the officer, but the other investigative end says, no, there are no charges. Who wins? I mean, I'll win, because I'll be able to defend that case as a defense attorney, because if the investigators can't figure it out, an administrative trial board is certainly not going to be able to find them guilty.
Never thought of that. Okay. So if I'm right that the city of Baltimore doesn't want to do this, are you aware of any other county in the state that is likely to opt for this discretionary power to charge their local police accountability board with the responsibility of investigating?
I don't know of any, but I would probably not be the best person to answer that question. It would probably be the local county or town office of law who could answer that.
Okay, thank you very much.
Thank you, Mr. Chair. Unfortunately, Senator West, you were I don't think you were here for the initial part of the bill. So I just wanted to clarify, and I'm happy to talk to you offline, but the entire point of this legislation is to have an independent, separate investigation that comes from the people, that is not reliant completely on the internal investigation, because that's proven throughout a long period of time to be ineffective. And we talked about a lot of examples, but I'll share that with you later. My question is for Mr. Davey. Isn't it true, sir, that the Fraternal Order of Police has never been in favor of the civilian oversight of police?
We have not supported it because we believe that police work is specific in certain aspects that police should be investigating themselves because they understand the job.
And so, but that's always been sort of at odds with what Baltimore City wanted to do, as well as the Civilian Review Board. Because I recall in 2016, the Fraternal Order of Police filed a lawsuit against the Civilian Review Board, I believe, which was dismissed because the FOP wanted to block the Civilian Review Board from receiving internal investigations information.
Yeah, there was an issue in 2016 regarding the confidentiality or privileged documents as it pertains to internal affairs records being personnel files. Obviously, the MPA and the new has changed all that. So that's all open to the public now.
So I just want to clarify, we're well aware about the Civilian Review Board. The issue is, first of all, there will not ultimately be 3 separate investigative entities. The issue here is that the administrative charting committees must rely on the internal affairs investigation. And even though you inject some civilians in there, they're hired by the police department. So there's still an internal process. The point of this legislation is to continue to keep this investigatory power that's already in the hands of the people with the Civilian Review Board in the hands of the people with the Police Accountability Board. That's all it seeks to do. And I know you've never been in favor of it, but it's really not creating 3 separate entities. And in answer to Senator West's question about the 47, that's not actually true. I actually think that the city and other jurisdictions should resource these civilian oversight bodies better than they do, but it's highly unlikely there'd be another 47 investigators. When I was working in the Civil Rights Office, I think there were a total of about 4 investigators altogether, but their categories of cases were limited. So this would allow for investigation of any type of case. It would just simply say that there's an independent investigation.
Right, but as I stated earlier in my testimony, I believe that the Administrative Charging Committee does have the authority. They're reviewing a case, which means they can listen to the interviews. They can interject by asking them to go back, re-interview people. They can ask them to go find another witness. They can go talk to somebody specific in the that's been mentioned in the file. They can review the body-worn camera. There are a lot of steps in this process now in which civilian oversight and civilian involvement is actually taking place. So the mere fact or the reasoning for having a separate investigative unit per se, or a group, I don't think is necessary. At a minimum at this time, we're still at the very beginning of this whole process. And I think it needs time to work its way through. And in a year or 2 years, we'll see if it's working and we'll go from there.
I understand your position, sir. And we did a lot, and I'm happy that we did inject civilians into the establishment internal process. I just believe fundamentally that we need that independent outside body. And I believe in keeping the power in the hands of the people to decide what policing works in their jurisdiction and what doesn't.
No, I don't believe you're wrong. I believe both this committee and the FOP worked very diligently last year and the year before to try to come up with a system that would work for everybody. And I would just like to see at this point, let's let that process work and see where we are.
Thank you, Mr. Chairman, and I agree with what both of you said just now. So, Mr. Davey, behind us is the Maryland Code, and I'm trying to get a precedent for this. Is there any way, anywhere in existing law where a civilian, non-attorney, unpaid volunteer is provided with subpoena power?
Yes.
I don't know of it, but if Senator Carter does.
Is the civilian board in Baltimore under the consent decree? Do they have subpoena power? Hold on. Let me get you on mic.
I'm sorry. Even before the consent decree, the Civilian Review Board in Baltimore City has had subpoena power. It has been limited to everyone except the subject officer under the current law, but they've always had subpoena power, and they've always had full investigatory power to conduct independent investigations, it has been limited to certain categories of cases.
I can go back and check the Maryland Police Accountability Act and as it pertains to the ACC to see if they actually have it. I'm off the top of my head, I don't recall.
Got it. Got it. And just to be clear, subpoenas aren't warrants. There's no, once these are issued, there's no judicial review. There's no third party approval. They just go out
Correct.
and
That's
carry the force of law.
Right.
Okay, understood. Thanks, Mr.
Object again, but so in Baltimore City, the way it has worked with the current Civilian Review Board is that they issue the subpoenas and the circuit court has jurisdiction to enforce it or not enforce it. Under the current structure, the city law department has been charged with, verifying, I guess, the legitimacy of the subpoenas, but that's the way it's been working under the current structure. Well, no, but I think that was brought up earlier, and certainly we'd be amenable if you think it's necessary to add language. I don't know that it is, because this is simply enabling. It's up to the jurisdiction to use the process that they so choose to how to enforce the subpoenas, I think, under the bill. It's just enabling.
Thank you, Mr. Chair. So, Senator, you just mentioned about enabling and legislation. Coming new to this committee, any committee that I've been on before, any kind of a local courtesy enabling piece of legislation to go forward always needed the local body to say, this is what we wanted. And I don't see any in the testimonies of any other counties, individual forms of county commissioners, boards, or those requesting anything this. So I don't know from a process standpoint, talking about precedent that the senator had mentioned in the code, but also from the precedent, are we giving enabling legislation to somebody who hasn't even been asked if they want it for having, as I see this as being local courtesy?
I'm sorry. So this is now a conversation. I'm sorry. This is not wait. So I see how you could think that, but here's the thing. When we created the legislation 670 in 2021, and we created two dual bodies. We created administrative charging committees, which everybody now wants to like act as the be all end all. But we also created a separate entity of civilians. We created that. We may have taken some input from jurisdictions as to what they wanted, but that's a statewide law. So we say to the jurisdictions, you appoint your people who you want to these different bodies. That's what you do. But now this bill is saying, don't limit that. Like each jurisdiction that creates a police accountability board has the ability to give them the power to investigate and the power to issue subpoenas. That's all. I think it's just enabling. And I don't think it's inconsistent with what we've done before when it comes to I suppose, the ideology of the state now that we want to have more civilian input into the police disciplinary process.
Thank you. Thank you, Mr. Chair. I guess my counter to that is, well, then if it's supposed to be statewide, then take out the may. And I think you take out the may changes a lot of people's testimony, may change people's testimony either for or against it. It changes the bill completely. If that was the intention, as I hear what you're saying. So.
That's interesting, because in the course of drafting the bill, we went back and forth about whether the language should be shall or may. And I think that we settled on may and not shall, because we didn't want it to appear as if we thought it would have a much better chance of being accepted by this body if we use the language of may, not shall. But I'm certainly like open to shall.
No, it's interesting. You could go round and round about this. I mean, you could reverse engineer this and say, look, well, if it's a may, then you should leave it to the counties to come and ask us for this responsibility in the first place, or if it's shall, then it's the will of this body to do it. But So the PABs were, initially, right now, they receive complaints from external complaints, refer them on, and then they also meet and produce policy recommendations to the governing bodies in their jurisdiction.
That's correct. They review policy, they create policy, they interact with the police department on a best practice purpose.
They go to the MPTSC, the Maryland Police Training Standards Commission, when they're selected by their local jurisdiction under whatever criteria that local jurisdiction has established.
Yes.
How many hours of training do they have to receive?
I believe it's 40, but I don't have the law in front of me, but there are a number. Yeah, it's just the ACC has to get that training, and I believe it's 40, but I can get that information.
That's important because if the ACC has to get the training, but the PAB does not, and there are no prerequisites for service apart from just being selected from the governing body, which is a good screening process, but no prerequisites other than that. So then this bill would propose that body would have subpoena power. I guess, back to the vice chair's point, like if it's not, and we haven't set that up, and I know that the sponsors opened to that scheme of having some level of judicial review at a circuit court level, then you're having an untrained body issue subpoenas. Are the left and right limits of a subpoena articulated here in this bill? Because I'm a little bit.
Just has the word subpoena.
What does that mean?
I'm guessing it would be a document demanding either the appearance of a person or a person and bring documents with them. But I don't know how you would enforce it. I just don't know.
I'm just trying to figure out how it works.
I mean, under the Police Accountability Act, under the discipline system now, the chairman of the administrative trial boards has the authority to issue subpoenas. It's in the law. So they can require the appearance or they can require documents, whatever either the prosecution or the defense requests that they issue. There's also, I still juggle between the LEOBR and the MPA because we've had no cases or no trials under the MPA yet. I believe, at least under the old LEOBR, if a subpoena was not adhered to, the trial board chairman could go to the circuit court in that local jurisdiction and request enforcement of that subpoena.
So, all right, and I'm just being honest, I'm trying to understand the process because having folks that are, there's no prerequisite and there's no training, having subpoena power that's undefined is a little bit scary.
Very.
So let's flip it on the other side. Where it's been working and in place since before the consent decree in Baltimore City. That body does have subpoena power, limited subpoena power, subject to the approval of the circuit court. What are and maybe Senator Carr can, the prerequisites for service on that board? Since that board has been working, what are the prerequisites for that board?
That would be an answer. Senator Carter would know that well better than me.
Sorry, let me get.
I'm not sure if I understand the question, but the limitation is simply they are not permitted or it's not enforceable to subpoena the subject officer, but every single other person involved can be subpoenaed.
Yeah, I just want to put it out there, like what this proposal is before us, and then some of the things that are working in practice. You still get every element of what you want, but in a different flavor. Senator Muse.
Secured an annual $1 million to meet the budget, to bring in the right people and to do it as it should be done. So I don't know how others are implementing this with subpoena power, et cetera, but that's what we've done.
In Montgomery, they've decided to pay the PAB.
Right.
But I think it's more like a stipend, not like a like a salary or something, but
I'm reading it, so.
yeah.
Okay.
Yeah. Senator Sidnor? No, right. I just think there's a lot to take in. That's all, I mean.
Yes, surely.
Right.
Yeah.
Because it hasn't been clear in Baltimore City what the role of the PAB is going to be versus the Civilian Review Board. Basically, the Civilian Review Board has been prohibited from continuing to take complaints. The PAB has not been allowed to take complaints. And so it's my understanding there's a backlog of more than 300 complaints. 700? Okay.
I think it's closer to the 300 the senator's talking about. It's a lot. I mean,
that's a lot.
I send My firm sends an attorney to internal affairs in Baltimore City every day, and we're averaging close to 45 accused statements a week. So it's a lot.
Well, one thing's clear, we've got a lot of work to do.
Yeah.
That's all right. All right.
Senator, if I may, can I just respond to something Senator Muse said earlier?
Sure.
You indicated that you've never, ever seen the FOP denounce an incident. I'll provide that to you.
I said I need some information so I can be objective because I'm hearing many, many things. I've never seen it. And so if you have it, please send it to me so I can have the information and be.
I will send you press releases from both the national FOP and Clyde Boatwright, the president of the Maryland State FOP.
That's all I'm asking.
You'll have it as soon as I get in the car. I'll call them and have them work on it. Thank you.
All right, seeing no further questions, thank you very much.
Thank you.
All right, so we'll have the, yes, here you go. Come on up.
Good evening. Thank you, Chair Smith, members of the committee. My name is Mariel Shutinia. I am the Chief of the Police Accountability Division for the Office of Equity and Civil Rights for Baltimore City, where I oversee our Police Accountability Board, our Administrative Charging Committee, and our Civilian Review Board. I'm here to provide information on SB 285. This bill represents an important next step in civilian oversight in the state, allowing local jurisdictions to bestow investigatory power to their PABs. As each jurisdiction was allowed to determine the makeup of their PAB, Baltimore City is very unique. We have 17 members on our PAB, the largest in the state. And as was stated, we anticipate about 700 complaints a year. We have not received 700 complaints. We've received over 400 at this point. My office has served as the designee to receive those complaints and forward them to internal affairs. So there is no backlog of receiving complaints. They are just waiting on the investigations to be completed so the ACC can hear them, but all complaints have gone through the system properly as of July 1st, 2022. I discussed the amount of complaints and the amount of members we have, just an aside that it would be burdensome and untenable for all 17 members to review all of these complaints and the completed investigations. So we're just advocating for adding clear language that would allow for the local jurisdiction to provide the PAB to have an allocated subcommittee or subset, a smaller portion, to review those complaints and look at the investigatory files. Additionally, as been stated multiple times, my office supports the longstanding Civilian Review Board, which has independent civilian overview and concurrent investigatory and subpoena power. We employ multiple civilian investigators who are trained to do these investigations and present them to the Civilian Review Board members. My office has the institutional knowledge and resources and experience to support this. Going forward, there is a bill pending, SB 763, that would sunset the Civilian Review Board. So we didn't have 3 investigatory bodies in our office and only have the PAB do that work instead. I welcome any questions and clarification. I'm very happy I was last to go at this point.
Thank you, Mr. Chair. I'm so glad you're here. So earlier, there was testimony that the Internal Affairs Division of the Baltimore City Police Department still employs about 47 people. So you say this, the Civilian Review Board also has investigators. How many does it employ?
Currently, we have 2 investigators. The Civilian Review Board has very limited jurisdiction right now. They have 5 complaint types they can hear. It has to be presented on a signed Civilian Review Board form, and it has to have happened in the last year. So we get about 60 to 100 complaints that are able to be investigated. We receive more than that are not jurisdictionally accepted. We have 2. We would anticipate if the PAB had investigatory power, we'd need to hire several more. This jurisdiction does not mean that every case would be investigated concurrently or independently. It just gives the ability for cases that the board believed there would be a need for civilian oversight and for a second look to have that ability. So the PAB would not be investigating, or investigators now looking at 700 cases. It would be a small subsection that needed that additional oversight. And I say that too, we review the body worn camera footage. We have access to all of internal affairs files for that. And there are certain cases that you would not need to investigate. It's clear on the body worn camera, you don't need a concurrent investigation. This allows for the possibility for concurrent investigations when deemed necessary. So not all 700 would be investigated concurrently.
So to the best of your knowledge, if this bill should get passed, would Baltimore City exercise the discretion authorized by this bill to authorize the Police Accountability Board to set up an investigatory team and start issuing subpoenas?
My understanding would be yes, as long as the Civilian Review Board was sunsetted. Again, I have both in my office. So if we had to do 2 concurrent investigations with our investigators, it would be burdensome. So the request, and that is in SB 763, would be to sunset the Civilian Review Board and provide that investigatory power to my office for the PAB. So we have multiple investigators already who are employed. We would need a few more, but we have training. We have a chief of investigations. We work very closely with PIB. We go to their investigator trainings, things of that nature. So we would be able to be up and running very quickly and just transfer the Civilian Review Board staff.
So I'm confused. So you're basically in charge of all of these investigations.
Yes, sir.
Why do you think it would be helpful to the city to have multiple investigations of the same complaint?
So right now, the only 2 bodies that can investigate complaints are PIB or Internal Affairs. We have 7 law enforcement agencies under a jurisdiction, not just BPD. So they do their own internal investigation and always will. Then the Civilian Review Board has the authority to have investigations as well. So really, there's only 2 boards at the moment, or 2 bodies. And the request is that CRB power to investigate would be given to the PAB instead. So the request is not to have them all at the same time. That would be duplicative, and the CRB has limited jurisdiction where the PAB receives all complaints involving a member of the public, and they would be able to review all of those complaints, which they already receive, and provide, investigatory power for cases where they deemed it necessary.
So you expect 700 complaints a year. And the current police department has 47 investigators to deal with 700 complaints.
No, so Internal Affairs has, to the best of my knowledge, has 47 investigators, and they're looking at both internal and external complaints that involve either a member of the public or only that don't involve a member of the public.
Okay,
So
you have 700 complaints from the public, and how many internal complaints are filed by the police against other police?
I know that they have many more. At the last consent decree hearing, I know there had been a large decrease in the amount of complaints involving a member of the public, and actually an increase in complaints that were internal that did not involve the public. And the reasoning behind that was things of an officer didn't go to training. That could be for sanction, things like that. So they're investigating, it would be an overtime fraud, failure to go to training, losing their cell phone, something like that. So they have many cases. So all 47 are not investigating cases involving members of the public. That's about 700 annually.
So 700 complaints from members of the public, and more than that from internally, from one policeman complaining about another policeman.
No, sir. So it's 700 complaints annually that will go through the PAB ACC process as of right now. So about 7.5 months in, we have received about 403 complaints. Baltimore City is unique, where the PAB receives a complaint and we have 3 days to send that over to Internal Affairs like everyone else in the state. But in Baltimore City, Internal Affairs, when they receive a complaint directly filed with them, they have 2 weeks to provide it to the PAB. So that 300, 400 complaints we're discussing we've received to this point are ones filed directly with PAB and also filed directly with the agency, either internally or externally, however they received it, and then they forward it to us for data tracking purposes.
You obviously know what you're talking about, but somehow it's not getting communicated to me. So about 400 complaints have been filed so far this year, since what, July 1st of last year?
Yes, sir.
By members of the public about police.
No, it has to be a complaint involving a member of the public. So it could either be what we say
Well, who's filing this complaint?
It could either be filed by a member of the public or it could be filed internally. So an example of one that would be PAB or ACC eligible that was filed internally would be an officer, a sergeant reviewing the body worn camera footage of a subordinate officer and finding misconduct.
Right,
if it involved a member of the public, that would be forwarded to the PAB as well as ACC eligible.
All right, so you're saying 400 complaints total have been filed since last July 1st in Baltimore City about police
involving a member of the public.
involving a member of the public?
Just real quick, you know, if a complaint involves a member of the public,
Yeah.
it goes the route of the PAB.
Right.
If it's the internal officer on officer, it does not go through the PAB unless it involves a member of the public.
Right.
That's very clear. That's very clear.
Yeah, that's as clear as mud.
No, member of the public in any instance, PAB, officer to officer, without a member of the public, internal.
It doesn't matter.
I'm trying to figure out if the city if this bill's passed and the city goes through with this, how many more pins or how many more employees the city is going to have to hire in order to handle all the complaints.
So as of right now, the Board of Estimates for Baltimore City has authorized $2.38 million annually to fund our Police Accountability Board and Administrative Charging Committee without investigatory power. The Civilian Review Board is already currently funded. And the fiscal note we're preparing for SB 763 that would sunset the CRB and provide that investigatory power to the PAB in my office. We project there would need to hire about 4 more
Just 4
investigators.
more people to handle all these complaints.
So the an average investigator would have about 35 to 40 cases annually. If we're getting about 700 cases annually, with a conservative estimate of 25 cases or 25% of cases being authorized for investigation, again, not all cases require an independent concurrent investigation. If it's very clear what happened, you wouldn't need that, right? So if we're thinking there's 25% of those 700 cases, that would require just 35 to 40 cases as a national best practice for internal affairs investigators or civilian oversight. We would need 5 investigators and 1 supervisor to get that work done and do it appropriately and efficiently within the timeframe under HB 670.
All right, thank you.
Thank you.
Okay, that's what I was gonna ask you, because I know, so this is all Baltimore City politics right now, but since you have a consent decree, the civilian board is under that consent decree. How, and you're saying that if we roll this over to the PAB, then you would sunset the civilian board that's under the consent decree. I know that. So do you have the authority to do that? Or do we have the authority to do that?
So the Civilian Review Board was
Without following the consent decree, yeah.
it was created by state statute. I guess it would have to just be run by Department of Justice and monitoring the federal judge, which we do at all times. If that investigatory power is not disappearing, it's just being transplanted to another civilian oversight body that has more jurisdiction. I don't see any issue
Who
with
has
it.
final bless off on that? Is it DOJ?
It would be the federal court, the federal judge.
Okay.
But again, if it's abrogated at state level, I don't really believe that there would be a problem in that jurisdiction.
Okay, but it's ultimately not up to us.
No, it
I
is.
mean, okay. I'm trying to, if it's subject to,
The
Okay.
civilian review board created by us would be repealed by us if it were to be repealed, Mr. Chair. But the consent decree specifically left out certain aspects of police discipline and civilian oversight. It's a long story. It created a civilian oversight task force, which is no longer in existence. The bottom line is that we would have the authority to repeal that, only us. But
I trust
with
Baltimore
that
City
being
folk about
said,
Baltimore City things that are.
so I just want to ask a question because you've said something that is news to me and confused me. We've talked before, and it's my understanding, the reason that we couldn't get anywhere last year with Baltimore City is that Baltimore City took a position that they wanted to give all the power to the Administrative and Charging Committee, not to the Police Accountability Board. You just said that the legislation this year would give that same Civilian Review Board power to the Police Accountability Board. That's news to me because it was my understanding that you wanted to leave it in the hands of the internal charging committee.
Yes, so that is a change. What was stated earlier in the opposition testimony, that there could be concerns if the Administrative Charging Committee reviewed 2 separate files, and there would be concerns that would cause justice issues with appeals and anything like that. We have agreed that it makes the most sense to have the Police Accountability Board have that power to avoid that conflict. And that's why we're advocating to just have the legislation allow for a smaller subsection of the PAB to do this work, just because 17 members would be, and even to get quorum to do that work would be difficult. But if we could drill down into a subsection of the PAB, a subsection, a subcommittee chosen by the other PAB members of who would be on it, that we think that would work best. And it would basically be substituting in what the Civilian Review Board already does, and would not cause any appeal issues or any other issues, as the Civilian Review Board has worked very well for over 20 years. And so, yes, we would like that ability to go to the Police Accountability Board, as long as it can be drilled down into a smaller subcommittee to make it logistically manageable.
Well, if true, that's exactly what we were going for with the legislation last year and this year, so we'll see. But nobody wants duplicative efforts, but all we've ever wanted was that power to be bestowed in the Police Accountability Board. And I personally would have a level of discomfort dissolving the Civilian Review Board until I'm assured the Police Accountability Board has all of the power as well as the political will to do that work.
So, and I'm happy to talk about that also, but yeah, no, the thought process we have and what we think makes the most sense, and we agree, is that it's for the Police Accountability Board and not the Administrative Charging Committee to have that independent investigatory and subpoena power. So we are in agreement with that.
Well, that's a delegation bill, right? So that would have to come out of your delegation. Okay. Yeah. No, I just want to make sure. Okay. Okay. Any further questions? Okay, thank you very much.
Thank you.
Thanks for hanging in there with us. All right. Did I miss anyone? Okay. All right, so with that, that'll end the hearing for Senate Bill 285. We'll now head on. Oh, I know, Senator, we're not over yet. We have 2 more bills to dance with tonight. All right. We're in this together, man. All right. All right. That's what you say. I'm going to the bathroom. All right. All right. Senate Bill 257 with Senator Waldstreicher.
Thank you, Mr. Chairman. This one is a lot cleaner and a lot easier. That's right. And my panel is certainly welcome to come up and join me. This is an important issue, but also an easy issue. Mr. Chairman and members of the committee, in recent years, this body has made great strides towards ensuring that indigent Marylanders in our justice system are not forced to pay for the cost of their own incarceration or supervision. Most recently, Senator Carter, Senator Sidnor, Senator Hedelman, and I have been working to ensure that indigent Marylanders under GPS monitoring are not required to pay for that monitoring. That legislation passed on a bipartisan basis. Under Senator Carter's leadership, we've also heard about the unfair system whereby indigent incarcerated Marylanders are required to pay exorbitant fees simply to keep in touch with their family or loved ones. This is patently unfair. We don't bill prisoners for their food, for their library books, for their cots, for their plumbing, or for their hygienic items. Why do we bill them for basic phone calls? This system has consequences for families and for reentry. Here is a staggering statistic. 34% of families, that's more than 1/3, go into debt in order to cover travel and phone expenses to visit and speak with incarcerated family members. That is unacceptable and serves as collective punishment for family members who have done no wrong. As for the prisoners themselves, many ration phone calls in order to reduce costs. But research clearly shows that connections to loved ones through the term of incarceration reduces recidivism and eases reentry upon release. In other words, free phone calls aren't just a benefit to prisoners, it's a clear benefit to society after the end of the term. The Keeping Families Connected Act of 2023 would create a task force to study and recommend how Maryland can make prison phone calls free for inmates and their families. This task force would analyze data from other states that have recently instituted free prison phone call programs and make recommendations as to how Maryland could do the same. A few quick points. First, this bill is aimed solely at exploring cost. It's not intended to explore changing prison policy about the frequency or length of phone calls. Those policies remain within the discretion of the department. Second, this bill doesn't affect your local jail. It only applies to state prisons. My belief is that once we prove we can do this at the state level, the locals will see that this is something that is clearly feasible at their county jails. Last thing here, why not simply pass the pure bill that has been introduced in past years? So I'm deeply empathetic with that idea, and I've supported that bill in previous years. But I know that we've also struggled for now multiple years to figure this out. Prison phone calls are more complex than regular phone calls. Unfortunately, some prisoners continue to further their criminal activity from behind the wire, so prison phone calls need to be recorded. Between that complexity, the fact that we have a new administration as well as a new secretary, a formal legislative task force during the interim will give us the time, space, and large inclusive table necessary to problem solve and bring back a more comprehensive, thoughtful bill. In sum, Madam Chair, members of the committee, encouraging incarcerated individuals to remain connected to their families and social networks is sound public policy. We want these individuals to successfully re-enter society upon completion of their sentences. The cost of a simple phone call should not be the reason that we fail in that objective, excuse me. I respectfully urge a favorable report on Senate Bill 257.
Good evening, Chair, Vice Chair, members of the committee. Happy Valentine's Day. My name is Natasha Calfany. I am Acting Assistant Director of Government Relations at the Office of the Public Defender, and I support and urge a favorable report for SB 257, Keeping Families Connected Act. Families are important and family connectedness is important, and even more so for our incarcerated persons. Family connectedness has a direct benefit to successful reentry into society. Some of those benefits include individuals who have family contact during incarceration are less likely to recidivate, more likely to have and secure opportunities for post-release employment, less likely to be depressed, more likely to be involved with their children post-release, which is related to less depression and substance use. Family connectedness is often facilitated through phone calls. Unfortunately, these phone calls are often expensive and more often predatory. As you heard from Senator Wallstreicher, that 34% of incarcerated families have gone into debt in order to pay for phone calls and visits. We believe that for these reasons, this task force is a good idea and we support it, and we thank Senator Wallstreicher and Senator Carter for bringing this bill. Thank you.
Good night, they would say in Africa. My name is Nicole Hanson Mundell. I am the Executive Director of Out for Justice, for the record, a nonprofit organization that advocates for the very population that we're talking about, our incarcerated loved ones. I won't repeat many of the statistics that have been laid out by my colleagues and the vice chair. I'll come from some experience. As a formerly incarcerated woman myself, I've had to rely really heavily on phone calls behind the walls. And I can tell you, given the fact that my husband was tasked with taking care of both of our children by himself, we often talked about those phone calls and how much they cost. And I would have to do simple tasks like help him market or, get the circulator to help him figure out how to take care of those kids, in addition to all the other tasks that he had to do on his own. And so I know firsthand the impact and the cost and how much it adds up every day, every month, right, for families, and especially families who have restrictive income. And so those individuals deserve the right to talk to their loved ones unlimited. One of my colleagues said something, if we pay $40 for our cell phone bill and we get unlimited everything all month, while our incarcerated loved ones paying quadruple that amount with limited phone calls and limited access to their loved ones. And we have access to tablets now too. So for those reasons, let's support this task force. It's always my hope, Senator, that we can get more
nonprofits on our task force and more directly impacted people on our task force. So that's the only thing I'll add about the task force. Thank you. Question?
Thank you very much, and I'm glad that you revealed the information that you have. One of the things that we do in our outreach, we have a lot of persons who complain about the phone calls where they have to call, collect, and all the other kinds of things.
Yeah.
How much is an average? Or I mean, if you don't have that, let me know. What is the cost of an average call, and what could that amount to?
So it depends. Like if you are someone,
It's
it's about like I think $1 for like almost $2 for a 10-minute call or something like that.
Okay.
But I'll get you the exact number because at Out for Justice, we put about $100 a month on our phones on the service, right? So you
not making long distance calls or anything like that.
No.
Just calling
just calling locally.
Which should be free. I would.
You would think.
Then my next question is, is there a particular provider, a service provider that for all prisons or for all? And
What
who
we
would
know
those
is
providers be?
Kinetics. Am I saying that?
Connecticut. Option.
Okay, so thank you to my advocates here. So in Maryland, it's 48 cents a minute. 48 cents a
48
minute.
cents a minute.
A
for
minute.
prisoner to make a phone call, or who has no job, who has, and so somebody's got to foot that. And who will the provider be in Maryland? From Maryland, is it?
Go ahead.
Verizon who is it?
So the department contracts with a company, a private company. It's not a telecommunication, a consumer-based company. It's a company that provides this service to prisons throughout the country. And my understanding is that they don't care where their money comes from as long as they get paid. In other words, this bill would not make it so that the vendor goes unpaid for the services that they're providing to the state. It just shifts the cost
to the family.
No, it shifts the cost to everyone in the same way that we all pay for the food and the hygiene products and the toilet paper. So too would we as a society cover the cost of people connecting with their family members. And so the reason you don't have the industry here testifying against this bill is because it's not designed to screw them.
Okay.
Although clearly they are a profit-making endeavor. They're making money off of our incarcerated prisoners. I don't want to hide the ball there, but the design is not to push them out. They are part of the solution here. And as long as they get paid, they are cool with it, which is why they're not testifying.
When you say we pay,
meaning the taxpayers, the same way that you pay for inmate toilet paper and inmate cots and inmate plumbing to make sure that.
Okay, I understand, but when they're making those calls and they're having to call collect and the bill is reflected on their husband or wife or mother or father on their bill, we're not paying that.
No, I'm sorry. I'm saying this bill would shift those costs
right
from the families or the incarcerated individual to be a usual and customary cost
at
of
the same rate of
incarceration.
48. That's what I'm getting at, the same rate of 48 cents a minute.
So I think we're not going to have
I got what you want to do and what you don't want to do.
That's right. Part of this is the task force is going to figure out some of these things. Yeah.
Okay.
And it's Telcom is the company.
Okay. Thank you. Okay.
Questions from the committee?
No one?
Senator Sidnor, and Senator Sidnor and then Senator James.
Oh, look, thanks for bringing the bill out. I remember a few years ago, back when I first came into the General Assembly, I looked at this, the issue of just the cost of telecommunications. And honestly, I think there was a contract, not only from Maryland, but some other states online, and the cost of the fees is extraordinary. So I'm looking at the additional comment section in the fiscal note, and it says that the Department of Public Safety and Correctional Services advises that the current contract for inmate calls is not a revenue generating source for the department. Thus, since fiscal 2016, no funds from inmate calls have been deposited into inmate welfare funds. Now I raise it just because I want to be real clear. It talks about it's not revenue generating source for the department. It's not talking about how much money that this private company that's contracting.
That's right.
And has gotten the contract through, I guess, the Board of Public Works is making off of the backs of these folk who are
That's exactly right.
incarcerated. So thanks for bringing the bill.
Of course.
Senator James.
Just a couple of quick questions. I know it's called the Keeping Families Connected, and we're talking about people calling their families and loved ones. But I didn't see in the bill, the task force isn't restricted to looking at the cost of calling your family and loved ones. It's just free calls in general.
That's right.
Is there a reason for that? Because I'm thinking about what this might cost and us prioritizing the kind of calls that we would even consider, helping families for sure. But is there a reason we didn't sort of restrict it to that as opposed to just free phone calls in general?
Yeah, I'll defer to the advocates. I would guess that the overwhelming majority of phone calls are to family and loved ones because they're limited into how many phone calls they can make and how long those phone calls should be. So when you're rationing those phone calls, you're calling the people who are closest to you. Nonetheless, it's only a task force. And if that's something you think would be advisable to look at, I'm 100% open to that. You wouldn't want to unintentionally expand the cost to the department.
Right. And also you had mentioned, the reason I'm bringing it up even more is, you indicated we don't, unfortunately, some people use phone calls to further illegal activity.
Right.
So I would think we would want to not look at every phone call being free, but try to prioritize it. And I would think we want to make that clear in the bill.
I think that's fair. And nothing about the bill intends to move away from the recordation of phone calls that are coming out of prisons.
And then just following up on my colleague down there, and everybody's comments about how incredibly expensive these calls are already, is the task force going to be able to look at whether or not just the carrier and these exorbitant costs, and maybe it has to do with, I have no idea, like they'll say it's security or the way we had to install the phones. But I would think that especially if the state is going to take this burden on, the state ought to be also looking at if we want to change that policy, how might we lessen the cost? And I would think this task force would be the right place to do it, to look at the carrier selected. What are the obstacles? Why has it always been this expensive, regardless of who's paying? And shouldn't we look at that as well, especially if we're going to ask taxpayers to pay it?
That's right.
So you would agree with that? I mean,
100%.
that you would want to add that. I would think you'd want to put that in the bill.
I like how thoughtful you are, Delegate. This is a new day, Senator. In reference to the families, unless you want to determine the definition of family, family could mean someone who I've known for the last 20 years and has supported me. Family does not always mean a blood relative.
I get that.
And so as a woman who sat behind those walls, I would tell you, I'm not making random phone calls. I'm making the most important phone calls. I'm putting the names of people on the list that are the closest to me, that are connected with my reentry, with my children, with my grandparents, of the such.
Maybe you could answer this for me. So is it a list is it a pre-approved?
We make, yes.
And that is how it works.
Yeah, so that doesn't change, right? You have to identify a contact list. Like once a month, you identify a list, and you only can put a certain amount of people on that phone list per month. That's managed by the Department of Corrections.
How people were able to continue to do criminal. I know.
Well, the criminal activity, like this bill or this task force doesn't deal with the criminal activity.
Right.
That would happen. The department still can listen in on phone calls and do as they will with those recordings.
Right.
Currently.
Well, I didn't mean to imply. I just was thinking if you could say family support, as opposed to just, I want to.
I mean, the way they make phone calls won't change. We still have to identify a list of people that go on our phone list anyway. That won't change.
Right.
what changes is probably what you said, which is the state actually looking at this company and seeing the predatory practices to make sure that the state don't incur those same predatory
So
practices.
you'd agree that ought to be part of their charge, don't you?
I agree that that's something we should look at.
Okay, thanks.
Yes,
Thank
ma'am.
you.
Questions from the committee? I'm going to take a Senator Waldstreicher point of personal privilege to thank you for bringing the bill. It's something that's long overdue, and it's been more than a decade since I, at the behest of an organization called Friend of a Friend, brought the initial legislation, and it was Friend of a Friend was founded by none other than Marshall Eddie Conway, who was a political prisoner in Maryland for a long time and who we got the news that he passed away yesterday. And so this bill to me at this moment has special significance. So I appreciate you for doing it. Thank you.
No, I appreciate your leadership on this. You were the first and you've led the charge.
Questions? Well, oh, no. I'm getting ahead of myself. Kimberly Haven, Ashley Devon Johnson, or Kiana Johnson?
They are not here. They had to go back to work. They were virtual. Could they be virtual?
They're not, I'm told they're not here.
Yeah. They were here, but okay.
All right, then Senator Waldstreicher, your next and final bill of the day.
Yeah, we'll get you
Senate
out
Bill
of here.
292.
Back to your spouses and loved ones. That's the most questions I've ever gotten on a task force bill in my life, by the
Yeah,
way.
so a real big point of Senator West would like a point of personal privilege.
Privilege, yes. So my point is this. This bill was introduced last year as Senate Bill 768. It was passed by this committee unanimously. It was passed on the Senate floor unanimously, 43-0. I'm looking at the 4 pages of witnesses signed to testify this evening. There's not a single person signed with unfavorable. Everybody here is favorable. So could I just suggest that in light of the hour, people not repeat what other people have said? Lots of Me Too's or I agree would be great.
Absolutely.
Thanks.
So there's going to be a lot of Me Too's tonight, and they are already under that instruction. But I did want to take a quick moment to introduce the bill to people who are not on the committee previously. So let's start with an important idea that is at the core of this bill, that victims of human trafficking are just that. They are victims. They are not criminals. And under that theory, we passed a bill a few years ago, not this bill, a different bill, allowing people who have had convictions on their record that were a direct result of being trafficked to get rid of those convictions under a concept called vacature, which is essentially equivalent in a lot of ways to expungement, which we've been talking about a lot this session. And so there are a list of crimes, they are minor crimes. And if you were convicted of that crime, but in fact participated in that activity as a direct result of your being trafficked, you can then clear that off your record because you were in fact a victim, not a perpetrator. But that is at the end of the criminal justice process. And so the idea behind this bill is, okay, we've got a solution at the end, but how do we prevent people from getting even into the criminal justice system on the front end? And so what this bill is a lot of words, but what it really is a series of off-ramps. It is a series of off-ramps from the highway of the criminal justice system. And at various points in that criminal justice system, when there is a recognition by any party that a person who has entered the criminal justice system is not a criminal and is in fact a victim of human trafficking, then that off-ramp can occur. And so let me start with a couple of examples. Let's say the police are doing a prostitution sting and they raid a hotel in which prostitution is happening. Very quickly, they will realize that one of the prostitutes who is underage is in fact not a prostitute, not a criminal, but instead a victim of human trafficking. Under this bill, that person would not go into the juvenile justice system. They would be off-ramped to something called a regional navigator, which is just a fancy word for the place that provides services for victims of human trafficking. So that's the first off ramp. So you have something like a sting, the police realize very quickly what is happening, that this person's a victim. They get off ramped to services, off ramped to the regional navigator. But prostitution is not the only criminal activity that victims of human trafficking are forced to participate in. So let's say someone is a victim of human trafficking and gets picked up for shoplifting, but they are shoplifting in order to survive or to give money to their trafficker. They're doing it not because they desire the item that they shoplifted, but as a survival, as a victim of human trafficking. The police in that circumstance may not realize that this child is a victim of human trafficking and instead charge the child in the juvenile justice system with the underlying crime, not realizing that person's victim status. At that point, the prosecutor could then go into court and tell the judge, hey, we didn't realize this at the time, but we realize now that this is not in fact a criminal. This is a victim of human trafficking. And then you have an off-ramp there. Let's say it's not the prosecutor who realizes it, but the defense attorney that is appointed for the child. The defense attorney can similarly say, hey, here's a motion. My client is a victim of human trafficking. And in that case, the prosecutor can not object and say, we agree. Now we realize this is in fact a victim. Or under the process we set up under the bill, the prosecution could say, yes, we actually don't believe that this person is a victim of human trafficking. We think this person is a perpetrator of criminal activity. And then they would have a hearing in front of a judge. And that judge would determine whether, in fact, the person charged is a victim of human trafficking. And if the answer is no, which almost never happens, then the case will move forward. If the answer is yes, which is much more the likely scenario, then that person is off-ramped there back to the same regional navigator that's required in the first instance. So basically what this is setting up is at every point during the process where someone is a minor and has committed one of a series of minor offenses as a direct result of being a victim of human trafficking, there are off-ramps that they can go onto to get away from our criminal justice system, which doesn't help them because they are victims, and instead provide services from these regional navigators that are just doing incredible work in our community, making sure victims of human trafficking have the wraparound services that they need and are able to leave the life that they are leading in our community. So with that explanation, I will turn it over to my advocates. They'll do a little more explanation and a lot more need to. And then, of course, if you have any questions, we are happy to answer them. Thank you, Madam Chairman.
Good evening, Madam Chair, members of the committee. I am Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence. Thank you all for remaining and listening to this important bill. For many of us here, this is part of our life's work. We've committed to passing safe harbor and working on behalf of child victims of trafficking in Maryland. The first safe harbor law passed, in fact, 15 years ago. 8 years ago in Maryland, there was a work group that was established by this body to study safe harbor policy for youth victims of human trafficking. The very first recommendation of that report was to create exactly what this bill does. And that was 8 years ago. This bill provides a very basic level of protection for victims of trafficking, for child victims of trafficking. And it says that it's the policy of the state of Maryland that we do not believe that a child who has been trafficked should be charged with the very act that makes them a victim. It says that we recognize the horrors that you have endured and that there are services we can provide and we will connect you to them. This bill is a crucial first step. I can assure you that the absence of safe harbor protections absolutely prevents children from disclosing their victimization or acceptance of services because they could be subject to prosecution and punishment for being victimized in ways that are hard to comprehend. And as someone who now works on behalf of victims of domestic violence, I will note the inextricable link of domestic violence and trafficking. In addition to the similar power and control dynamics, it is all too common for a trafficker to be a boyfriend or intimate partner of the victim. It's time for Maryland to do better. I'd like to thank Senator Waldstreicher for all of his work on this bill, and we urge a favorable report on Senate Bill 292.
Madam Chair, members of the committee, my name is Amanda Rodriguez. I am the Executive Director of Turnaround. We are the comprehensive domestic violence organization for Baltimore County, Baltimore City. We're the Rape Crisis Center for Baltimore County and Baltimore City, and we're the first comprehensive human trafficking provider in the state. We are also the regional navigator for Baltimore County and Howard County. I'm also the co-chair of the Legislative Committee of the Maryland Human Trafficking Task Force. Imagine that a child of sexual abuse, after years of enduring abuse, finally is identified and feels safe to speak out about their victimization. It would be unconscionable to think that we would arrest that child for the very thing that makes them a victim, that we would handcuff them, or that we would prosecute them. Child sex trafficking is child sexual abuse. It is the only law, this is the only law in the entire state in which the very thing that makes the child a victim is also the thing that makes them a criminal actor under the law currently. To be clear, current law allows for children who are not old enough to consent to sex with an adult to be charged with something that in the same breath is statutory rape. And it's just as unconscionable to believe that a trafficker who is willing to compel a child to engage or perform in commercial sex will not also force that child to squat in a vacant house, to sit in the backseat of a stolen car, or to hold drugs. Maryland has been working on safe harbor since 2014, and 38 other states have passed some form of this legislation. They've not only lapped us in preventing and protecting children, but they've gone on to expand and to refine their laws, while we currently have no protection for these children. Maryland is so far behind that we received an F when graded, and we're in the bottom of 10 states for our policy response to child sex trafficking victims. When we first came before you, there were 4 states' attorneys that spoke in opposition to this bill. When we testified in the House, there were 5 states' attorneys that came out and supported this bill, the Public Defender's Office and the Judiciary, all of it. For the foregoing reasons, we ask for a favorable report. Thank you.
Good evening, Madam Chair and the committee. My name is Liz Kimball. I'm the program director at a survivor-led nonprofit here in Maryland and also the survivor advocate for this bill. I'd like to thank you for the opportunity to be heard on behalf of many children in our great state of Maryland who are being sexually exploited and are not able to be here today. Throughout the years that I've been championing this piece of legislation, I've often used my own horror stories and shared with many the worst moments of my life, almost always feeling used and defeated by the time I'm done. I have to share with you that coming up here is triggering for survivors, and when we do it and our bills don't pass year after year after year, there's a familiar feeling of having been exploited for the sake of something that people just don't care enough about. Despite the advancements made in the majority of other states on the treatment of child sex trafficking victims, Maryland continues to allow arresting and charging children with the crimes committed as a result of their trafficking. As a direct result of this criminalization, survivors face a myriad of horrors while moving throughout the system. Each and every survivor will need restorative programming, and this bill will address that. I was born and raised in College Park, Maryland, where I was also trafficked from the ages of 12 to 15. During those years, I was forced to commit a number of crimes as a direct result of my trafficking, all of which were a means of survival and often at the hands of my traffickers. I stole makeup sponges every month so that I could work even while menstruating. I drove cars without a license because my trafficker would take a harder charge than a child. While this bill only serves a specific group of children, these victims are also the only group who can be legally prosecuted against for their own rapes. The times I was apprehended by law enforcement were some of the most traumatic moments of the 3 years that I spent being trafficked. With this bill, we would be proving to the youth that we're responsible for protecting, that Maryland cares and is going to do better. I hope that you will pass a favorable report on Senate Bill 292. Thank you.
Good evening. Again, Joyce King on behalf of the Maryland States Attorneys Association, here to really vocalize our unanimous support of this bill, all jurisdictions. Senator West, I really appreciate your comments that this is a common sense bill and no one stands against it.
So I hope that this committee will move it and move it quickly. I've been a prosecutor in child exploitation for 10 years, and I'm proud to sit with these panel of advocates and subject matter experts to echo the simple sentiment that child trafficking victims should not be prosecuted for their own victimization. I also stand here to attest that we know that this model works. In Frederick County, we have a human trafficking response team that was established in 2018. We have a regional navigator housed at our Hartley House since 2021. And as of January 2023, our regional navigator has a current caseload of 49 victims. In 2022 alone, our regional navigator served 21 victims of human trafficking, and not a single one was prosecuted. In many of those instances, because those victims got the services that they needed, they were able to assist us in successfully prosecuting their traffickers. We believe in this process and know that it works. Human trafficking is a heinous crime. So I really appreciate you all sticking around to listen to these passionate advocates and not minimize or deprioritize this bill any further. And I hope that this committee moves it forward. MSAA, for all those reasons, believe that this bill will empower survivors and lead to more prosecutions of sex traffickers. And we ask for a favorable report of SB 292.
New to the committee, so I just doubt, what is the definition of child under this bill? That's just, and then I have a second question.
Sure. So it's defined as under the age of 18. So somebody who would be under juvenile court jurisdiction.
And then I think I misheard or misunderstood. I know somebody said it, and I get it, something, it was be horrible for someone to be legally prosecuted for their own rape.
Yes.
So without getting too explicit, I'm just trying to follow that.
Sure. So, I mean, by definition, if you are a child under the age of 18 in Maryland, even if they're go into a long conversation about what trafficking is, but even if there isn't an actual trafficker, it is in fact trafficking. It is also in the definition of child abuse. There's also consent laws. So if you have a child of 13 years of age who is being trafficked and her trafficker has sex with her, or there is another individual who pays to have sex, then either of those situations are rape. It is non-consensual.
Okay, okay, it's just.
Yes.
Okay, thank you.
No problem.
Right. Oh, come on. Yeah.
This panel.
Excellent. Seeing no further questions, thank you all very much. All right. So Ms. Jordan is gone. Is Ms. Jordan here? Is Joyce King still here? There you are. You already did? Oh, great. We got you. You might as well. I mean, Christine Reno. Jessica Emerson. Krishnan. Is Krishnan? Oh, here. And Nick Maroney.
Good evening. My name is Christine Reno, and I am testifying in support of Senate Bill 292 on behalf of Shared Hope International. Thank you, Mr. Chairman, Mr. Vice Chair, and committee members for hearing testimony on this critically important legislation. Shared Hope is the only organization tracking, analyzing, and evaluating all 50 states and DC's laws and legislation related to child and youth sex trafficking. We also provide technical assistance to state lawmakers and anti-trafficking stakeholders in a majority of states to increase protective responses for youth survivors. In this capacity, we have been uniquely positioned to ascertain effective practices and policies. Safe harbor or non-criminalization protection is a well-established, researched, and proven policy for appropriately responding to child sex trafficking victims. The majority of states in the nation have passed legislation to protect child sex trafficking victims from being charged with prostitution. In addition, many states have gone on to increase and expand that protection to include other offenses. The fact that states have expanded their safe harbor laws demonstrates the benefit to all stakeholder groups and the positive outcomes for youth. Senate Bill 292 remedies a glaring contradiction in Maryland's criminal code. While children who have experienced exploitation are rightfully identified as victims of sex trafficking under one section of the code, the prostitution law undermines their victim identification by treating the same child as an offender. Furthermore, innovative and smart policies and practices that are designed to protect rather than punish child sex trafficking victims, such as the Regional Navigator Program established in 2019, are undermined when child sex trafficking victims continue to face potential criminalization for their own exploitation. Along with the many advocates testifying here today, I've been part of efforts for the past 8 years, including serving on the Safe Harbor Work Group, to bring Maryland's laws in line with the types of victim-centered responses we are seeing develop and be implemented around the country. I look forward to seeing that goal accomplished this year and urge a favorable report on Senate Bill 292.
To the chair, the vice chair, to this committee. My name is, I'm Pastor Chris. I pastor Love AME Church in Prince George's County, Maryland. And I stand here because I'm here on the side of children. And I believe that as representatives, as you all are convened as senators, you're here for the people. And I know a lot of us may be saying the same thing tonight. And I know it's the end of the night. I know because I left my wife and kids to be here because it's that important. It's that important that when we understand we're not at all talking about prostitutes, we're not at all talking about criminals, we are talking about children who are victims. And when we put it in proper context, and we understand these very same children who are victims who are indeed raped and raped and raped and raped and raped. And that might have seemed a little excessive how many times I said it. However, it doesn't even measure the number of times that some young children experience it in the evening, on a Monday, and again on a Tuesday. And my 2 minutes could do no justice to talk about the atrocity it is that when they finally find potential help, that someone would even think that they were able to stand up against the people that dictated what would happen to their own bodies. Those same people, they could then magically tell them, well, I'm not going to steal anything and I'm not going to hop in any stolen car. They don't have that power. If they did, they wouldn't allow themselves to be raped and trafficked for the enrichment of others. I hope that you would deliver a favorable report, not on behalf of the traffickers, but on behalf of the children of the great state of Maryland. God bless you.
And yes, I have to follow that. Good evening, Mr. Chair, Mr. Vice Chair, remaining members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which is the only organization in the state of Maryland to focus exclusively on the criminalization of human trafficking survivors. Enough has been said. It is late enough. And so I am simply going to say that we have taken too long to pass this bill. I did this work over a decade ago with adolescents, preparing them for New York's safe harbor law. And so I can obviously offer on the off time any perspective on that. But at this point, I just beg of you, do not let this body be yet another system that fails these kids. And with that, I say me too. Thank you.
Good evening, Chair, Vice Chair. Vice Chair, thanks for bringing this bill. Fellow members of the committee. My name is Nick Maroney. I'm here from the JJMU, the Juvenile Justice Monitoring Unit, out of the Attorney General's office. We perform unannounced visits to the juvenile detention and placement being the equivalent of prison, to make sure kids aren't being abused and to make sure that they get proper resources and services. Anybody who has been trafficked, and a high proportion, unfortunately, of the young women and girls who are stuck in the system in the deepest level have been trafficked and have suffered physical and sexual abuse. Are they getting the right services through DJS? Hell no. I mean, how could they possibly be getting the right service? How could they be getting individual trauma-informed services for that level of trauma within DJS? So, you know, this kind of thing which mandates that the kids be steered towards services is exactly what needs to happen. We certainly don't need to have victims, whether they be girls or boys, of sex trafficking and human trafficking within DJS facilities. For that reason and many others, we support this bill wholeheartedly. The only thing I would add is what I said across the way when this bill came up across the road, and that is, you know, last year there was a very well-meaning attempt by a member of the Judiciary Committee to run just before Sine died to make sure that this bill got through. It didn't make it, so I think people need to, perhaps the chair could prioritize this, and so we don't have to run at the end. We could actually just make sure that this thing goes through, and it goes through quickly, and as I said, it's prioritized, and that's all I have to say. Thank you.
All right. Seeing no questions for the panel, thank you all very much for sticking in there with us. All right, is Aaron Seegers here? And then Jessica Emerson. You already did. That's right. Who else am I missing? Aaron, Sophie Ann. So Sophie Ann, Aaron. Yes. Anyone else? Am I missing anyone else? Okay, excellent.
Good evening, Mr. Chairman, Vice Chairman, and members of the committee. My name is Erin Seegers, and I'm an attorney with the Maryland of the Office of the Public Defender in the Juvenile Division. I have the great privilege of working with and behalf of many remarkable, resilient children here in the state of Maryland, many of whom who are victims in one way or another, all of whom are children and should be treated as children first and foremost. We therefore urge a favorable report for SB 292. I'm grateful I don't have to convince this room that we shouldn't be prosecuting, punishing, and further traumatizing children for what they're forced to do when they were trafficked. I will take this opportunity, though, to share with the committee a more tangible reality of trafficked children here in the state of Maryland. Trafficked children are not always necessarily kidnapped, snatched up by strangers against their will. Often it's older people that they know, who they are familiar with, who by threats, manipulation, get control over them. Trafficked children might not also be seen as the most well-behaved children with a squeaky clean past. Often they have struggled at school or at home with substances. They might have had previous contacts with DJS, and they likely have. Trafficked children, even with immunity, might not be the most perfect witness effectively used to lock up their traffickers. You can't expect traumatized children to turn so easily against the subjugators and willingly participate in intimidating legal proceedings. And unfortunately, many trafficked children don't have happy, healthy homes to return to welcome them back in their arms. Many do have involvement with DSS, where they can be labeled, judged, and open to further trauma. So we need this bill, not just to protect and care for and provide for the perfect innocent victims of trafficking in Maryland, also for the kids I work with every day, who are kids first and foremost. Thank you.
Good evening, everyone. My name is Sophie Aaron. I'm a social worker at the University of Maryland Safe Center for Survivors of Human Trafficking. We are a comprehensive service center based in College Park, serving Montgomery County and Prince George's County. We serve exclusively survivors of human trafficking, so this is our everyday. I want to just offer a Me Too and position myself at the Safe Center as the regional navigator for Montgomery and Prince George's counties. I want to give a couple examples of the services that we provide as the regional navigator. Basic needs, connection to mental health services, connection to substance use, educational support, and most importantly, a healthy adult ear. I served as a caseworker for regional navigator clients, and I can't tell you how much gossip I got from these young kids, but what I did was just offer them a safe place to be with an adult and to work on mentoring and healthy relationship building with their peers. I'm open to any questions about the Regional Navigator Program. It's a program that I really believe in. We expanded from a 3-county pilot to now we're nearly statewide. And for those reasons, I offer a me too and ask for a favorable report on SB 292. Thank you. Sure. Do you have any specific questions? I know we're all itching to stay here a little longer.
No, I just want to make sure. No. Just to sit
Good
down
kidding.
and
Certainly.
see how other networks that we're connected to, how they may be helpful as well.
Sure.
That's what we want. Thank you.
Certainly.
Okay.
Great. Thank you.
It wouldn't be JPR without just one more question, you know? All right. All right. Ms. Feinstein, all right. Ms. Feinstein, you're up. Looks like you're still in your office burning the midnight oil on Valentine's Day. So thanks for being here with us.
Thank you for having me. I appreciate that. Good evening. My name is Debbie Feinstein. I'm Chief of the Special Victims Division with the Montgomery County State's Attorney's Office. And I want to offer a Me Too on support of this bill. Thank you so much and happy Valentine's Day to everyone.
Brilliant testimony. All right. Ms. Sanko, you're up next.
Good evening. I want to thank you for the opportunity to speak to the committee this evening. My name is Rhonda Sanko, and I've spent a dozen years as a psychotherapist with a focus on sexual trauma. In my current role, I'm executive director of Araminta Freedom. It's a nonprofit in Maryland that works to prevent child sex trafficking through education. And we also offer an array of services to youth that have been trafficked. But this evening, the reason I'm still on at this hour is that I'm speaking to you as a mom, because I'm a mom of a young woman who was trafficked when she was 16 years old. The act of trafficking another person is the act of systematically destroying their lives. While I don't know the specifics, I do know that my daughter committed crimes and did things while being trafficked that she hadn't done before or since. Fortunately, we benefited by working with law enforcement experienced with trafficked youth. They interacted with her as if safe harbor were in fact the law. And once it was clear that she was being seen as a victim and not as a criminal, it was one less trauma for her, but it also set her up to cooperate with law enforcement. As caring citizens, we should remove any barriers between our kids and safe adults. My daughter identified a number of bad actors, and consequently, 3 of her traffickers were successfully prosecuted. Maryland does not have enough prosecution of traffickers and buyers, but cases cannot be prosecuted without witnesses. The absence of a safe harbor law puts kids and law enforcement on opposing teams, and that is a situation where only one person wins, the trafficker. I urge you to ensure that this bill becomes law this year. Thank you.
Thank you very much. Next, we'll hear from Ms. Amparo. You're up. Welcome. Sorry, Ms. Amparo. We can't hear we can't hear you. We can see you, but we cannot hear you. You're not muted. So there's maybe something wrong with their microphone. All right, try that. Can you say something now?
Can you hear me?
Yes, there we go.
Okay. My name is Stacey Amparo. I am with the Baltimore County State's Attorney's Office. I have been prosecuting these trafficking cases since 2015. I've testified before this committee before, even back when the MSAA was not supporting this bill. The thing that is different now is that we do have the Maryland Human Trafficking Navigators Program in effect. That program ensures we have the proper services that we can route these children victims to. And we can no longer use the excuse that we will not know where these children are come time for trial. I have met
many children that are survivors of trafficking after they have been arrested. Those children were always reticent to be interviewed by law enforcement who arrested them and reticent to cooperate in the process that can be lengthy for survivors with the courts. In Baltimore County, we've learned that rapport building is absolutely the key to children disclosing their abuse at the hands of traffickers, and we cannot build that rapport if children are arrested for a crime that they cannot even consent to. I would urge a favorable report on this bill, and I thank you very much.
All right, excellent. Thank you very much. Seeing no questions from the committee, I believe that is the last witness for the evening. So thank you all very much. That'll end the testimony and the hearing for Senate Bill 292. Before we break, I will say this. I want to say thank you to the staff, to the council, to the senators for being here, and most importantly to the members of the public that came down to petition their government for change. You stayed until 9:30 on Valentine's Day. We've been going for 8 hours and 30 minutes. So thank you all for being here, and thank you for your participation. Also, the chair of the Judiciary Committee stopped by with popcorn to watch us. So to you, my good friend, I'm going to return the favor sometime next week. But have a good evening, you all.